Section 19 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 9. Monotonous repetition of the drowning trick. In February 1881, a house painter in Evansville, Kentucky, named Charles A. Lucas, was seen to fall overboard from the Ohio River steamer Maggie Smith, then plying between Evansville and Henderson, and was reported to have been drowned. Soon after this occurrence, it was discovered that he had been insured for $15,000 in the Northwestern Mutual Life and $4,000 in a Louisville cooperative. Investigation followed, and translucency soon became transparency. Mr. Lucas was not drowned beyond resuscitation. He reappeared upon the stage of action and confessed participation in a conspiracy. His employer was a well-known young lawyer of Evansville, Julius A. Coleman, who persuaded him in pursuance of the scheme to marry Coleman's servant, who willingly entered into the plot, and became nominally the beneficiary of the policies. Then, to mature the claim, Lucas was to drown himself in the river in a life-preserving rubber suit. In the confession of the woman, which is made in the form of a sworn affidavit, it is stated that Coleman hired her and Lucas to carry out the scheme, agreeing to pay her $2,000 and Lucas $4,000, and that they were to disappear for a time, and when the matter was forgotten, to try the same trick over again somewhere else. A man named J.V. Richardson was also employed by Coleman to witness the drowning and swear to it. His affidavit states that he was hired for the purpose and was to receive money, that he saw Lucas with a rubber suit and knew it was a plot to swindle the insurance companies. He reported the matter to the newspapers, and the arrest of Coleman, Lucas, and Richardson promptly followed. The executive officers of the Northwestern Mutual Life entitled themselves to great credit a few years ago for their patience in following to final conviction an unusually lengthened disappearance. Several years elapsed before suspicion ripened into confirmation, but even-handed justice overtook the offenders at last. In 1873, Jeremiah Elliott, who lived in the neighborhood of Portland, Oregon, insured the life of his son Moses, aged 18, in the company through its Portland agent for $8,000. In the course of a few months, allegation was made that Moses, while rafting with his uncle on the Columbia River, was drowned. There was no recovery of the body, but at the same time there was no one to refute the evidence of the uncle. The suspicious character of the occurrence, however, clear to the trained scrutiny of the company, would have presented nothing irregular or crooked to the untrained vision of a jury, and as there was no alternative but payment, the company paid the claim. Soon afterward, Elliott and his brother removed to Jackson County, where they bought a sheep ranch. In the management of this enterprise they were joined by Moses, who it seems was not drowned dead enough to prevent his assuming the role of a gentle shepherd upon the pastoral acres which had been purchased by his submersion in the Columbia River. Industry and economy were attended with prosperity, and as years passed on, Moses grew to manhood. But his features did not change beyond recognition, and when the ministers of the law told the co-parsoners they were wanted, they obeyed the summons. Legal proceedings resulted in a verdict for the company for $13,676, principal and interest of the money wrongfully paid, and as the ranch and its woolly ruminants had become valuable, the company was secure in recovery. On the 20th of July, 1893, William B. Gregg of Duluth, Minnesota, who had a short time previously obtained insurance to the amount of $14,000 on his life in the Fidelity Mutual Life of Philadelphia, the Mutual Life of New York, the United States Mutual Accident, and the Northwestern Mutual Life, was reported to have been drowned in Lake Superior by the capsizing of a small sailboat. The insurance companies were promptly notified of the loss and proofs duly sworn to, in which the details of the capsizing of the boat and the drowning of Gregg were given by John T. Clark of Duluth, who accompanied Gregg and who was in the boat at the time of the accident. Contradictory statements made by Clark and suspicious circumstances connected with the affair led to the inference that there was a purpose to defraud and that Gregg was still alive. Detectives were employed by the companies, and after several weeks of careful investigation, Gregg was captured in New York City and taken to Duluth. Clark, who was with Greg in the boat and swore to the drowning, was also arrested, together with one Frederick E. Crayenbull of Duluth, the brother-in-law of Greg, who was implicated in the conspiracy and who was the beneficiary under Greg's policies. In May 1889, James Dillon, a well-known citizen of Terrell County, North Carolina, insured his life for $3,000 in the Connecticut Mutual Life Insurance Company. Sometime after, he fell from a boat, feigned inability to swim, and had to be pulled out of the Alligator River to prevent his drowning. The next day he overturned his boat half a mile from shore and yelled loudly for help to a man a quarter of a mile away. When the man responded, Dillon secretly swam ashore and could not be seen. The man whose assistance he had asked supposed he was drowned and was willing to swear to it. Notice of Dillon's death was sent to the company. It refused to pay the claim. Action was brought by Dillon's wife, and the case stood for trial at court, the widow alleging that he was drowned. Then a body was found near the place where he had been seen to sink in the water. The body was identified by 25 people as that of Dillon. At court, counsel took a non-suit because the body had been found. Evidence of death and identification was forwarded to the company, who wrote that they would do as advised by their attorneys in the county. The company would have paid the money, but to the surprise of everyone, Dillon himself returned safe and sound to Columbia. Hearing of the non-suit, he thought it put an end to his claim and that there was no hope of collecting the money, and so he returned home. His statement was remarkable. He said he swam ashore the day he overturned the boat, put his hat in it, and left it half full of water. He determined to hide in the woods so that his wife could get the insurance money. He remained in the great swamps for 5 months when he found the body of a drowned man floating in the Alligator River. He removed the hair from the head so as to make it bald, and taking his own hair and whiskers, put them in the decomposing flesh of the corpse. He knocked out 2 of the front teeth of the dead man, and removing the clothing from the corpse, dressed it in clothes he had worn on the day of his disappearance. Early in 1890, a singular case of disappearance and of reappearance after a long interval was reported from the Australian city of Brisbane, the capital of Queensland. A surveyor named Geddes, who was insured in the Australian Mutual Provident Society for £2,500, was believed to have been drowned, and when claim was made for the amount of the policy, it was paid to Mr. Geddes' father. It now turns out that the surveyor was not drowned, but took passage on a vessel for New Zealand and landed at Invercargill, where he successfully practiced his profession. Some years afterward, having an erratic disposition, he returned and settled at Adelaide in South Australia, where he eventually became insane and was placed in a lunatic asylum. Here, by mere accident, he was discovered and his identity established. Thereupon the Australian Mutual Provident Society proceeded against the elder Geddes for the recovery of the money paid to him. Mr. Geddes responded promptly and properly, and not only returned the original sum, £2,500, but added interest amounting to nearly as much more, rising at 8% to £2,400. Late in the fall of 1883, George W. Strom was reported to have fallen overboard from the steamboat Gus Fowler in the Ohio River above Cairo. Some time afterward the man turned up alive with a doubtful story of terrible suffering. The newspapers intimated strongly at the time that the drowning was a farce played to defraud insurance companies. J.F. Yoakum, residing near Grand Chene, a sort of exhorter and schoolmaster, addressed a card to the public asserting that Strom was an honest man who could not be induced to defraud anyone, and that he had no insurance on his life. At Mound City, Strom, who was a simple-minded man, was induced by detectives to confess the plot. He had $10,000 insurance on his life and was induced to enter into a plot to get the money without taking the trouble to die. The plotters were on board the Gus Fowler, and it was agreed that when Yoakum made certain signals, Strom was to jump overboard and swim ashore. At Ogden's Landing, when near enough to shore to make it safe, the sign was made and Strom leaped over and gained the shore. After a reasonable time, Yoakum, with a power of attorney, made an application for money to various companies in which the insurance on Strom's life had been affected. An investigation was begun, which resulted in the arrest of Yoakum and Strom. Yoakum also made a confession, corroborating Strom's statements. Anthony Acchetta, age 40, an Italian residing at Catskill, New York, whose occupation was given as that of a railroad contractor, was insured in the Fidelity Mutual Life Association, January 14, 1885, for $10,000. The agent, A.G. Fox, was generally regarded as a man worthy of confidence. The policy was made payable to the father and mother of the insured, but a few months afterward it was surrendered for change of beneficiary, and a new policy was issued, made payable to the estate of the insured. Early in the month of June 1885, the Fidelity Association received a telegram from Agent Fox that Accetta was accidentally drowned in the Catskill Creek, near its confluence with the Hudson River. Without waiting for proofs or further developments, President Faust delegated Mr. Alexander McKnight, then Superintendent of Agents, to proceed to Catskill and investigate the case. He found that the brother of the insured, Cosmo Accetta, together with a boy, claimed to have been out on Catskill Creek in company with the insured fishing, and that at 11 o'clock at night, as they were about to pull for the shore, Anthony changed his place in the boat, fell overboard, and that was the last that was seen of him. The alleged drowning was reported, and the usual efforts were made to recover the body, but without success. About a week afterwards, the body of a dead man, very much bloated and discoloured, was found, and it is believed that if it had not been for the effective work done by the representatives of the insurance company, it would have been identified as the body of Anthony Accetta. The insured, it turned out, was an interpreter for Italian labourers of railroads instead of a contractor, and it was found that he had carried accident insurance in 2 different companies and had received benefits when he was not entitled thereto. He was assisted in securing such benefits by a Mrs. Hanley, with whom he boarded. It was her son, together with the brother Cosmo, who was a witness to the alleged drowning. A watch was placed on the house of Mrs. Hanley, the telegraph office, post office, railroad station, etc., to note the movements of the suspected parties. It was found that a little girl, the daughter of Mrs. Hanley, visited Hudson, a neighbouring town, almost daily, and that she called at the post office at the latter point. It became apparent that a correspondence was going on between Mrs. Hanley and Accetta under an alias previously agreed upon. With great difficulty, a photograph of the insured was procured from a photographer in New York City. The trail of the person who was believed to be Accetta was taken up at Buffalo and followed to Cleveland, Ohio, by Mr. McKnight, who found Accetta at 164 Superior Street, while in the act of writing a letter to Mrs. Hanley. He was at once taken into custody and searched. Letters were found on his person from Mrs. Hanley, written in cipher, and a book was found in his possession containing a key to the cipher. With the aid of the key, the letters were read, which proved conclusively that a conspiracy had been entered into by the woman and Accetta and his brother to defraud the Fidelity. Accetta, however, at once took the position that he had no intention of defrauding the company, that on account of a difficulty he had with a woman it was his intention to leave her under the impression that he was dead, and that neither his brother nor the boy had guilty knowledge of his intentions, that he actually fell out of the boat, swam under water for some distance so as to deceive them, and then swam across the river, where he dried his clothes and took the first train for Buffalo. His story was not believed, and the letters in cipher disproved it. He was taken to Catskill, and after a preliminary trial, which consumed nearly a week, he was held for final trial at the December session of the criminal court. His brother, Cosmo, Mrs. Hanley, and the boy were also arrested as parties to the conspiracy. Anthony was convicted and sentenced to the Albany Penitentiary for 1 year, while the others were either dismissed or sentenced to pay a small fine. End of section 19. Read by Sandra, near Montreal, 2021.
Section 20 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 10. A Welsh Deserter. John Jones of Pittsburgh, Pennsylvania, was insured by the Fidelity Mutual Life Association under policy number 5616 for $2,000, issued through its Pittsburgh agency, dated August 25, 1883. The policy became forfeit through non-payment of premium due May 30, 1889. Under its terms, it could not be restored without a certificate of good health signed by the insured in person, subject to the approval of the president and medical directors. On June 4, 1889, the amount due was paid and health certificate was furnished. The signature attached to the health certificate did not correspond with the signature appended to the application, which aroused suspicion that the signature attached to the health certificate was not that of the insured. The officers of the association declined to restore the policy, and it was then admitted by the wife of the insured that she had signed the health certificate in perfect good faith, that her husband had left her some time before, that his whereabouts were unknown, and she agreed that the reinstatement should not be binding if it could subsequently be shown that her husband was not in good health, as stated in the health certificate, at the time it was executed. On the strength of such agreement on the part of the wife of the insured, the policy was revived. No subsequent payment was made, and nothing further heard from the insured or beneficiary until April 1, 1892, when a demand was made for the insurance money. It was alleged that on December 23, 1889, the insured, John Jones, was killed by a Pittsburgh, Virginia, and Charleston train at Hayes Station, Pennsylvania. His remains, however, were not at the time identified, and he was buried at the county's expense. Mrs. Jones claimed that two young men told her on December 20, 1890, that her husband had been killed as above stated, and that thereupon she went to the coroner's office and immediately recognized the photograph of the remains of the man who had been killed by the train as being her husband. She reported the discovery to friends, who likewise called at the coroner's office and identified the picture of the man who was killed by the passing train as a likeness of John Jones. The lapse of time between the accident and the discovery and surrounding circumstances led the association to make a careful investigation. As a result, payment of the alleged claim was denied. Suit was brought against the association, plaintiff being represented by Mr. Roddy Marshall of Pittsburgh. The association was roundly censured for its attempt to deprive the unfortunate widow and orphan children of their rights. A number of affidavits had been obtained by Mr. W. E. Gary, chief of the association's inspection service, showing that the insured, John Jones, had been seen alive and well after he was claimed to have been killed by the railroad train. With the aid of such affidavits, an attempt was made to convince the plaintiff and her counsel that the insured was alive and that the suit should be dismissed, but Mrs. Jones would not be convinced, neither would her counsel, claiming that they could establish beyond a question of doubt that the man killed by the railroad train, who was unidentified for over a year, was no other than the insured, John Jones. The association, on the other hand, was equally convinced that it was not he, that at the time he was alive and worked in Scranton, Pennsylvania, and it therefore proceeded to find him, which proved a difficult task. He had left his wife and did not wish to acquaint her with his whereabouts. He was finally traced to England, and on December 28, 1893, through the courtesy of an inspector of one of the Scottish offices, he was located on Dock Street, Newport, in the county of Monmouth, England. He made an affidavit, sworn to before Mr. F. S. Dauncey, in which he gave full particulars of his departure from the United States, attaching a photograph as an exhibit, and established beyond doubt that he was the person insured by the Fidelity Mutual Life Association. On receipt of said affidavit and photograph, the latter was shown to people who were acquainted with Mr. Jones, and they without hesitation declared the photograph to be a picture of the insured. The following is a copy of the affidavit made by John Jones, December 29, 1893. In the matter of a suit alleged to be pending in the American courts between Martha Jones, plaintiff, and the Fidelity Mutual Life Association, defendants. I, John Jones, of Dock Street, Newport, in the county of Monmouth, England, laborer, and previously of several places in the United States of America, and for some time of Carson Street, Pittsburgh, in the said states, make oath and say as follows. 1. I was born in Crumlin, in the parish of Menindee Lyn, in the county of Monmouth, on the 5th day of June, 1843, and my father was Thomas Jones, who was locally known as Thomas Jones, of Llanhillock Colliery, proprietor. 2. I was married to the above-named Martha Jones, then Martha Thomas, or Lloyd, at the residence of the Reverend William Ragg, Sandkeys House, Sarah Street, Pittsburgh, aforesaid, in or about the year 1878, and lived with her off and on up to the years 1887 and 1888, when I left her, after being imprisoned for non-maintenance. I came to England in the year 1886, upon my father's death, and ultimately returned to my wife, and finally came back to England in 1891, where I have remained ever since. 3. I well remember having effected an insurance upon my life and in favor of my wife, the said Martha Jones, with the said Fidelity Mutual Life Association, at their office or agency in Pittsburgh for $2,000, and I believe it was in the year 1883, and that the policy is numbered 5616. I was medically examined by a stout practitioner at Allegheny City, but I forget his name. My wife always kept the policy, and as I could not get it from her, I declined to pay the premiums and the policy ultimately lapsed, and I thought it had come to an end. I did not know that it had been renewed, and I have never signed or authorized to be signed for me any health certificate to procure its renewal. 4. During part of the year 1886, I was in England, as aforesaid, and in 1887 and 1888, I lived with my wife, the said Martha Jones, at Pittsburgh, and in the years 1889 to 1890 and 1891. I worked at various places in the States, amongst others Scranton and Edwardsdale, Luzerne, Collinsville, Fayette County, and in 1891 came to England, as before stated. John Jones. Sworn at Newport in the county of Monmouth, England, this 29th day of December, 1893, before me, F.S. Dauncey. A commissioner to administer oaths in the Supreme Court of Judicature in England. The affidavit could not be used in court, but it served its purpose in convincing the Defendant Association that John Jones was alive. A commission was issued to take the deposition of John Jones before a United States consul in England. The testimony given in the deposition confirmed the statements made in the affidavit. The case was called for trial in the Court of Common Pleas, No. 3, Allegheny County, Pennsylvania, and after introducing in evidence the deposition of John Jones and other testimony showing that he was alive, the court, on October 9, 1894, granted a non-suit. It would have cost the Fidelity Association little, if any more, to have paid the fraudulent claim, which was resisted as a matter of principle. Repeated attempts were made by plaintiff's counsel to compromise the case, but the Defendant Association would entertain no proposition of compromise. End of section 20.
Section 21 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 11. The Burning in Place of the Drowning Trick. More than 20 years ago, Mary Halverson, a young Swede girl, had her home with Andrew Anderson, who kept a store at Neenah, Wisconsin. Mary was a bright girl and continued to live with the Andersons nearly 10 years. The house where they lived was known throughout that region as the haunted house. Strange traditions prevailed that a miner who had come from the then wilds of the Upper Peninsula of Michigan had entered the place one night seeking refuge from the storm, and that he had never been seen alive afterward. It was alleged that when the miner was last seen, he had $18,000 in money. The occupants of the place died not long afterward, and it passed into the possession of the Andersons, with the mystery which had followed the miner's disappearance clinging to it. The Andersons were naturally curious to learn if the money he was supposed to have had was still secreted on the premises. The girl Mary was as much interested as the family in the search for treasure trove. The yard was dug up, the house examined, but still no trace of it could be gleaned. Experts in psychical studies visited the haunted house from all over that part of the state. They admitted that there was something strange about it, but further than that, they could not penetrate. In 1880, the sweet girl Mary left Nina and went to Spencer to live. Afterward, she removed to Colby. There she met Ferdinand Jules Thrun, who was also a Swede. He was an excellent mechanic and was employed in the sawmills of that region. It was not long before an attachment sprang up between the two, and in 1881 they were married. Soon after the marriage, Thrun bought a sawmill with what earnings he had accumulated and started in business for himself. The venture proved a losing one, and he not only lost the mill, but was left with a large accumulation of debts. For a time thereafter, the history of the couple is a blank. The following year, Mrs. Thrun went back to Nina and visited the people who were living in the old house which had sheltered her so long. She seemed to take great interest in a part of the backyard which was buried under a big woodpile. After remaining at Nina for some weeks and finding that the woodpile was not to be removed, she returned to her husband, only to go back to Nina 2 years later. This time, the backyard was covered by a huge lumber pile. Once more she left, but in 1886 she reappeared at Nina and found the backyard of the old haunted house was unencumbered. This time her long and weary waiting to secure the treasure she had found in the old house and buried in the backyard was rewarded. It is believed that she had located the miner's money while residing with the Andersons and had hidden it in the yard, with the view of carrying it away at some future time when she could do so with safety. This incident illustrates the cool calculation of the woman who is to figure conspicuously in a most remarkable insurance fraud. The treasure trove of Nina came at a good time for Thrun. That year, he bought another sawmill, paying $4,000 in cash for it. The mill was at once heavily insured, and, whether from accident or design, it burned the following year. Those who knew the family are inclined to believe that this mill burned without the aid of a match, but it is immaterial from what source the fire started. As the tiger, which, having once tasted human blood, is ever after known as a man-eater, with an unquenchable hunger for human flesh. So the taste of insurance with the Thruns seems to have aroused an unappeasable appetite for it. Soon after the first fire, all the creditors of Thrun from his first venture came down upon him and made a desperate attempt to get hold of the insurance paid by the company. It was at this time that Mrs. Thrun told the story of the treasure trove at Nina and how she had obtained it. The story was wrung from her on the witness stand in her explanation of how she, a poor sweet girl, should have had so much money. Once started, she put on many embellishments about seeing mysterious lights over the spot where she found the money. The jury believed her story, and the creditors failed to recover. Opportunities were plentiful for buying old sawmills in that part of Wisconsin. Most of the timber had been cut away. In every few miles an old abandoned mill was to be had at almost any price. What had been thriving towns while the trees were being cleared away were now almost deserted hamlets. As soon as the legal wrangles with the creditors over the first mill had ended, Thrun again invested. His sawmill was started up, working on the residue of the timber which had been left over in the first grand onslaught on the Wisconsin pineries. Local insurance agents, on the lookout for remunerative commissions, were as plentiful in those days in that part of the Badger State as in the rest of the country. Thrun had no difficulty in getting his sawmill insured for all it was worth. He made a pretense of operating it for some months, and one night it followed the first one. The experience the couple had with their first mill had been a good guide to them with the second. This time, when the adjusters came to find out what their companies had really insured, they quickly learned that the only thing to be done successfully was to pay the loss. This was their report to the companies, and the Thruns got their second taste of insurance money. The course of the couple for the next 2 or 3 years in buying sawmills, which were always insured and were equally certain to burn up, became the general talk of the wide stretch of the country northwest from Oshkosh. People differ as to the number of mills which were thus realized upon. Some say that there were at least 5 or 6 of them. At last, officers of insurance companies came to the conclusion that by playing Thrun's game, they were to be the losers. When that decision was reached, Thrun had bought an old useless mill at Romeo, a small town on the Wisconsin Central some 75 miles northwest of Oshkosh. During the time that the timber was being cut away, Romeo had been a prosperous place of 1,000 population. When the woodchoppers and sawmill hands left, not over 40 or 50 people remained. Thrun's new mill, without insurance, was practically worthless, and the case to less resourceful people would have seemed hopeless. Not so with Mrs. Thrun, however. It appears that she conceived the idea of burning the mill and then suing the Wisconsin Central for the loss, on the ground that the fire had been caused by a spark from a passing locomotive. On Sunday night, the Romeo sawmill went up in smoke, as the others had done before. Suit was at once instituted against the Wisconsin Central for $20,000. The evidence against the railroad company was complete, as it always was in these cases. When the Wisconsin Central people examined the claim, they at once decided that it was fraudulent, and that the mills had been set on fire for the express purpose of bringing the suit. But their belief would amount to little before a jury composed of Thrun's associates in the county. A detective was sent to Romeo to uncover the fraud and to give the Wisconsin Central a basis for fighting the claim. The detective did not detect, for he was taken into camp by the Thruns through the influence of a woman. Like Antony at Alexandria, the detective forgot all about his quest until he was awakened to the necessity for action by a sharp letter from the railroad company. To square himself with the powers above him, he told the officials that the woman with whom he had formed an acquaintance knew something of the case, but what it was he had been unable to discover. The woman was brought to Chicago, but the officials were unable to wrench the facts from her. It was at this juncture that T.G. Hansen, who was taken to Oshkosh on the charge of being a co-conspirator in the insurance fraud, came upon the scene. The railroad company wanted an intelligent Swede to commingle with the people at Romeo and uncover the mystery of the mill's burning. Hansen filled the bill and was at once employed. A few days later, a young fellow, evidently just over, walked into Romeo and wanted a job as woodchopper. He was as verdant a foreigner, to all appearances, as ever disembarked in that part of Wisconsin, and that is saying a good deal. Thrun gave him work, and he did good service among the pine stumps. The newcomer immediately was smitten with the charms of the woman who had beguiled the first detective. The two got along famously together, and the young Swede developed a longing for liquor when in the presence of his charmer. One night, a pint bottle of whiskey was 2/3 emptied by the pair, and, in the confidential state this produced, the woman gave away the secret which the railroad company had sought so long. Soon afterwards, the woodchopper was arrested on complaint of the Wisconsin Central for some offense. He induced Thrun to come to Chicago with him in order that he might escape being locked up. Once inside the offices of the Wisconsin Central, the woodchopper disguise was thrown off, and the long array of circumstances he had gathered was unfolded to the firebug. Then, as he did before the attorney for the Mutual Life Insurance Company, Thrun broke down. He not only acknowledged that he had no just claim against the Wisconsin Central, but signed a paper before leaving the office relinquishing all demands for the loss of his mill. The pint bottle, with the whiskey which had been left by the woodchopper and the woman that night still in it, is now among the archives of the claim department of the Wisconsin Central in Chicago. The whiskey that is gone represents just $20,000. Hansen had done so well in his initial case that he was retained in the employ of the Wisconsin Central Claim Department and has since made an enviable record. He has enjoyed the full confidence of the officials, and nothing has occurred up to the recent developments in the big insurance fraud to indicate that he was not thoroughly honest. Even now, they profess confidence in his integrity and believe that he will come out of the ordeal unscathed. The failure of the attempt to filch money from the Wisconsin Central put a quietus on the plans of the Thruns for 6 months. The couple continued to live at Romeo in a ramshackle house, which was one of the few vestiges left of the town's more prosperous period. There was nothing more to be gained from fire insurance companies, but life insurance offered a most alluring inducement for swindling. All that was needed was to get the chief actor insured for a large amount, and he was to disappear. His widow was then to collect the value of the policies, divide the money among the co-conspirators, and then rejoin her husband in the mining regions of Idaho. The first plan which suggested itself to the conspirators was to have Thrun appear to fall overboard from one of the steamers trading between Green Bay and Chicago. This was accepted as the easiest way, and Thrun suddenly manifested a great interest in life insurance. Local life insurance agents were as eager for their commissions as the fire insurance men had been, and it was not long before Thrun had policies for $57,000, some of them in the most influential companies of the country. The risks were accepted by the various offices, with the exception of the Equitable Life of New York, whose inspector threw out the application because he could see no good reason why a man in Thrun's apparent circumstances should carry so heavy an insurance. One evening in the midsummer of 1892, a man with a heavy beard, a broad-brimmed slouch hat, and an ill-fitting suit of clothes, accompanied by a sharp-looking young man, boarded one of the Goodrich steamers, bound from Green Bay to Chicago. The same man with the same long beard disembarked from the steamer upon its arrival there. All night long, the bearded man had watched for a chance to fall overboard in such a way that a passenger with a smooth face, a derby hat, and a good suit of clothes would be left on deck. The old slouch hat was to have been dropped from the deck when the sharp young man sounded the cry of, "Man overboard!" The watchmen on the steamer did their duty so well that the scheme was balked. 2 more trips the same couple made between Green Bay and Chicago, but Thrun was not to die by being drowned. The boat watchman prevented that fate. It was then that the most horrible fate of being burned to death in his dwelling at Romeo was allotted to him by the conspirators. Mrs. Thrun, it appears, planned the details. The house was to burn down. Thrun was to disappear and bones were to be found among the ashes. To carry out successfully this project required witnesses who could be depended upon to prove Thrun's death to the satisfaction of the insurance companies. The circle of the conspiracy was enlarged to take in two of Thrun's associates at Romeo. The legal side of the case had to be looked after so that the claims on the policies might be valid, and also that, in case of failure, the conspirators would not suffer the penalty they deserved for the crime. As to the parties who entered into the conspiracy, the confession of Thrun left no doubt. It was a compact organization, and arrangements were promptly completed for the event which was to blot out Ferdinand Jules Thrun as a legal entity in human existence. Thrun's house at Romeo took fire the night of October 28, 1892. As the flames were working their way toward the roof, Thrun rushed into the burning structure and was not seen again. "I have some valuable papers in the house," he cried to the bystanders as he disappeared, "and I must get them." The next morning, when the people of Romeo began to poke around in the ashes of the burned building, they uncovered the bones of a human being. Thrun had been there the night before and was gone. He had been seen to go towards the house, and here were his bones. The coroner's jury was summoned, heard the statements of the people who had been at the fire, and found a verdict that F.J. Thrun had been burned to death. The three witnesses who had testified that they had seen Thrun enter the house to rescue his valuables were N.L. Claudy, George Luchtman, and Charles Herbert. They were all asleep at the house at the time the fire broke out. Mrs. Thrun was visiting friends in an adjoining town when she received a dispatch to come home and that her husband was dead. "I am aware," she calmly said to the representatives of the life companies, "that some people say my husband is not dead. All I know is that the men who were with him that night say that he was burned in the house, and the coroner's jury has said that he was dead. All I ask is that you satisfy yourselves, gentlemen, as to his death. I am in no hurry. I can wait until you are ready to pay me. If my husband is alive, as you say he is, you must produce him. I would rather have him back than have the money. But if he is dead, I am entitled to what is due on the policies." All the cross-questioning of expert underwriters who had been trained in the wiles of life insurance crooks did not discompose Mrs. Thrun. She was cool and collected throughout an ordeal which would have broken down any ordinary man or woman. Subjected to the same test afterward, her husband went to pieces almost at the outset. "The poor man was burned to death," she said at once, although the dispatch had told nothing of there being a fire. She had with her insurance policy on Thrun's life. Some women would have overdone the thing by a profusion of tears and sobs. Mrs. Thrun did nothing of the kind. She professed sorrow at her husband's death, put on her widow's weeds, and started in to collect the insurance. Soon afterwards, she removed to Fredonia, a small town about 30 miles from Milwaukee. 6 weeks elapsed before serious doubts as to the fate of Thrun began to be aroused. When it was discovered that the bones found in the ashes were those of an old skeleton, the doubts ripened into certainty. The insurance companies prepared to fight the claims, and on December 22nd, the case was turned over to the Pinkerton Detective Agency. All were united in the search for the man who had taken the star part in the fraud. In January 1893, Mrs. Thrun, still wearing her widow's weeds, appeared at the offices of the insurance people in Chicago and insisted upon payment of her claim. The policies were transferred to the hands of Hansen for collection, but in view of the well-founded doubts of the underwriters and the significant rumors afloat, he undertook to compromise. Some of the companies were induced to pay 10% of the face value of their policies in exchange for those contracts. Apparently realizing that the conspiracy had failed, Hansen suddenly changed front. Perhaps in order to save himself, if guilty, he entered into a contract with the Aetna Life of Hartford to produce Thrun within 90 days. At the same time, Hansen insisted on the company paying 10% on its policies of $15,000, life and accident. This offer the Chicago manager energetically declined. Hansen made a pretense to be at work looking for Thrun, but told the insurance company that he had not been able to locate him. At the end of the time specified in the contract, he appeared again at the office. This time he is said to have offered to produce Thrun in short order if immunity from prosecution were given the fugitive. "Produce your man," General Agent Linus said to Hansen, "and we will settle the question of prosecution afterward." Hansen left the office in a rage. In all, he secured about $4,000. The Mutual Life, which paid over 10% of its policy of $10,000 for a settlement, soon regretted the hasty step and joined eagerly in the search. Convinced that the easiest way to trace Thrun's whereabouts was to watch the correspondence between the fugitive and his wife, the detectives began to work at Fredonia. As was suspected, Thrun had gone into the wilds of northern Wisconsin at first and had drifted thence into the far west. From Montana, he was traced over nearly every state in the Mississippi Valley. He had come to Chicago and from there had drifted towards the south. When he anchored in New Orleans, he worked as a day laborer, and his entire surroundings indicated that he had but one object in life, and that was to escape arrest. Everywhere he felt that detectives were on his track. His only correspondent was his wife, and she addressed her letters to R.L. Harris. With that clue, a detective was at the post office window one day when he called for his mail. The letter received at the time was not from his wife, however. It was from the Pinkerton Agency in Chicago, and as it was handed to him, he was placed under arrest. William Beck, who had been employed by the Mutual Life of New York in the search, went to New Orleans and brought back the prisoner, who seemed to be relieved by his arrest. On his arrival in Chicago, he was taken to the office of Gordon E. Sherman in the Ashland block, where he was subjected to a fire of cross-questioning, which soon brought out all the facts regarding the great fraud. Put to the test, Thrun broke down in Mr. Sherman's office and told of the steamboat scheme as leading up to the burning of his house. This confession was made March 17, 1893. The arrest of the conspirators followed, but they were not tried until December 8th of that year. A verdict of acquittal was returned in the cases of Hansen, Follett, and Claudy, the parties mainly implicated in the confession. Apparently, the jury believed them while they refused to believe Thrun. But as the charge of conspiracy failed, Thrun was allowed his discharge with the rest of the gang. End of section 21. Section 22 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances Part 12. The Mariano Rubio Case. From a full and carefully prepared report of this remarkable case in the Coast Review, San Francisco, the following particulars are obtained. On the 3rd day of March A.D., 1869, Miguel No, made application to the Manhattan Life Insurance Company to insure the life of one Mariano Rubio in the sum of $15,000 on an ordinary life policy to be made payable to no who claimed to be a creditor of the said Mariano Rubio. The application was presented in the regular form. Rubio was properly examined, the application accepted by the company, and a policy issued for the sum of $15,000. Rubio, the assured, was at that time a resident of the county of San Luis Obispo, California. The premiums upon the policy were regularly paid up to March 23, 1880. On July 1, 1879, the policy was regularly and duly assigned by Miguel No to a leading lawyer of the city of San Francisco, Mr. Tully R. Wise, who thereupon became the lawful owner for a good and sufficient consideration. By private arrangement, however, between No and Wise, the former was to receive 1/2 of the proceeds of the policy, should it ever be collected. On the 23rd day of October 1880, there was presented to the Manhattan Life Insurance Company the following proofs of the death of Mariano Rubio, which it was alleged had occurred in the manner stated by the witnesses in the affidavits hereafter noted. Notice is hereby given to the Manhattan Life Insurance Company of New York that Mariano Rubio of San Luis Obispo, County of San Luis Obispo, California, has deceased. That said, Mariano Rubio was the same person insured by said Manhattan Life Insurance Company in the sum of $15,000 for the term of his natural life, by their policy of insurance number 27,671, dated March 5, 1869, and that under the terms and conditions of said policy, the same becomes payable to me as the lawful holder and owner of said policy, and I hereby declare that my interest in said policy is to the full amount of $15,000, and do further declare that the statements in the annex certificates A, B, and C are correct. The proof of said death and my claim under the before-mentioned policy I answer as follows. Name of deceased, Mariano Rubio. Residence, San Luis Obispo County, California. Occupation, farmer. Place and date of birth, Mexico, March 1st, 1824. Place and date of death on his way from Los Angeles to the state of Nevada, somewhere in November 1879. Have been acquainted with the deceased 15 years. Last November, said Rubio and one Gonzalez, with others, left Los Angeles County for Nevada and were lost on the way, and died from exhaustion. Their bodies were found about 6 days after their separation from the other parties, and were buried on the spot where they were found. Dated at San Francisco, October 23, 1880. Signed and sworn to before Commissioner of Deeds Holland Smith by Tully R. Wise, a signee, who made oath that the foregoing statements by him made were true and full, to the best of his knowledge, recollection, and belief. Certificates A and B annexed, being for the attending physicians, and the undertaker's statements, of course, were left blank. Certificate C, however, the statement of an acquaintance of deceased, was subscribed to by one Anders Sanderfield, who testified that he had known Mariano Rubio since 1850, and that the latter had died in Nevada from exposure, as stated in the accompanying affidavit. Accompanying the above statements regarding the decease of Mariano Rubio, and apparently relied upon to corroborate them, was affidavit made by Rafael Peralto and Maximiano Archie, who stated under oath that they left Los Angeles to go to Nevada with Mariano Rubio on the 13th day of November, 1879, and during the trip, Mariano, Rubio, and a man named Gonzalez separated from them, and about the 27th of November, the former two lost their way, as Peralta and Maximiano supposed, and 6 days after, the affidavit goes on to say, "We came upon their dead bodies, and we buried them about 280 miles from here, and we can now go to the spot." Mariano Rubio I knew for a long time. He was an old man, and his age I do not know, but he must have been between 50 and 60. The affidavit containing the above statement was begun in the plural, and in the last two sentences was written in the first person singular. It was signed by both Maximiano Archie and Raphael Peralta, in the presence of W.H. Gray, Notary Public, in Los Angeles, October 6, 1880. Attached to the same affidavit was one subscribed to by Francisco Milliken, who testified that he knew the parties above named and knew that Mariano left that neighborhood, Los Angeles, with them in accordance with the above affidavit. Senor Ignacio Sepulveda, Superior Judge of Los Angeles County, certified that W.H. Gray was a notary public in and for that county at the time the above affidavits were taken, and that his signature was genuine. Detective Harry Morse was engaged to look up the various parties who had a personal knowledge of Rubio's death, and soon learned that one Jose Lopez had accompanied Rubio to Sonora about the time at which his alleged death took place, in the desolation of Death Valley. A detective was sent to Mexico, and finally the long-lost Rubio was found alive, in excellent health, and moreover, newly married in Autlán, in the state of Jalisco. Meanwhile, on the 6th of December, 1881, suit was brought by Tully R. Wise against the Manhattan Life Insurance Company in the Superior Court of San Francisco to recover the sum of $15,000, with interest thereon from the 30th day of November, 1879, and the further sum of $407.35, with interest thereon from the 23rd day of March, 1880, and for costs. The complaint set forth the statement of the insurance of Mariano Rubio by the defendant, the interest of Miguel No and of the plaintiff, and the statement of Rubio's death as given in the proof of death and in the narratives of Maximiano, Archie, and Peralta. An answer signed by Mr. Landers as representative of the defendant company, denying the claim, was filed in January 1882 by Messrs. McAllister and Bergen, attorneys for the defendant. Soon after, Messrs. McAllister and Bergen received a letter from the U.S. consul at Mazatlan, under date of January 30th, 1882, in which the following appeared. I had the pleasure to report the successful completion of the commission entrusted me by you, to obtain proofs of the existence of Mariano Rubio, whose life had been insured in the Manhattan Life Insurance Company in favor of Miguel No, and whose death has been claimed to have taken place. I dispatched Mr. Campbell Ford to Autlán for the purpose of obtaining affidavits, and today received a document from him, properly authenticated by the U.S. consul at Manzanillo, which proves beyond doubt the existence of Rubio. Mr. Ford writes me that Rubio is about to get married and is in perfect health. Accompanying the above letter were the proceedings of voluntary jurisdiction instituted by Mariano Rubio to demonstrate the identity of his person. On the margin was the seal of the Revenue Department of the 6th Canton of the state of Jalisco. The evidence was taken at Autlán, January 13, 1882, and signed by Rosenda Hiyar de Haro. To the Court of First Instance, I, Mariano Rubio, of lawful age, widower, and resident of this vicinity, as the best mode of proceeding, depose and set forth. On the 23rd of March, 1879, the Manhattan Life Insurance Company, established in San Francisco, state of Upper California, one of the United States, insured my life, the respective policy being fixed in the sum of $15,000 on account of Senor Don Miguel No, resident in the said city of San Francisco, and intervening in that contract, besides the Senor No, his attorney Hulls, whose name I do not remember, 2 agents of the said company and myself, and the Senor No, having obligated himself to pay the premiums, bonus correspondent to the policy, and to acknowledge on my death, in favor of my heirs, the sum of $5,000. Rubio then set forth that in order to secure as well as the rights which pertain to him in the said policy, as those which the said company might have or desired to make clear, he prayed the court to execute such proceedings of voluntary jurisdiction as might conduce to the identification of his person. Thereupon, such proceedings were had. Rubio's personal appearance, age, and general qualities were deposed to by witnesses. It was shown that he was enrolled as a citizen of that city for many years of his life, and that from there he came to California about 30 years ago, and that in 1880 he returned to Autlan. Rubio, upon being sworn, told the tale of his return home as follows. In the month of March or April of the current year, it will be 2 years since he arrived in this place, Autlan, having been 3 months on the road from San Francisco, California, to this place, his last place of residence having been the Santa Rosa Ranch, in the county of San Buenaventura, California, whence he departed for the Colorado River, thence touching at Altar, in the state Sonora. From this latter place he went to Hermosillo, thence to Guaymas, thence to Alamos, thence to Friet River, thence to Culiacan, in the state of Sinaloa, thence to the port of Mazatlan. From Mazatlan to Autlan, the route taken by Rubio was also described. Continuing, Senor Rubio deposed, "It is alike true that in order to be able to marry Donna Merced Hernandez, I was required to furnish evidence of the decease of my first wife, Donna Maria Villasenor, which took place in San Francisco, California, which evidence was furnished in a certificate which was issued to me by the Senor Bishop of the aforesaid California. It will be observed that both sides, up to this time, had made strong documentary evidence to substantiate their respective positions. The plaintiff, Mr. Tully R. Wise, had submitted the proofs of the death of Mariano Rubio and the sworn affidavits of 2 persons who had buried his remains in the sun-heated sands of that far distant and desolate region known as Death Valley. For the defense, the statement of Jose Lopez, who said he had gone to Sonora with Rubio, was obtained, and in substantiation of that statement, it was found that a man named Mariano Rubio had arrived at Mazatlan, and from thence had gone to Autlan, Jalisco, his native place, as told by a well-known citizen of San Luis Obispo County. What would be the result should these 2 conflicting theories be placed before a jury? A sum of money aggregating nearly $20,000 was at stake, besides the moral effect of being right or enduring wrong. At this crisis, Mr. John Landers, agent of the Manhattan, dispatched Mr. A. Hinz to Mexico to find Mariano Rubio and produce him in San Francisco. This step was taken in April 1882. Mr. Hinz made a toilsome trip through the mountains of Mexico to the city of Autlan, Jalisco. He returned to San Francisco after great hardship and expense, arriving there on the 29th day of May 1882. With him, he brought Mariano Rubio, alive and in good health. Senor Mariano Rubio was accompanied by his wife, a buxom, brilliant Mexican woman, whom he recently wedded in Auckland, his native city. They were soon safely domiciled at one of the leading hotels in this city, secure from intrusion and supplied with the comforts and necessities of life. On the day of their arrival in San Francisco, Senor Rubio, when leaving the office of the Manhattan Life Insurance Company on California Street, came face to face with Mr. Tully R. Wise and Senor Miguel No, who were conversing together upon the sidewalk. The recognition of Rubio by No was almost instantaneous. The latter gave his hand to Rubio and bade him welcome, extending the hospitalities of his home to the long-sought-for Mexican. But to affirm that No was not surprised at the unexpected appearance of Senor Rubio would be wide of the truth. The latter presented a well-preserved figure for a man buried in the scorching sands of Death Valley for 3 years. Whatever splits there had been in his lips were completely healed. His tongue did not have the appearance of having been burned and blackened by thirst, and his body had so recovered from its exhaustion and the advanced stage of decomposition so graphically portrayed by Maximiano Archi and Rafael Peralto as to be recognizable by his old friend, Senor Miguel No. A conference was held in the office of Messrs. McAllister and Bergen, Nevada Block, this city, at which were present Mariano Rubio, Miguel No, Tully R. Wise, John Landers, and Mr. Bergen. Mr. Wise expressed his entire satisfaction at the identity of Rubio, and also his regret at having been led into assuming the questionable position that he occupied. He believed that rank perjury had been committed by the parties who had alleged that they had buried Rubio, and not only condemned them, but held that they should be punished. In conclusion, he metaphorically washed his hands of the whole affair. Subsequently, the following document was drawn up and filed in the Superior Court. In the Superior Court of the State of California, in and for the City and County of San Francisco, Tully R. Wise, plaintiff, versus the Manhattan Life Insurance Company, defendant. The plaintiff in the above entitled action, being here now fully satisfied that Mariano Rubio, named in the complaint in said action, is now living, and that the plaintiff is not entitled to recover herein, it is hereby stipulated that said action be, and it is hereby dismissed, and the clerk of said court is hereby authorized to enter judgment of dismissal in said action. Signed, Tully R. Wise, plaintiff in person. End of section 22.
Section 23 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Beau Wood. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 13. The Hillman Concealment. The cases of Sally E. Hillman against the Mutual Life Insurance Company, the New York Life, and the Connecticut Mutual Life, repeatedly before the courts for a period of 13 years, have attained a degree of notoriety that could only attach to one of the most desperate legal struggles in the history of jurisprudence. The contention on the part of the companies has cost them more than their liability in the event of satisfactorily proved death, and their stubborn resistance has been due to their belief that Hillman has been seen alive in various places at different times, that he is still eluding the detectives and covering his tracks, and that it is a duty they owe to honest policyholders, aside from subserving the ends of justice, to resist fraud at any cost. When the claim was made and resisted, the first trial took place in the United States Circuit Court at Leavenworth in June 1882. The jury failed to agree, and in 1885 the case was retried in the same court before Judge Brewer with a like result. A third trial was held in Topeka in February 1888 before Judge Shiras, and a verdict was rendered for the plaintiff. The jury gave a verdict against the Connecticut Mutual for $7,530, against the New York Life for $15,060, and against the Mutual Life of New York for $15,060. The defendants entered a motion for a new trial, and Judge Shiras suspended judgment until the June term to allow of the preparation of a bill of exceptions. The grounds upon which the new trial was asked were as follows. First, misconduct of the plaintiff at the trial. Second, misconduct on the part of the jury. Third, because the verdict and judgment are contrary to the evidence. Fourth, because the verdict and judgment are contrary to law. Fifth, because of error of law occurring at the trial and duly accepted to by the defendants at the time. Sixth, newly discovered evidence material to the defendants which they could not, by reasonable diligence, have presented upon the trial of this action. Failing to secure a new trial, the companies carried the case to the United States Supreme Court upon questions of law. The decision of the Supreme Court at Washington reversed the judgment in favor of the plaintiff in the Circuit Court at Topeka, its action being based upon errors in the admission of testimony and in the charge to the jury. After this remand, the case came up for a fourth trial at Topeka and ended in another disagreement. On the first trial, the jury stood 10 for plaintiff and 2 against. On the second, they stood 6-6. On the last trial, 7 for the plaintiff and 5 for the companies. John W. Hillman was born in Indiana in 1845. Therefore, at the time of his alleged death near Medicine Lodge, Kansas, in 1879, he was 34 years of age. In October 1878, he was married to Sally E. Quinn, the plaintiff in the suits against the companies. 4 months afterwards, he started for Wichita in company with his partner, John H. Brown, both being drovers. Near sundown on March 17, 1879, while encamped in a desolate spot on Crooked Creek, a man was shot through the head and killed by Brown. He declared that it was accidental and had occurred while he was taking a rifle from the wagon. He called upon a farmer in the neighborhood named Briley to view the body and assist in burial. He asserted that the body was Hillman's, and as the head had been placed near the fire, the features were burned and charred beyond recognition. Afterward, when the body was exhumed and taken to Lawrence for identification, it was noted that the corpse had a full set of regular teeth, whereas Hillman's were irregular and one had been lost. Confronted with the dental evidence, Brown broke down and confessed that Hillman was alive, that a conspiracy had been formed in December 1878 between Hillman, Mrs. Hillman's cousin Levi Baldwin, and himself to defraud the insurance companies. Baldwin was to furnish the money for the first-year premiums, and Brown and Hillman were to arrange for the latter's disappearance. Brown alleged that the man who was killed, in order to provide a body to be palmed off as Hillman's, was named Joe Berkeley. This eventually proved to be false, as it turned out that the dead man was Frederick Adolph Walters, a young German cigar maker of Fort Madison, Iowa, who had gone to Lawrence in 1878. His remains were identified by his parents and sister. Here, then, was a plain case of murder in which Brown and Hillman were principals and Mrs. Hillman and Baldwin accessories before the fact. In a subsequent confession made by John H. Brown before a notary public of Platte County, Missouri, he blamed Hillman with the shooting. The notary's record is as follows. John H. Brown, of lawful age, being duly sworn according to law, deposes and says, My name is John H. Brown. My age, 30 years. I am acquainted with John W. Hillman, also Mrs. S. E. Hillman, and Levi Baldwin of Douglas County, Kansas. Have known John W. Hillman for about 5 years and have been with him a good deal for the last 2 years. I was with him last March at Wichita and on the trip from there to and around Medicine Lodge in Barber County, Kansas, where it is claimed that I killed him on the 17th day of March, 1879. Along about the 10th of December, 1878, John W. Hillman, Levi Baldwin, and myself talked about and entered into a conspiracy to defraud the New York Life Insurance Company and the Mutual Life Insurance Company out of some money to be obtained by means of effecting policies on the life of said John W. Hillman. Baldwin was to furnish the money to pay the premiums and to keep up the policies in case they had to be renewed. Our original arrangement was to get Hillman's life insured for $15,000, but it was afterwards changed to $25,000. Hillman and myself were to go off southwest from Wichita, Kansas, ostensibly to locate a stock ranch, but in fact, to in some way find a subject to pass off as the body of John W. Hillman for the purpose of obtaining the insurance money aforesaid. We had no definite plan of getting the subject, but to, in some manner, get one. The final termination of the matter was the last idea thought of. Our first trip out from Wichita was in the last days of December, while the snow was on. We expected to find a subject that would appear to be Hillman, frozen to death, and that could not be identified except by the clothes and papers found upon it, and so I could pass it off as Hillman. We went from Wichita to Medicine Lodge, then direct to Sun City, from there to Kinsley, from there to Great Bend on the Santa Fe Road, then to Earned, and to Wichita via Hutchinson. Hillman and myself were entirely alone on this trip. Iliff of Medicine Lodge saw Hillman on this trip. We put up at his stable. I then stayed at Wichita until the 4th of March. Hillman, in the meantime, went up to Lawrence to see his wife and to get some more money. He returned about the 1st of March, and on the 5th we left on our second trip. We went due west to Cowskin Creek, and then west to Harper City, then to Medicine Lodge, on by Sun City, and beyond some miles. Then we turned northeast down Medicine River to a camp on Elm Creek, about 18 miles north of Medicine Lodge, where Hillman is claimed to have been killed. We got there about sundown and stayed in camp until the next evening. We overtook a stranger on this trip, the first day out from Wichita, about 2 or 2.5 miles from town, whom Hillman invited to get in and ride, and he, Hillman, proposed to hire him to work for him on the ranch as proposed to be located. This man was with us during all this trip. Hillman proposed to me that this man would do for a subject to pass for him. I told him and contended with him that the man would not do to pass off for him, giving him various reasons why the man would not answer his description, and complained and objected because his proposition was to take the man's life. And I protested and said that was going beyond what we had agreed and was something I had never before thought of and was beyond my grit entirely. But Hillman seemed to get more deeply determined and more desperate in the matter. Pains were taken not to have more than 2 of us seen together in the wagon. Sometimes one and then the other would be kept back out of sight. On his trip up to Lawrence, Hillman was vaccinated. His arm was quite bad. Hillman kept at the man until he let him vaccinate him, which he did, taking his pocket knife and using virus from his own arm for the purpose. He also traded clothes with him, Hillman first giving him a change of underclothing, then traded suits, the one he was killed in. The suit he was buried in was a suit Hillman traded with Baldwin for. This man appeared to be a stranger in the country, a sort of easy-go-along fellow, not suspicious or very attentive to anything. His arm became very sore, and he got quite stupid and dull. He said his name was either Berkeley or Burgess or something sounding like that. We always called him Joe. He said that he had been around Fort Scott a while and had also worked about Wellington and Arkansas City. I don't know where he was from nor where his home or friends were. I did not see him at Wichita. That I know of. I had but very little to say to the man and less to do with him. He was taken in charge by Hillman and yielded willingly to his will. I dreaded what I thought was to be done and kept out of having any more to do with him than was possible. I frequently remonstrated with Hillman and tried to deter him from carrying out his intention of killing the man. The next evening, after we got to the camp last named, the man Joe was sitting by the fire. I was at the hind end of the wagon, either putting feed in the box for the horses or taking a sack of corn out, when I heard a gun go off. I walked around and saw the man was shot, and Hillman was pulling him away around to keep him out of the fire. Hillman changed a daybook from his own pocket to Joe's and said to me everything was all right and in shape, just as he wanted it, and that I need not be afraid, but it would be all right. He told me to get on a pony and go down to a ranch about 3/4 of a mile and get someone to come up. He took Joe's valise and started north. This was about sundown. We had no arrangements about communicating with each other. He first proposed to do so, but I told him I did not want to know where he was, that in case I should, I might find out some other way. I have never heard a word from him since that time. At Lawrence, Mrs. Hillman gave me to understand that she knew where Hillman was and that he was all right. The man over whom an inquest was held at camp, afterwards at Medicine Lodge, and at Lawrence, Kansas, was the man named Joe Burgess or Berkeley, killed by Hillman, as related above, and John W. Hillman, I believe, to be still alive. At least he left our camp and went north, as stated above. After killing Joe, Hillman said he would assume the name of William Marshall. Baldwin, his wife, and Mrs. Hillman know all about this. The last trial of this remarkable case, which took place in the United States Circuit Court at Topeka before Judge A.D. Thomas, occupied a period of 9 or 10 weeks in the early part of 1895. With regard to the question of identity, it was shown that while Hillman's height was 5 feet 9 inches, Walter's height was 5'11 and a half. There were material differences between the hair, the teeth, and the weight, and one had several distinctive scars. While 8 witnesses declared that the body in dispute was Hillman's, 21 of the defendant's witnesses testified that it was not Hillman's, and 26 others, including Miss Alvina D. Caston, who was engaged to be married to Walters, insisted that the body was Walters. Charles Hay testified that he saw Hillman alive near Leadville in July 1879, and the following witnesses declared that he was alive after March 17, 1879, the date at which Hillman is claimed to have been shot. Richard Helm of Albuquerque, New Mexico, J.D. Benton of New Mexico, and W.E. Northrop of New Mexico, who saw Hillman alive in 1884 and 1885. The following witnesses who knew Hillman intimately in the 70s, having hunted on the plains with him, identified him when arrested and imprisoned in 1889 in Tombstone, Arizona. John H. Mathias, George S. Baker, Charles W. Hart. Mrs. Hillman, in 1882, admitted before 5 witnesses that her husband was alive. Mrs. George A. Nichols, Hillman's sister. George A. Nichols and W. W. Nichols, Hillman's 2 brothers-in-law. Mr. S. D. Nixon and Mrs. Maggie Nixon, all testify that Mrs. Hillman, at the first trial of the case at Leavenworth, went to the Continental Hotel where the above-named parties were stopping to find out what they intended to testify to in the case as to the appearance of her husband, and when told they would describe his defective teeth and the scar on the hand, exclaimed, "If you, his sister, and you, his brothers-in-law, and you, his friends, mean to testify to that, then I will go and withdraw my suit and turn my husband over to the authorities." On the 15th of September, 1879, Mrs. Hillman went to the office of Mr. Wheat, one of the attorneys for the plaintiff, who lived in Leavenworth, and demanded from him the policies, which he then held, stating that she wanted to back out from suing the companies. Mr. Wheat refused to give them up unless he was paid $10,000, claiming a lien to that extent. Mrs. Hillman, finding that she could not obtain the policies to hand back to the companies, executed 4 releases, the following being a copy of one, and all being identical except the name of the company, number of the policy, and amount. Lawrence, Kansas, September 15, 1879. In consideration of $1 to me in hand paid, the receipt whereof is hereby acknowledged. I hereby release, surrender, and acknowledge satisfaction in full of all claims against the Mutual Life Insurance Company of New York by reason of policy number 195132, issued by same company, dated December 10, 1878, and for the sum of $10,000 on the life of my husband, John W. Hillman, and hereby enter satisfaction in full and order the dismissal of any and all suits or proceedings commenced, or that may hereafter be commenced by any person or persons in my behalf for the collection of the same. Signed, S. E. Hillman. Attest, W. J. Batchen. Attest, John H. Brown. These releases were signed without the payment of $1 or the promise of the payment of $1. They were signed upon one condition, namely, that the companies should agree of themselves not to undertake the prosecution of John W. Hillman, Mrs. Hillman, Levi Baldwin, and John H. Brown, but with the understanding that if the state prosecuted them, the companies would not withhold the evidence which was then in their hands. The insurance companies claimed that a conspiracy was entered into by John W. Hillman, Levi Baldwin, and John H. Brown for the purpose of insuring Hillman's life, in pursuance thereof, securing the body of another man and palming it off upon the companies as that of Hillman, and then collecting the insurance money upon Hillman's life and dividing it among themselves. The companies also claimed that Mrs. Hillman became a co-conspirator with them at the time of the inquest and continued to be such from that time on, and that also others, on account of their pecuniary interest, became co-conspirators engaged in the endeavor to collect the insurance money on the life of Hillman not having lost his life. In support of this charge of conspiracy, Dr. Phillips testified that Levi Baldwin asked him all about life insurance, the length of time after death before decomposition set in, and the appearance of a man after being buried, and also said, "Doc, wouldn't it be a good plan to insure some fellow's life, have him disappear and go south, and get the body of some greaser and pass it off on the insurance companies for him?" Mr. Blythe, an attorney of Tonganoxie, testified that Baldwin and Hillman came to him one day and asked all sorts of questions as to the manner of collecting insurance money in the event of death. Baldwin told him that he meant to insure Hillman's life, and he wanted to know how he should go about it. Mr. Blythe explained that as he was not a life insurance agent, it would be better to consult those who were engaged in the business. Mr. Seelig, Mr. G. W. E. Griffith, and Major Wiseman testified that Baldwin and Hillman went unsolicited and made application for $50,000 insurance upon the life of Hillman, $25,000 of which was issued. That Baldwin and Hillman repeatedly asked what form of statement had to be made out in order to collect the money in the event of Hillman's death. Mr. Carr testified that Baldwin told him in March 1879 that he and Hillman were mixed up in a scheme to get hold of a lot of money. As already remarked, the successive suits, the adjudicature of the highest court in the land, the efforts made in tracing the fugitive in Arizona and Mexico, and the employment of all the legal and detective machinery available must have cost the companies more than $25,000, the amount of the claim. They have never accepted the averment that the man killed near Medicine Lodge in March 1879 was John W. Hillman. They have always contended, and they are firm in the belief, that it was another man who was killed, and that the parties to a criminal conspiracy undertook to palm off the body as Hillman's, while they facilitated Hillman's escape and concealment. It is now 17 years since Hillman disappeared, and if he is still lingering among the living, he has well preserved his disguise. In the event of proof of his death, the companies have, of course, been ready to meet their obligations. But until such proof is complete and satisfactory, or until the courts in their final judgment make payment compulsory, they are justified in resistance. End of section 23.
Section 24 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 1, Poisoning and More Violent Forms of Assassination. In revolving our many-sided picture, we next come to the tragic side, the portion whereon the darker shadows fall. Here, to the eagerness of the speculator and the calculation of the gamester, is added the fiendishness of deliberately planned and relentlessly pursued homicide. And in view of the fact that the victim is generally selected from that relationship or that friendship which will sustain an insurable interest, we may well exclaim, "Murder most foul, as in the best it is, but this most foul, strange, and unnatural." If we scan the biography of the homicides who have left their names on the scroll of infamy, we find that many of them were patterns of gentlemanly grace and fastidious polish. But under the surface show of refinement and complacence was the serpent's fang. The velvet glove concealed a bloody hand. Gilding and sugar-coating masked the poison that had been smuggled into the salutary drug prescribed as a restorative. Probably no one of this class ever equaled Thomas Griffith Wainwright, the literary coxcomb, who, under the nom de plume of Janus Weathercock, wrote such slashing reviews and spicy criticisms in the English magazines on art and artists, the drama, the opera, and the ballet. A fine person and fascinating manners, great fluency and ready wit, he was not only an acknowledged leader of fashion, but such a favorite in aristocratic circles that even the gentle and amiable Charles Lamb could not help writing of him, kind, light-hearted Janus Weathercock. Nor did he ever sparkle with such unwonted gaiety or so outshine his accustomed elegance as while the poison he was secretly administering was speeding on its deadly errand. It is nearly a half-century since Helen Abercrombie's young life was sacrificed by this brother-in-law in hope of gaining £18,000. But many another half-century will roll around before the circumstance will be forgotten in England. Whoever follows his career can easily understand why Mr. Francis observes of him, "It was death to stand in his path. It was death to be his friend. It was death to occupy the very house with him." Well might his associates join in that portion of the litany which prays to be delivered from battle and murder and sudden death, for sudden death was ever by his side. Yet, in point of resolute daring and infrequency of repetition, Wainwright's methods of assassination were tame compared with those of William Palmer, the sporting surgeon, a history of whose crimes is here presented to the reader. William Palmer of Rugeley. In the valley of the Trent, on the line of the Northwestern Railway of England, lies the quiet, pretty town of Rugeley. It is about midway between the great sporting grounds of Derby and of Chester, and is well known for its jockeys and its horse fairs. Among the fields and the trees which make the town, like almost every English country town, enchantingly beautiful, is an old square house of brick standing on the shores of the river, with gardens sloping to the margin. With the generations to come, it will very likely be called a haunted house, and the yews which darken the doorstep will nourish murderous memories in their shadow. A wood merchant lived years ago in this square brick house, who made the building what it is only after acquiring, very suddenly and very mysteriously, a large fortune. His business was not extensive. He was known to be a betting man, yet he lived extravagantly, reared a family of 5 sons and 2 daughters, and one day suddenly and mysteriously died. Of the 5 sons, one became a clergyman, one a grain merchant, another an advocate, a 4th a lumber merchant, and the 5th, whose name was William Palmer, studied chemistry in Liverpool and became a surgeon. At the time, 1856, public attention was attracted to the crimes which have made his name famous. Palmer was only 35 years of age. He was a man of fine presence and winning manners. He had played, in his youth, the country roue, and had married, some years before, the natural daughter of Colonel Brooks, of the East India Service. Colonel Brooks was a man of fortune. He was mysteriously assassinated not long after the marriage of his daughter. By his will, he had bestowed upon the mother of his child a life lease of his estate. The daughter, Mrs. William Palmer, was remarkable for her beauty as well as for her kindness of heart, and the poor people of Rugeley have always a good word for the memory of Mrs. Palmer. William Palmer seemed to give himself up to 2 fancies of a very opposite nature, to wit, horse racing and chemical experiments in his private laboratory. The first involved a full purse. His private resources became speedily exhausted. He appealed to his mother-in-law, who, anxious in regard to her daughter's happiness and suspicious of the dissolute habits of her son-in-law, left her own home and came to establish herself with her daughter at Rugeley. 4 days after her entrance in Palmer's house, she died suddenly. The property of which she was in possession passed into the hands of Mrs. Palmer, and under the control of the husband. New stables were built at Rugeley, new horses purchased, new bets entered, new acquaintances made, and new debts contracted. The Jewish money lenders of London were appealed to, and money loaned at enormous rates. Meantime, 4 of his children died suddenly, at intervals of 1 or 2 years. Only one remained as heir to the fortune of the mother, which at her death was to pass to the child. Mr. William Palmer, as a measure of precaution, secured an insurance upon the life of Mrs. Palmer for $75,000. The physicians testified to her perfect good health, and the premium paid was not exorbitantly high, but was more than he, at that time, was able to pay, as he was so pressed for money that he drew a bill, which was actually discounted on the security of the policies, so that he, with criminal ingenuity, contrived to make the policies pay for themselves. A troublesome claim of £700, a debt of honor, was held against Palmer by one of his sporting friends named Mleigh. This gentleman visited Rugeley to collect the sum, was a guest of Palmer, fell sick at his house, was visited by an old physician, the family advisor of Palmer, was drugged, and died. The debt was canceled, and the old physician reported the case as one of cerebral fever. In a little time, perhaps after a year, Mrs. Palmer took a slight cold on a pleasure excursion to Liverpool. The old family physician and a deaf nurse attended her. The husband insisted upon active treatment. The poor lady lingered for a month and died. The pleasant old physician made out his certificate of the cause and time of her decease. It was signed by the nurse and accepted by the authorities of Rugeley, who all admired and flattered that game fellow, William Palmer, Esquire. The London life assurance companies paid their losses, and the surgeon Palmer was again afoot for new enterprises on the Derby. But he found occasion shortly to negotiate, through his Jew friends of London, for insurance upon the life of a brother, Walter Palmer, who had been addicted to drinking, who had been threatened with delirium tremens, but who, subject to the special guardianship of his brother William and of the old physician of the family, it was hoped and affirmed by competent examiners, would live for many years to come. The insurance was effected for the sum of £13,000. The surgeon Palmer employed a man to attend upon his brother and to supply regularly all his wants. Even his own inclination for the bottle was not forgotten by the new guardian. Walter Palmer resisted, however, the influences of gin until a visit from the brother, in the autumn of 1855, supplied some stronger stimulant, and the wretched drunkard died. Application was made to the London office for the payment of the amount insured, but refused. The application was not renewed. There were those who had seen Palmer on the turf who spoke suspiciously of this circumstance, but who should venture to accuse William Palmer, Esquire, of foul dealing? Did he not own one of the best studs in the country? Had he not been on terms of familiarity with Lord Bentinck? Was he not regular and prompt in his contributions to the parish church of Rugeley? Did not the rector dine with him from time to time, and admire his great horses, Strychnine and Chicken? Was he not become altogether an English country gentleman? At the Shrewsbury races in November 1855, appeared with Palmer a young man of about 28, named John Parsons Cook. Both had large stakes involved, but with different results. The Polestar, Cook's horse, won, by which Cook received £2,000. Chicken, Palmer's horse, was beaten, by which Palmer was utterly wrecked. He had taken immense bets, with the hope of winning enough to pay the suits on the £13,000 forged notes then pressing upon him. These bets turned against him, and exposure became imminent. But this was not the only difficulty. Palmer had borrowed largely of Cook, who, besides his late winnings, was possessed of a fortune of about £12,000. By fair or foul means, he had obtained what purported to be Cook's signature to notes to a very large amount. Cook's sudden death could not be other than advantageous to him, in the circumstances under which he was placed. It was then, according to the prosecution, that he took measures to bring this death about. Footnote: Wharton and Still's Medical Jurisprudence. On the 5th of November, Cook took lodgings at Rugeley, the town where Palmer lived. His life had been previously dissipated, and he had been suffering much from ulcerations in the throat, the result of venereal excesses. On the 14th of November, the day after the races, Cook and Palmer were drinking together at the inn at Shrewsbury, where, according to Palmer's statements at the time, Cook was more or less affected by liquor. Palmer, towards the end of the evening, was seen mixing some colorless liquid in the passage leading to his room, and shortly afterwards gave some brandy and water mixed by himself to Cook, who drank it, and immediately cried out that there was something in it, that it burned his throat dreadfully. Palmer immediately took the glass, drank what remained, and handed it to a third person to try, who found, however, nothing left. Cook was soon taken very sick, vomiting largely. He recovered, however, enough to be on the race course the next day. The day after, Friday the 15th, he arrived at Rugeley with Palmer. He continued unwell throughout that and the next day, Saturday, when Palmer gave him some coffee, after which he vomited. On Sunday, Palmer caused some broth to be made, which was given to Cook. This broth was tasted by the chambermaid at the inn, who was by it made very ill. On Saturday, Palmer sent for Mr. Bamford, a practitioner at Rugeley, to give his attendance to Cook, and on Monday he wrote to Mr. Jones, who practiced at Lutterworth, telling him that Cook was sick with a bilious attack, and asking his medical services also. Certain pills of an anti-bilious character were given by Mr. Bamford to Palmer, to be administered to Cook. After sending for Mr. Jones, Palmer went to London on business, and returned on the evening of the same day, Monday, to Rugeley. On his return, he went to a druggist, with whom he had not been in the habit of dealing, and bought 3 grains of strychnine. When he saw Cook, he administered to him pills which purported to have been those prescribed by Bamford. Cook had, during the day, been much better, and had been talking with his jockey and trainer. But an hour after he had taken the pills, the inn was roused by the violent ringing of his bell and by the screams, "Murder! Christ have mercy on my soul!" At once the servants gathered in his room, and he was found in extreme agony on his bed, beating around him with his hands, and in the highest muscular tension. His cry was that he would be suffocated. He was agonized with convulsions, and when a composing drink was given to him, he grit his teeth and snapped at the glass and spoon. His first call when the servants came in was to send for Palmer. Palmer came and remained with him until 6 o'clock the next morning. Between 11 and 12 on that day, Tuesday, Palmer went to another druggist and bought 6 grains of strychnine and a small amount of opium. At 3 o'clock arrived Mr. Jones, the physician from Lutterworth, who was a personal friend of Cook's, whom he found much better. That evening, the 2 physicians had a consultation with Palmer, Mr. Jones declaring that the symptoms were different from those described to him by Palmer. Mr. Bamford prepared some additional pills which were given by him to Palmer, who at night administered pills from the same box to Cook. Within an hour after taking the pills, Cook was attacked in the same way as on the previous evening. He was in violent spasms. His breathing was almost entirely suspended. His muscular system was strung to the highest tension, and he was so rigid that, when he cried to be lifted up in bed, this was found to be impossible. So great was this stiffness that, when lying with his face upward, his back arched inward, and only his head and heels touched the bed, they bearing his whole weight. He cried to be turned over on his side, which was done, when in a few moments he died quietly. Palmer, who was sent for immediately on the attack, arrived at once and remained until the death. 2 days afterwards, Mr. Stevens, Cook's stepfather, came to Rugeley to inquire into the circumstances. He found the body still unburied, and a certificate from Mr. Bamford was given him, to the effect that the death was by apoplexy. His suspicions were excited by his inability to find Cook's betting book, by a claim set up by Palmer against Cook's estate for £4,000, by the anxiety which Palmer showed to make it appear that Cook had lately squandered away all his available funds, and by his effort to have the body buried at the earliest moment. Mr. Stevens went at once to London and made arrangements for a post-mortem examination. This took place at Rugeley, in the presence of several medical men, Palmer being in attendance. No symptoms of disease were discovered, except the ulcers on the tongue, which have been already mentioned, and some white granules on the lower part of the spine. With some carelessness, the stomach and intestines were taken out and placed in a jar, and it was noticed first that while the operator was at work, he received a push, communicated apparently through Palmer, which produced some disarrangement, and second, that the jar was afterwards removed by Palmer towards the door, ostensibly for the purpose of greater convenience, and was then found with 2 cuts through the parchment, which had been placed over its mouth. It is clear, however, that its contents had not been tampered with, though it was in evidence that Palmer told the boy who was employed to drive Mr. Stevens and the jar to the station that he would give £10 to see the jar upset. Such was the evidence of the prosecution, though on cross-examination the witness who testified to the last point seemed to leave it uncertain whether it was Stevens or the jar that Palmer so much desired to see thus disposed of. The stomach and intestines were analyzed by Dr. Taylor, an eminent toxicologist of London. The result was that a little antimony was discovered, but no strychnine or prussic acid. Dr. Taylor and Dr. G. Owen Reeves certified accordingly, adding that it was now impossible to say whether any strychnine had or had not been given just before death. When Dr. Taylor, however, became acquainted with the symptoms, he changed his opinion, holding, as subsequently advised, that the death was produced by strychnine. So great was the local excitement that Parliament, at Lord Campbell's suggestion, passed a bill transferring the venue to the Metropolitan Court of the Old Bailey in London. The case came on for trial on May 14, 1856. The main strain of the trial was on the question whether the non-detection of strychnine in the remains was to be conclusive. Testimony, though not of the highest order, was adduced by the prisoner to prove that it was. On the other hand, the Crown produced very high authorities to show that strychnine acts by absorption into the blood, and thence it passes into the nervous system, that it exhibits itself peculiarly and distinctively by a violent, spasmodic convulsion and rigidity of the muscles, particularly those of the chest, that death is finally produced by suffocation, and that, as only the excess of poison beyond what is necessary to produce death remains in the stomach, no trace is to be found when only the minimum dose is given. That Palmer was acquainted with the way in which the poison acts was evident from the fact of a notebook of his being found in which the page was turned down at a point containing description of death by strychnine. From Lord Campbell's charge to the jury, we extract the following important passages. You have evidence of strychnia, having been procured by the prisoner on the Monday night before the symptoms of strychnia were exhibited by Cook, and by the evidence of Roberts, undenied and unquestioned, that on Tuesday 6 grains of strychnia were supplied to him. Supposing you should come to the conclusion that the symptoms of Cook were inconsistent with death by strychnia, if you think that his symptoms are accounted for by merely natural disease, of course the strychnia obtained by the prisoner on the Monday evening and the Tuesday morning would have no effect. But if you should think that the symptoms which Cook exhibited on the Monday and Tuesday nights are consistent with strychnia, then a case is made out on the part of the Crown. After the most anxious consideration, I can suggest no possible solution of the purchase of this strychnia. The learned counsel for the prisoner told us in his speech that there was nothing for which he would not account. The learned counsel did not favor us with the theory which he had formed in his own mind with respect to that strychnia. There is no evidence. There is no suggestion how it was applied, what became of it. That must not influence your verdict, unless you come to the conclusion that the symptoms of Cook were consistent with death by strychnia. If you come to that conclusion, I should shrink from my duty. I should be unworthy to sit here if I did not call your attention to the inference that, if Cook did die from strychnia, that strychnia was administered by the prisoner at the bar. It appeared that, in the middle of November, Palmer was involved in pecuniary difficulties of the most formidable nature, that Cook, the deceased, by winning a race, became master of at least £1,000. And there is evidence from which the inference may be drawn that the prisoner formed the design of appropriating that money to his own use, that he did appropriate the money to the payment of debts for which he alone was liable, and, if Cook had survived, the fraud must have been exposed. Upon the important question of whether Cook died from natural disease or from poison, we have the evidence of Sir B. Brodie, and of other most honorable and skilful men, who say that, in their opinion, he did not die from natural disease, as they know of no natural disease which will account for the symptoms attending his death. And many say that they believe the symptoms exhibited by him were the symptoms of strychnine. All we know respecting strychnine not being in the body is that in that part of the body, which was analyzed by Dr. Taylor and Dr. Rees, they found none. His lordship then drew attention to the evidence that the deceased had been tampered with by having something put into his brandy and water, broth, etc. The absence of any satisfactory explanation of his having bought strychnine, and the behavior of the prisoner after Cook's death, he said. The answer consists of two parts. First, the medical evidence, and secondly, the evidence as to facts. With regard to the medical witnesses on the part of the prisoner, I must observe that, although there were amongst them gentlemen of high honor, consummate integrity, and profound scientific knowledge, who came here with a sincere wish to speak the truth, there were also gentlemen whose object was to procure an acquittal for the prisoner. His lordship next read Mr. Harapath's evidence, and at the close of it remarked, "Mr. Harapath is a very distinguished chemist, and no doubt says what he sincerely thinks. He is of opinion that where there has been death by strychnia, strychnia ought to be discovered. But he seems to have intimated an opinion that the deceased in this very case died by strychnia, and Dr. Taylor did not use proper means to discover it. If you are of the opinion that the symptoms were consistent with death from strychnia, you should consider the evidence given in the case, to see whether strychnia had been administered by the prisoner at the bar. These are the questions I again put to you. If you come to the conclusion that these symptoms were consistent with death from strychnia, do you believe that death actually resulted from the administration of strychnia, and that strychnia was administered by the prisoner at the bar? Do not find a verdict of guilty unless you believe that the strychnia was administered by the prisoner at the bar. But if you believe that, it is your duty to God and man to find the prisoner guilty." At the conclusion of this address from the Lord Chief Justice, the jury retired from the court. They re-entered their box after an absence of 1 hour and 17 minutes, having found a verdict of guilty. The prisoner was subsequently executed, and, though the question was greatly agitated, both medical and legal opinion have settled down into the belief that the conviction was right. The body of Mrs. Ann Palmer, the wife of the prisoner, had been lying 15 months in the grave under a professional burial certificate of death from bilious cholera, when the sudden death of Cook and the detection of antimony in his body led to the exhumation of the body of this lady. It was found, says Dr. Taylor, who conducted the autopsy and examination, that she died from the effects of antimony, which was detected in all parts of the body. When the history of the illness which preceded death was gone into, it was found that the symptoms were consistent with the effects of tartarized antimony, but not with those of bilious cholera or of any other disease. Antimony had not been prescribed for the deceased during her illness, and it was therefore clear that it must have been administered to her by someone up to within a short period of her death. Footnote: Taylor's Medical Jurisprudence. Within a little more than 6 months after effecting the insurances on her life, the wife died from poison under his immediate superintendence. On her death, the large sums insured were claimed by Palmer and were paid to him by the companies. Although there was at the time some suspicion, there was no inquest or inspection, and the body was hastily buried. It seems that the general respectability of Palmer, his social and professional position, together with the 2 medical certificates of the cause of the wife's death, checked any intention which might have existed on the part of the companies to resist the payment of the policies. It was ascertained that the death of Walter Palmer, the brother of William, was probably caused by prussic acid. Walter had died suddenly in the presence of his brother William and another man of doubtful character, and it was proved that William had, an hour or 2 before Walter's death, purchased at a druggist's a bottle of prussic acid. At the inquest held on the body of Walter, it was shown that Palmer had directed the man with whom he had placed the brother, after the insurance on his life, to give him as much brandy as he would take, and to keep a quantity of the spirit by his bedside. The brother was a drunkard, but this mode of destroying life was too slow for Palmer's purpose. When the necessity for money increased, he reverted to the potent poison above mentioned and suggested that death had been caused by apoplexy. Palmer subsequently tried, but ineffectually, to insure, to the extent of £25,000, the life of his groom, George Bates, described by him in his application for the insurance as a gentleman of independent means. And he advised a man named Cheshire, the postmaster of Rugeley, also to effect life insurance to the extent of £5,000, and assign the policies to him. But for the revelation of facts connected with the death of Cook, these 2 persons, on whose heads a heavy life insurance value had thus been set, would have been the next victims. End of section 24.
Section 25 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an Authentic Record of Remarkable Cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 2. The Goss-Udderzook Tragedy, Part 1. A brief announcement appeared in the local columns of a Baltimore newspaper, published on the morning of February 3, 1872, stating that W.S. Goss, residing at number 314 North Utah Street, had been burned to death the previous evening in a house on the York Road about 4 miles out. The fire was supposed to have been caused by an explosion of some chemicals with which he was experimenting. The building in which the accident occurred was entirely consumed. The charred remains were taken out of the burning building by Mr. Udderzook, a brother-in-law, aided by some neighbors. 4 days later, the attention of several life insurance companies was called to the incident thus briefly stated, through notifications served upon them in the following form. Baltimore, February 7, 1872. This is to notify of the death of W.S. Goss, which occurred in the following manner. He was in the habit of going to a place in the country where he was engaged in making samples of a substitute for India rubber. On the evening of his death he went out as usual, in company with his brother-in-law, Mr. William Udderzook, and when night came on he lit his lamp, one which he has used for some time. The lamp burned for a while, then suddenly went out. He lit it several times again, but it refused to burn. Mr. Yu told him he would go to a neighbor's house and get another lamp, and while he was gone the lamp exploded and set fire to the house, and W.S.G. was burned to death. The coroner held an inquest and rendered the following verdict: that W.S. Goss came to his death by the explosion of an oil lamp. A.C. Goss, brother of W.S. Goss. The insurance companies directly interested in this matter were the underwriters of the following policies, all of which were upon the life of Winfield Scott Goss, for the benefit of his wife, Eliza Waters Goss. First, an ordinary life policy for $5,000, written by the Mutual Life Insurance Company of New York, dated May 21, 1868. Second, a similar policy for $5,000 in the Continental Life Insurance Company of New York, dated May 26, 1871. Third, an accident policy in the sum of $10,000 in the Travelers Insurance Company of Hartford, dated October 18, 1871. Fourth, a life policy for the sum of $5,000 in the Knickerbocker Life Insurance Company of New York, dated January 26, 1872. The insurance companies regarded the circumstances of the case with suspicion, and they at once made inquiry into the facts. At the commencement of the investigation, there was no incident or fact which of itself was conclusive of fraud, but there were minor tokens which, grouped together or viewed in their relations to one another, led to conviction that the mystery surrounding the fire needed explanation. It seemed highly improbable that a strong, athletic man, such as Goss was known to be, should be overpowered in the manner described, and unable to make his escape from the burning building. The plausible stories of Udderzook, and of the brother A.C. Goss, tend to convey the impression that they knew too much. At an inquest held by the coroner upon the next day following the fire, and again at an interview with the insurance agents soon afterwards, Udderzook testified that he was a brother-in-law of Goss, they having married sisters, and he resided at No. 167 Conway Street, Baltimore, where he had lived during the last 6 years; that on Friday afternoon, the 2nd day of February, 1872, he met Goss by appointment between Biddle and Howard Streets in the city of Baltimore, when they at once proceeded on the York Road to a cottage on the premises of a Mr. Lowndes, where Goss had been experimenting in the manufacture of some substance to be used as a substitute for India rubber. They walked part of the way and then rode in a Waverley Horse Railway car to the terminus of the line. This brought them to within 3/4 of a mile from the cottage. On leaving the car they went into a store, where they procured a gallon of kerosene oil, carrying the oil in a wicker-covered demijohn, which they had left at the store some 3 days previously. Goss also purchased a bottle of whiskey. They then walked to the residence of one Engel, where they borrowed an axe, and thence they both proceeded directly to the cottage, where they built a fire in a stove, which was in one of its rooms. This was about 3:30 o'clock in the afternoon. From that time until dark, Goss visited the cellar of the cottage some 3 or 4 times. About dusk, Goss filled a coal oil lamp in Udderzook's presence, using the oil from the demijohn brought there that afternoon. The lamp would hold about a quart of oil, and was filled full. At about 6 o'clock, he, Udderzook, went to Engel's house and returned the axe which he had borrowed, and remained there at supper with the Engel family. After supper, he and Gottlieb Engel went to the cottage, where Goss, Engel, and himself all drank whiskey from the bottle which Goss had obtained that afternoon. About an hour afterwards, the light of the lamp went out. One of them lighted a piece of candle and attempted to relight the lamp with the candle blaze, but was unsuccessful. Engel proposed to cut off a portion of the wick, and Udderzook offered to get a new wick from the store. Goss suggested that a lamp be obtained from Engel's house, whereupon Udderzook and Engel left the cottage for that purpose. Arriving at Engel's house, they remained there from 15 to 20 minutes, when Udderzook, starting to return, discovered that the cottage was on fire. Together with Gottlieb Engel and Louis Engel, he ran to the scene of the fire as fast as possible, and on arrival found the flames bursting from the windows and the roof. He made no attempt to enter the house, nor to his knowledge did anyone else attempt an entrance, on account of the fierceness of the flames. After he had been at the fire about half an hour, he sent Louis Engel to Goss's residence, No. 314 Utah Street, to inform the family of the fire and of his fears that Goss was burned to death. About an hour after his arrival at the fire, he expressed his fears to Mr. Lowndes that Goss was in the burning building. The roof and a portion of the sides of the building had then fallen in. An effort was at once made by the spectators present to ascertain if Goss had been burned with the building, which led to the discovery of a human body so burned as to be past recognition or identification. He, Udderzook, had visited every room in the cottage during the afternoon of that day, and he knew there was no one in the house during that time except himself and Goss, and no one entered the house afterwards except Gottlieb Engel, up to the time when he and Engel went for a lamp. He also knew that there was no dead body in the house, and that no dead body had been brought to the house that day or evening or at any other time. He had no knowledge which led him to believe the body found in the ruins was the body of any other person than Winfield S. Goss. In giving his story of the occurrence, Udderzook manifested a willingness to mention every detail known to him, and was ready to account for and explain apparent inconsistencies. At no time did he betray an uneasiness under his close cross-questioning by the insurance men, before whom he voluntarily presented himself for the purpose. The main features of his account of the fire were corroborated by other and disinterested parties. The Engel family were visited and interrogated. They lived about 300 yards distant from the cottage, and had known Goss and Udderzook during the preceding 6 months. They were evidently an honest, industrious German family, who would not knowingly be a party to any deception. It is certain that they were credulous, and did not doubt what seemed to them, from the evidence of their senses, that Goss was burned up at the cottage fire. Gottlieb Engel was a simple-minded, hard-working young man of 23 years. He saw Goss and Udderzook on the afternoon of February 2nd, and loaned Udderzook the axe. He said that Goss asked him to come to the cottage in the evening, after supper, as Udderzook was going back to the city after a while, and Goss would like to have him there for company. While eating his supper, Udderzook came in and returned the borrowed axe. Mrs. Engel, Gottlieb's mother, inquired where Goss was, and Udderzook replied that he was at the cottage. Udderzook further said to them that Goss wanted him to stay with the Engel family about an hour and a half, so Mrs. Engel invited him to a seat at their supper table. After supper, Udderzook and Gottlieb went to the cottage. On arriving there, they were admitted by Goss, who unlocked the door from the inside. They went into the southeast room of the cottage, where there was a fire in the stove. Gottlieb remembered seeing a coal oil lamp burning in an adjoining room, where there was also a workbench. Goss brought the lamp and put it on the floor of the room where they were. Gottlieb went into the room where the workbench was, but into no other, except the room he first entered. While Gottlieb was there, Goss went several times into a third room, alone, closing the door after him each time. Every time he went to that room he took the lamp with him. The last time he came out he remarked, "I wish I had my fortune." Goss went to the cellar once while Gottlieb was at the cottage. The entrance to the cellar was on the outside of the house. At one time, while Goss was entering the room where Gottlieb and Udderzook were, the light of the lamp which he was carrying went out. Goss then called to Udderzook to bring a light, and Udderzook took him a lighted paper, but did not light the lamp with it. Udderzook then lighted a piece of candle, and with it attempted to light the lamp, but the tallow ran upon the lamp wick, which prevented its lighting. Gottlieb offered to remedy the trouble by changing the ends of the wick, but Goss objected. Udderzook proposed to get a new wick from the store, but Goss said a lamp had better be obtained from Engel's house, when Gottlieb offered to go and get one. He at the same time invited Goss to go with him and get his supper. Goss refused to go, but insisted on Udderzook going with him. Gottlieb and Udderzook then went back to the Engel house. After they had been in the house about 10 minutes, Mrs. Engel said to Udderzook, "You had better go now," she thinking Goss was left alone in the dark. But Udderzook delayed going, and after a while went into the kitchen for a drink of water. Gottlieb was close behind him, and noticed the reflection of the light of the fire. They stepped out upon the porch, when Gottlieb said it was the cottage on fire. Udderzook replied, "Scott has illuminated." Gottlieb at once ran as fast as he could to the fire, and outran Udderzook, who caught up with him after he had slackened his pace. While at the fire, Udderzook said to Gottlieb, "I think Scott is in the house," when Gottlieb replied that he had probably run out of the building. At the time, Gottlieb did not believe that Goss was in the building, and he returned home before the body was recovered. Udderzook came to the Engel house that evening and told the family that Goss had been burned to death and his body found. Upon interrogating A. Campbell Goss, the brother of W.S. Goss, as to his whereabouts during the night of the fire, he manifested extreme caution, and was guarded in his replies. He preferred to submit his written statement covering the time in question, and he did so as follows, the paper being subscribed and sworn to under date of February 26, 1872. On Friday at about noon, near 1 o'clock of the 2nd of February, 1872, my brother, W.S. Goss, and I were with each other, and we parted at about that time on the corner of Fayette and St. Paul streets. He told me he was going to his country place, where he was at work making samples and specimens of his substitute for India rubber. I asked him to let me go out with him, but he requested me to remain in the city and go see Mr. Clark, a portrait painter in Mulberry Street, and collect some money Clark owed him for frames. I promised and did so. This is the last time I saw Scott. Before we parted, he told me to remain at my boarding house, No. 41 North Calvert Street, the next morning, and he would call for me, and we were going to see a Washville friend, James Thompson, at Locust Point. He left me to go home to his dinner. I went to mine at my boarding house. Then in the afternoon went to see Clark. Was at supper as usual. After tea, was in my room about an hour writing a letter home. Finished that, spent the evening with my landlady's family as I often did. Retired to my room, went to bed, was there all night, and the next morning was waiting for my brother as promised, and while waiting received a letter from Mr. Way, a friend of Scott's, telling me a great misfortune had happened to my family. I immediately went to his house on Utah Street, and there learned of my brother's death. I went immediately to where this occurred, and found it was too true. About a week after this, I went out with a friend to the wreck, and we looked a while for his watch, keys, etc., but did not find them. A day or two afterwards, I went and made a thorougher search, and found his watch, chain, and keys in the debris. A. C. Goss. This statement of A. C. Goss was subjected to a thorough test as to its truthfulness, and was found to be false in several material points. The lady who kept the boarding house at No. 41 Calvert Street had a distinct recollection of the night of the fire, and of the fact that A.C. Goss was not at supper at her house that evening. After tea, she saw him in her parlor. It was then past 9 o'clock. The next morning after the fire, the burning of A.C. Goss's brother was the subject of conversation at her house, and the fact that Mr. Goss was not home to supper was noticed and spoken of at the time. The daughter of this landlady also had a precise recollection upon that point. She was at home, in the parlor, when Mr. Goss came in at about 9:30 o'clock that evening. He had made an engagement on that Friday morning to spend the evening with her. Instead of keeping it, he left a note for her, saying that he was obliged to meet his brother and would not be back until rather late, and was sorry to be obliged to break the engagement. That he was not at home to supper that evening was a fact observed, spoken of at the time, and explained by the young lady upon the information given her in the note written by Campbell Goss. The proprietor of a livery stable also had a clear remembrance of the night of the fire. He was applied to that Friday, soon after dinner, by a man who wished to engage a horse and buggy to use that evening. The man said he would call for the horse about 7 o'clock. He wanted to drive a short distance out into the country. The livery proprietor did not know the person at the time, but a few days afterwards he saw and identified A.C. Goss as the same person. When A.C. Goss came to the stable, his name and residence were asked, and he gave his name as A.C. Arden, No. 314 North Utah Street, which name and address were noted down at the time. It afterwards appeared that Arden was the name of the father-in-law of W.S. Goss, and the street and number given was his residence at that time. He came for the horse about dusk, and did not return until a little past 9 o'clock. On his return he gave a pair of buckskin gloves to a hostler at the stable. Of the identity of A.C. Goss with the party who hired the horse and buggy that evening, the livery proprietor had not a shadow of doubt. When he first thus identified A.C. Goss, he spoke of the gloves which his hostler had said were given to him, and which, on the contrary, it was supposed might have been left in the buggy by accident. But Goss denied all knowledge of the matter. At this stage of the investigation, it became quite reasonable to infer that A.C. Goss drove out to some point near the cottage, where he met his brother W.S. Goss by appointment, and drove him to a railway passenger station. The time occupied, considering the distances and all the facts, fitted exactly his thus going from and returning to his boarding-house. The finding of certain personal effects in the debris, at the place where the body lay, was regarded with suspicion when it was ascertained that the place previously had been searched, carefully and thoroughly, for these very articles. Early upon the morning subsequent to the fire, and before the spot had been visited by any other person, a Mr. J.C. Smith searched for the watch and ring which he had seen Mr. Goss wear, but failed to find them. This Mr. Smith was a junk dealer, and had had much experience in searching for lost or hidden articles of value. He knew Goss personally, and he purposely went to search among the embers for the recovery of these or any other articles which Goss might have had upon his person. It began to be whispered about as very strange that no trace of such articles could be discovered, when Mr. A.C. Goss, more than a week afterwards, "made a thorougher search," and found the watch, chain, and keys. There were other noticeable points in the early investigations of this case, of which we need only mention two. First, it was ascertained that Goss had drawn from the bank a small balance due him on his deposit therein, and thus closed his account the day before the fire. Secondly, it was noticed that letters testamentary had been taken by Mrs. Eliza W. Goss on the 6th day of March, 1872, indicating that W.S. Goss had executed a last will and testament prior to his cremation. The document was found on file in the office of the Register of Wills for Baltimore City. In it, Goss apologetically says, quote, "Being desirous to settle my worldly affairs, and thereby be the better prepared to leave this world, when it shall please God to call me hence," end quote, he therefore does make and publish his last will. He directs his body to be decently buried at the discretion of his executrix, and devises all his estate, quote, "real, personal, and mixed," end quote, to his wife, whom he constitutes the sole executrix of his will. It could not be learned that the testator left any estate which might be denominated real or personal, nor anything whatsoever, save the mixed mystery of his taking off. While all these disclosures tended to strengthen the suspicion of fraud, there was absolutely nothing in the way of direct demonstration. In the meantime, the usual proof and claim papers had been submitted to the insurance companies concerned, and the claims were rapidly maturing. Mrs. Goss at once placed her policies in the hands of able attorneys, who wrote each company as follows, quote, "Our instructions are to act promptly in the presentation of the claim, and on the institution of a suit, if the matter is to be taken into the courts. Mrs. Goss would decline any offer of less than the whole amount of the policy." End quote. The companies refused to pay at maturity, and suits were promptly instituted under each policy. End of section 25. Section 26 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 3. The Goss-Udderzook Tragedy, Part 2. Time wore on with the development of nothing more satisfactory for the defense than has been mentioned. It was therefore desirable to learn what light, if any, could be thrown upon the matter by an exhumation and examination of the charred remains which had been buried as those of Goss. At the inquest which had been held upon the body, it was observed that although the extremities were more or less consumed, the head was entire, and it was believed the bones of the skull, including the teeth, were uninjured. Any peculiarity of the teeth, whether natural or arising from mechanical dentistry, might at once determine the question of identity of these remains. An effort was made to obtain a description of any such peculiarity, if it existed, for the purpose indicated. In pursuance of this information, every dentist in Baltimore was interrogated, but with only negative results. So far as could be ascertained, Goss was known to have had unusually good teeth, which were conspicuous in his ordinary conversation, and were fully exposed when he laughed. From no source could it be learned that he had had occasion to employ a dentist. Mrs. Goss had testified before the coroner to certain facts touching the size and general figure of her husband's person, which facts had reference to identity with the burned body, and therefore a verbal request was made of her, through her spiritual adviser, the Reverend Dr. Fuller of Baltimore, that she would make a more elaborate description, especially of his teeth, and grant permission for the exhumation and examination. This request was made through Dr. Fuller because of his proffered assistance, as he expressed it, quote, "to get at the truth of the matter." The result of Dr. Fuller's efforts to arrive at the truth may be deduced from the following note, sent by him as the conclusion of his labors in that direction. Baltimore, January 3, 1873. My dear Sir, I have seen Mrs. Goss. She says that, knowing it was her husband and grieving over her sorrow, she yet summoned resolution and believes she testifies to all she knew, and that others did the same. She has been so shocked at the suspicion in the case cast upon the memory of her husband that she has resolved to commit the matter to the God of the widow and the afflicted, and to speak no more on a subject so abhorrent to all her feelings. Very respectfully, dear Sir, R. Fuller. Mrs. Goss had determined that an exhumation should not be made, and had obviously silenced her officious pastor's inquiry into the validity of her claim to the insurance. But this did not arrest or discourage an effort looking to the thorough examination of the charred body over which Dr. Fuller had held solemn burial service. This purpose led to the following correspondence, which sufficiently explains itself. Baltimore, January 22nd, 1873. To Milton Whitney and Henry V. D. Johns, Esquires, Counselors, etc. Gentlemen, the undersigned, counsel respectively of the Mutual Life Insurance Company, the Knickerbocker Life Insurance Company, and the Travelers Insurance Company, defendants in suits brought by you in behalf of Mrs. Eliza W. Goss, to recover upon policies issued by said companies upon the life of Winfield S. Goss, respectfully ask your attention to the following suggestions. As you are by this time probably aware, the defense relied upon in these suits is that proofs of loss required by the terms of the policies have not been furnished to the satisfaction of the several companies, and are not, in fact, such as we can advise our clients will warrant them in paying the large amounts involved. The extraordinary circumstances under which it is claimed the insured met his death, you must in fairness admit, called for unusual care and particularity in proving the loss, and takes the case out of the ordinary class as to which there can be no reasonable doubt of loss. The proofs furnished are on their face plainly insufficient. They are not such as are required by the policies, and proper to be given, even in cases of death free from unusual circumstances. And these objections on the part of the companies that your proofs were insufficient were brought to your notice prior to bringing suit. We wish most plainly to give you to understand that our companies resist this claim with no captious spirit and with no speculative object, and that they only require such proofs as are reasonable and such as they think they have a right to expect the plaintiff to be able to produce. If she can give reasonably conclusive evidence that the body buried in February last as that of Winfield S. Goss, the insured, was really his, we are authorized to assure you that her claims will be admitted and paid at once. It is more agreeable for the companies to pay than to contest, and they are determined to afford you every opportunity to remove their doubts and to meet their requirements to the most ample manner the case will admit. It is obvious that the most decisive and satisfactory proof on this point is to be derived from the body itself buried as that of Goss, provided it be in such a state as to admit of identification, and we can hardly suppose that it existed in such a condition as to authorize the finding of the coroner's jury and to warrant the drawing of the affidavits presented as proofs of death, and yet that it was so far disfigured and consumed as to afford no points of recognition. If the body was that of Winfield S. Goss, there must have been, and must still be, some physical marks, characteristics, or peculiarities known to Mrs. Goss or to other relatives or friends, by which it can be recognized. That every person has such marks, recognizable by someone, can hardly be doubted, and we believe such exist in this case, which may be found if carefully sought for, and which will go far, if not prove quite effectual, to decide this question. For the purpose of enabling you to meet these requirements of proof, we are authorized to make the following propositions. First, Mrs. Goss is to furnish us with an accurate written description of Winfield S. Goss, to be made specific upon these points: height, average weight, shape or figure, age in February last, size and shape of head and skull, as far as can be stated, to be verified by the production of a hat once worn by him, if it can be had, description of his teeth, their quality and appearance, whether wholly or partially sound or defective, natural or artificial, whether he had any peculiar teeth, had lost any, and how many and what teeth, Had any teeth broken, and how many and what teeth, and how broken? Had any teeth filled or otherwise operated upon by a dentist? And how, where, and when operated upon, and by what dentist? The color, quantity, and quality of his hair, beard, or whiskers? In what style worn in February last? Any peculiarity about his nails or joints? Whether he had any and what fracture or other wound of a serious or permanent nature, and covering such other points as would be presumed to lead to an identification of his person. Second, such statement, as full as Mrs. Goss is enabled to make it and signed by her, being first furnished us, we propose that she shall then permit the body in question to be exhumed and subjected to a careful, exhaustive, scientific examination by medical or other experts to be selected by counsel on each side. The examination is to be attended by counsel, and all expenses are to be borne by the insurance companies represented by us. Should such an examination be had, it is probable that one of three things would result. Either, first, the remains would appear to be those of Winfield S. Goss, the insured, in which event we should feel bound to advise our companies it was useless further to defend these suits. Or, second, the remains would appear to be not those of Winfield S. Goss, the insured, in which event we might fairly expect you to advise your client her case was hopeless. Or, third, the remains would be incapable of identification, and nothing would appear from them to the advantage or disadvantage of either party. We are, gentlemen, respectfully yours, etc., etc., Edward Otis Hinckley, attorney for the Mutual Life Insurance Company, Marshall and Fisher, attorneys for Knickerbocker Life Insurance Company, A. Sterling, Jr. and George H. Chandler, attorneys for Travelers Insurance Company. Baltimore, January 25, 1873. Gentlemen, in reply to your communication of the 22nd instant, we furnish evidence of our acquiescence in your first proposition by enclosing herewith a written description of the late Winfield S. Goss, signed by Mrs. Eliza W. Goss, following the order of your suggestions and as specific as it was in her power to make it. To your second proposition, Mrs. Goss also sorrowingly but promptly signifies her acquiescence, if the companies you represent desire such steps taken. At the exhumation and examination of the remains of her husband, she will be represented by 2 medical gentlemen, by her counsel, and by a few of those who superintended the interment, upon whom she can rely to identify the body as that she committed to the ground, preliminary to the scientific examination which you suggest should now be made. Please accept Mrs. Goss's thanks for the assurance you give her in your communication of the 22nd, that the 2 propositions, and the suggestions therein contained, are made by your respective companies in candor and good faith, and in no speculative or captious intendment, and that she may at last realize the truth of those arguments in favor of the value and necessity of life insurance, and of the special advantages of your corporations, which their agents, during an interval of many years, so urgently presented to her husband. As far as the payment of the amounts due upon these policies is concerned, it is a mere business matter, and should be dealt with as such. But, in view of the imputations cast upon the memory of the deceased, and upon the characters of the living, and the invasion of the most sensitive relations of domestic life and into the very privacies of the grave itself, which this defense involves, we are glad to know that now, in your hands, the matter will be more mercifully conducted than it has been heretofore. The necessity and propriety of such consideration was made apparent today to ourselves, as we were given an account of the severity of the ordeal through which this lady has passed. Its first scene was upon the occasion of the bringing back of the body of her husband to the privacy of his house. We are informed that after giving sufficient searching scrutiny for an instant, hoping it should not be him, the fact of his identity, in her mind, was evidenced by her throwing herself upon the poor, charred form and clinging to it until removed by the strong arms of others, and that shortly after this pitiful reunion, the detectives sent by the defendants were at the house to see them. Thanking you for the relief given by your letter, and with the request that you will name an early day for the proposed examination, we are, with great respect, very truly yours, Whitney and Johns, attorneys for Eliza W. Goss. Baltimore, January 25, 1873. I make and sign the following statement in response to the request contained in a letter dated January 22, 1873, addressed by the counsel of 3 of the insurance companies against whom I have claims, to my counsel, Messrs. Whitney and Johns. Winfield S. Goss, my husband, was about 5 feet 8 inches in height, and would have weighed, at the time of his death, I should think, 165 pounds. He was of full figure, broad, deep chest, stood very erect, short, full neck. Was, to the best of my recollection, 36 years of age on the 4th of November, 1871. He had a broad, intelligent forehead, resembling in general outline that of his brother A.C. Goss. He wore about 7 or 7 1/4 size hat. His hat last purchased was destroyed at the time of his death, I believe burned up. I have an old felt hat once used by him, and will produce this at the time of the proposed exhumation. I have a velvet vest once worn by him, though this was too small for him and had been laid aside some time previous to his death. This shall be also produced. I gave away in charity most of his clothes after his death, most of them to a poor man who was injured at a sawmill. Owing to the circumstance of his having usually worn a mustache long enough to partially conceal his teeth, I am not able to describe them very accurately. He wore no artificial teeth to my knowledge, never complained of pain or inconvenience from decayed teeth, and I do not remember his requiring the services of a dentist during the time we lived together. I should call his front teeth quite regular. His hair was dark brown. In earlier years it was curly. About the time of his death he wore it trimmed closer than formerly, and it was not so curly. He would brush his hair and then pass his fingers through it, wearing it lightened up, and very much in the style in which his brother, A.C. Goss, now wears his hair. I preserved for a time a small piece of hair cut from the back of his head at the time of his preparation for burial, supposed to have been taken from the place on which his head rested. But it must have been touched by the fire and soon fell to powder. Can remember no singularities of nails or joints. His nails were regular. His hands were well formed and small in proportion to his size. My impression is I have a glove once worn by him, and if so, I will produce it with his clothes above referred to. He had neither fracture nor wound to my knowledge. I would state also, as it may throw additional light upon the description sought, that my husband and Mr. J.W. Langley, the gentleman connected with the Continental Life Insurance Company, were photographed together some months before his death, and that I will endeavor to produce also one of the pictures. The photographs were taken by Mr. Bachrach, an artist whose place of business is on the corner of Lexington and Utah Streets. I have recently had a copy of my husband's likeness taken from the negative in his possession, to send to the parent of my husband, to his mother. Eliza W. Goss. Upon receipt of the statement signed by Mrs. Goss, arrangements were at once made for the purpose indicated by the foregoing correspondence. Professor F.T. Miles, M.D., and R. Wysong, M.D., were selected by the counsel of Mrs. Goss to be present and assist in the examination. Professor E. Lloyd Howard, M.D., and Professor F.I.S. Gorgeous, M.D., were selected to represent the insurance companies. The last named, being an eminent dentist, was specifically qualified for this work. The necessary preparations being made, The exhumation was conducted in presence of counsel representing all parties in interest, the medical gentleman already named, and the consulting surgeon of one of the insurance companies. A.C. Goss and William E. Udderzook also were present, and both were closely observant spectators of the proceedings. A superficial inspection of the remains was made at the graveside, and the coffin with its contents was then taken away for a more critical examination. A.C. Goss objected to such removal, and endeavored to have no examination made, save such as could be made on the ground. On finding that the physicians could not and would not conduct their work in such a place, he and the legal adviser of Mrs. Goss gave their reluctant consent to a removal of the remains. The following is a copy of the report submitted by the examining surgeons. The undersigned, appointed to examine certain remains interred in Baltimore Cemetery, met by agreement in the cemetery on the afternoon of Monday, February 10, 1873. The grave was in soft, clayey soil, about 5 feet deep. On being opened, the coffin was found enclosed in a wooden box, both the box and coffin in a good state of preservation, and both filled with water. On removing the lid of the coffin, which bore a plate marked W.S. Goss, died February 2, 1872, in the 37th year of his age, the charred remains of a corpse were disclosed, wrapped in a white cloth. After a superficial inspection, the coffin was closed and placed in a wagon to be removed to the city. On the following day, February 11th, the undersigned met at the College of Physicians and Surgeons, and proceeded to a careful examination of the remains. The coffin was again opened and showed remains to be in the same condition as on previous day. A complete examination revealed the following facts. The soft tissues of the body were almost entirely destroyed, apparently by fire. Those not so destroyed were converted into adipocere and afforded no indications for determining any points of interest or importance. There were found lying to the back of the head portions of the scalp, entirely separated from the skull, covered with hair about 1 inch in length. The proper color of the hair could not be well determined, as it might have been stained by the fluid in which it lay. It presented a dark, almost black appearance. The skull was entire, except portions of the maxillary bones, to be afterwards more fully described. The skeleton is here examined in detail, and a minute description given of each and every bone which escaped destruction by fire. The skull was of full size, measuring 22 inches in circumference, around the forehead and occipital protuberance, round, and well formed. The chest was deep and capacious. The bones of the trunk and limbs were thick, with large articular extremities, and strongly marked at the points of muscular attachment. The bones presented no indications of disease, fracture, or other injury, other than those caused by burning as specified above. The teeth were defective to the extent shown in the detailed statement which is appended to this report. From a careful and critical examination of the remains, the undersigned feel fully authorized in forming the following conclusions. First, the remains were those of a male. Second, he was not a Negro. Third, he was between the ages of 25 and 50 years. Fourth, he was of fair average height, of stout build, and of great muscular strength. Fifth, it is impossible to determine whether the burning was the cause of death or was post-mortem. F.T. Miles, M.D., R. Wysong, M.D., E. Lloyd Howard, M.D., F.I.S. Gorgeous, M.D. Baltimore, February 13, 1873. Condition of maxillary or jaw bones. Superior maxillary, perfect except margin of alveolar process. Inferior maxillary, a portion of the external surface of body of the bone below the alveolar process and to the right of the median line, including the right mental foramen, destroyed for a space of 2½ inches long and 1 inch broad or wide, the bone otherwise perfect. Number of teeth remaining in upper jaw, 2. Number of teeth remaining in lower jaw, including one root of tooth, 7. Condition of the 2 teeth in upper jaw. Superior right second bicuspid. A superficial carious cavity on posterior proximal surface. Cusps on grinding surface worn away by mechanical abrasion, but not so much as to wholly obliterate the natural depressions on this surface. Superior right third molar, perfectly sound. Condition of the 7 teeth in lower jaw. Root of inferior right central incisor. The crown evidently destroyed by caries to a point below free margin of the gum before death. Inferior right lateral incisor, perfectly sound. Inferior right canine, sound. Angle worn away by mechanical abrasion. Inferior left central incisor. Various cavities on both proximal surfaces which communicated. Inferior left canine. Carious cavity on the anterior proximal surface. Inferior left second bicuspid. Small carious cavity on the anterior proximal surface. Inferior left third molar. Large carious cavity on the buccal surface near neck. Superficial cavity on grinding surface. Grinding surface worn by mechanical abrasion so as to almost obliterate the natural depressions on the surface. Form of irregularity of inferior front teeth. Proximal surfaces of the inferior right lateral incisor and inferior left central incisor approach near together at the cutting edges, caused by the loss of the crown on the right central incisor, the root of this latter tooth remaining in the alveolar cavity. As a result of this examination, the insurance companies were advised that it would be impossible to reconcile the dissimilitude between the diseased jaws and mouth of this almost toothless corpse and the mouth of W.S. Goss as described in the statement signed by his wife. That statement declares he had, quote, never complained of pain or inconvenience from decayed teeth, and I do not remember his requiring the services of a dentist during the time we lived together. I should call his front teeth quite regular. End quote. As Mrs. Goss had been married to W.S. Goss some 14 years, during which time they had lived together, it is fair to presume she necessarily would have heard complaints of pain and inconvenience from such badly decayed teeth and jaws, that she would have remembered the required services of the dentist who had extracted so many of these teeth, and that she would not have called such front teeth, quote, quite regular, end quote. End of section 26. Section 27 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, An Authentic Record of Remarkable Cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 4, The Goss-Udderzook Tragedy, Part 3. 2. The suits, which originally had been instituted in the Court of Common Pleas at Baltimore, were afterwards transferred, by the defendants, to the Circuit Court of the United States, where they were entered in September 1872. The action against the Mutual Life Company preceded the other insurance suits, as entered upon the calendar, and was reached for trial on May 27, 1873. This being regarded as a test case, the defense was conducted by counsel of the several insurance companies interested, all of whom were members of the Baltimore Bar. In his opening statement, Mr. Johns, counsel for the plaintiff, said, quote, "This suit is between Mrs. Eliza W. Goss and the Mutual Life Insurance Company. But you will soon find, gentlemen of the jury, that though technically this case is between Eliza W. Goss and the Mutual Life Company, that this is in fact that single plaintiff contending with no less than a combination of 4 powerful insurance companies. We will adduce evidence which will enable you to perceive, While these companies solicited Mr. Goss to insure for the benefit of his wife, they acted one by one singly. But when his body was cold, and it was necessary for his wife, his widow, to ask that these insurance companies should keep their promises, that while they acted singly as they solicited his confidence, when it was necessary to meet the widow, they present the solid combination of companies, with all the powerful agencies behind them, which their moneys, power, and wealth enable them to bring into this court. Though the rule of defense in this case has not been communicated to us with that business-like frankness which should characterize especially such intercourse as that between a lady and companies who have sought the confidence of her husband in his lifetime, and though the object of the pleading is to give notice to the opposite party, they have communicated no specific and definite information. Yet we do know that the agents of these insurance companies have laid their corporate cheeks together through this community to defame the memory of the dead and intimidate this widow, and it is right and proper— Mr. Hinckley: I must interrupt the counsel in slandering the agents of the companies. Is that a proper opening statement, Your Honor? The Court: I do not think this is within the proper limits of the opening statement. Counsel charging the parties on the other side with a combination to defame. Mr. Johns: I will rest there if Your Honor so rules. Now, gentlemen, with your permission, I will ask your attention, carefully, to the immediate facts which led this lady to make the claim against this company. We shall prove to you that in the summer preceding his death, Winfield Scott Goss was boarding upon the York Road, near Waverly, about a mile or two from the city of Baltimore, at the house of a Mr. Engle. That near there was a little tenement upon the estate of A.J. Lowndes, Esquire. It was idle. Mr. Goss asked permission of him to rent and occupy that building, that he might there carry on his trade as a mechanic and pursue the prosecution of certain inventions which were then occupying his attention. That he was undertaking to develop the manufacture of a substitute for India rubber, which he had been promised large rewards for if he should only be successful. I shall prove to you that the basement room, where he carried on his inventions, was damp and uncomfortable, that he asked his brother-in-law and a neighbor to accompany him there to help him remove some heavy articles from the basement to a more comfortable room upstairs. We shall prove to you that he was in perfect health that day, the 2nd day of February, 1872. We shall show to you that in the afternoon of that day, his brother-in-law, Mr. Udderzook, and a neighbor came up to be with him. That as it grew dark it became necessary to light a lamp, that W.S. Goss, the deceased, took up a large glass lamp, holding about a quart, which at that time was almost empty, that he attempted to light it, that Mr. Udderzook, his brother-in-law, and Mr. Engle, who were with him, remonstrated with him that he had better not fill that old lamp, that they suggested they would go down to Mr. Engle's and obtain a lamp, that these two persons left Mr. Goss in that building, going away for that purpose. Our proof will then be that when these two gentlemen were absent for the purpose of borrowing a lamp which they thought would be safe, they were alarmed by the cry that the house was on fire, and in a few moments, as they looked out, this building was in flames, and of course they and all the rest of the neighbors collected at the spot. That in a few moments afterwards, not finding Mr. Goss, Mr. Udderzook commenced to make inquiry for him, and that then one of the parties there present took a large board and threw it against the side of the building, so as to let the vision in from the flames, and there upon the floor they saw the burning and almost charred remains. That with an ice hook they succeeded in bringing the remains out, and that it came out with the blood pouring from it, the limbs burned off, but the breast, which may have been concealed, as we will show you, by timbers or something which had fallen upon it, almost preserved, and a little of the hair still remaining. We shall prove to you, gentlemen, that the body was then removed to a barn near by, that it was cold weather, that it was placed upon a sash in the barn and allowed to remain there during the night. We shall prove to you that when they came there in the morning, The blood, which had flowed freely from the freshly burnt body, had frozen in icicles around the sash. That after the inquest the undertaker removed the body to the residence of the widow, and we shall prove to you that instinct as well as intelligence came to the recognition of that body, and that a woman's eye and a widow's breast knew it was the one upon which her own had rested and pulsated, and that, after giving it look enough to know from the broad frame and the thick neck and the form of the head that it was the remains of him she had almost worshipped, she threw herself upon that body and had to be taken from it by violence. We shall prove to you, gentlemen, that all the friends and relatives and neighbors were invited to that funeral, and that he was buried as every honest man who had met with such a painful and accidental death would desire to be buried, from the house of his own family. We shall prove to you, mark this little circumstance, gentlemen, that a day or two after the accident occurred, the brother of the deceased visited the premises and felt around among the ashes for anything that might look like a bone, and anything that looked like a bone he gathered up, and took and deposited them in one corner of the coffin, that he might do the last act that a brother's love dictated him to do, burying all that remained of his brother, and not leaving it to be scattered by the winds of heaven. We shall prove to you, by way of closer investigation of that body, that the brother found there a bunch of keys which Winfield Scott Goss carried with him, and that they fitted drawers in his home. We shall prove to you that he found his watch, a little tape line, or the metallic case of it, which he had been in the habit of carrying with him. Then, gentlemen, we shall prove to you that we committed these remains to the ground, and we supposed that we were burying him, giving him forever to the earth, but that such in the issue was not the case. In last January, 1873, as we shall prove to you, we received a communication from the council of these companies, filled with platitudes about the desire of these companies to pay this lady when they were satisfied, and demanding that they should be allowed to dig those remains from the ground and examine them. They accompanied these with a prerequisite that we should furnish them, first a written statement descriptive of Mr. Goss over the signature of the widow, and that then, in the presence of such medical gentlemen as they might select and we might select, the remains should be disinterred and examined. Strange demand to make upon us! Strange and startling demand as a matter of right! That, gentlemen, we hesitated, as we shall prove to you, in yielding to this demand. We shall prove to you that we consented to that exhumation, imposing simply one essential prerequisite from which we would not yield, that we should have someone present at the time who would identify the remains as those we had buried there, because we, as business men, knew the uncertainty that hangs over the remains when the family loses sight of them, and we knew what a hubbub would be created through this city if we should consent to that examination and go there and find nothing, or a substitute for what we had placed there. We shall prove to you that we went there and met the medical gentlemen they had selected, and took with us those we had designated. It was a year after it had been interred, but when the coffin was opened, and those whom we had taken with us to identify it as the body which had been placed there, looked in the corner of the coffin, there were the few bones we had placed there. We shall prove to you, gentlemen, that then, in consequence of the inclemency of the weather, these medical gentlemen requested they might be permitted to remove that body for a more careful examination. We could hardly tell what more they could ask. It was removed. The only restriction we placed upon them was that they should do nothing to it, even in its then dilapidated and pitiful condition, that would further mutilate or disfigure it. We shall show you the report that was made by those medical gentlemen, which, though it could not identify the form in its then poor, emaciated condition, still reported what they did discover, and we shall show to you that there is not one single hair or tittle of difference that would commend itself to any intelligent and honest man, bent on an honest purpose, between the description that they give and each and every description which they had been given by Mrs. Goss herself. And, gentlemen, we yielded to that request, and I must say here that often since I have wondered if I did right in yielding to it. But it seemed to me that though Mr. Goss was dead, his good name and his memory were still living, and that while a sentiment alone might prevent us from yielding to such a demand, his good name and memory required that we should yield. We knew that that grave which they proposed to disturb, if we refused, would be pointed out as men point out a felon's grave. We desired it should be the grave of our friend, where those who knew him and respected him in life might visit it, where the sunshine would fall upon it, and where his friends would speak lightly and kindly as they passed, and we yielded to the demand. Then, gentlemen, we shall prove to you that they promised us, if that examination was satisfactory to them, that that policy should be paid, and we will prove to you that, to our infinite and absolute surprise, I may say to our intense disgust, a letter came saying that they would not advise their clients even then to pay the policy. Therefore, gentlemen, the defense, as far as we know it, is that they deny the death of Winfield Scott Goss, which amounts to charging a base, savage, and merciless fraud upon this estimable family, which we are here to resist and to vindicate. Therefore, we shall supply this by another element of proof. We shall prove to you the high character of all these parties involved. We shall prove to you, all who knew Winfield Scott Goss, deceased, respected him, and though at times he might deal in conviviality to too great an extent with his companions, that he was a man then in the relations of business and social life, that all who knew him respected and loved him. We shall prove to you the high character of Mr. Udderzook, his brother-in-law, who was with him, prove it to you by those who were associated with him in the benevolent societies of the city, and who have known him as a man estimable and entitled to the confidence of all who are thrown with him. And we shall prove to you the high character of the brother, A.C. Goss. We shall prove to you that when his lips had been hushed into silence by death, and he was not here to tell the circumstances and the motives which had induced him to take out this insurance, that then all these companies interlaced and intertwined, and here we are to meet them. Alexander Campbell Goss, examined by plaintiff's counsel, testified as follows. In the month of February, 1872, I was boarding at number 41 North Calvert Street in the city of Baltimore. I last saw my brother alive about noon the 2nd day of February, the same day of his death. We separated on the corner of St. Paul and Fayette Streets. He told me he was going home. At that time he was engaged on the York Road, about 2.5 miles from the city, near the town of Waverly. His business there was completing an invention of his own, a substitute for India rubber, also gilding picture frames. He had been there about 4 months. I have been out to these premises. It was a small tenement house with about 7 rooms. The whole building was rented to him, but he did not use all the rooms. He was carrying on this investigation of his, to perfect his invention, in the cellar of the house. He also used one room immediately over the cellar. Question. What was that room used for? Answer. That was where he had his little steam apparatus on top of the stove that conveyed heat down into the cellar. I never saw my brother alive again after departing with him on the corner of the streets. I saw his dead body the next day about 12 o'clock. It was at that time placed in an ordinary, medium-sized shoe-box in the barn of Mr. Lowndes. I noticed there was blood dripping to the floor and a little blood on the floor. The blood was running down from the box in which the body lay. The body was handed over to the coroner the same day. It was then taken to his home, No. 314 North Utah Street. It was subsequently placed in the public vault and afterwards buried in Baltimore Cemetery. While the body was in the vault, I went out where the accident occurred, and there commenced raking the debris, and found some little bones which I supposed to be his. I made a small bundle of them and brought them to the city and kept them until the next day, and while the body was in the vault, I removed the coffin lid and placed the small bundle of bones in the coffin. On the following Saturday I again made an examination of the place where this fire occurred. I went there in company with a young friend. We did not search very diligently, nor very long. We did not find anything. The next week I went out again and searched there for some time, probably an hour or more. I first found his watch and chain, then I found the little keys that belonged to a drawer in his house, then the metal case of a tape line. I brought these articles in and showed them to Detective Mitchell. He went with me to see Mr. Lowndes, and we showed him the articles which I had found. The various articles produced and identified by witness. All these belonged to my brother. Question. Could you describe the appearance of your brother so far as his physique was concerned? Answer. Yes, sir. He was a very large man, weighing from about 175 to 180 pounds, very full in the chest, with a large neck and prominent forehead. Cross-examination by Mr. Wallace. Question. What induced you to go out and make the third search at the place where the fire occurred? Answer. My anxiety to get these things. I went out alone. Question. Was anybody there when you made the search? Answer. Yes, sir. A colored woman at Mr. Lowndes' house came up while I was at work. She remained there about 10 minutes. I had been there about 10 minutes before she came. Question. By what means do you identify this as your brother's watch? Answer. I have often seen his watch. This is the same size and the same kind of watch as his, and the chain I bought and presented to him myself. Question. What was the condition of the crystal of the watch when you found it? Answer. Around the edges it looked like it had been a little melted. Not a great deal, but was broken and mashed flat down on the face of the watch. It was not melted, except around the edge of the circle. I could see through it and see the hands. Witness further testified, my brother was boarding at number 314 North Utah Street with David Arden. Mr. Arden is married to the mother of my brother's wife. When I parted with my brother on the corner of the streets as stated, he said to me he was going home to dinner, then he would go out to his place, where he would be at work until late. He did not think he would be back home before 8 o'clock. I was a stranger in this city at that time. Had been here about 2 months. Was not engaged in any business at all. I came to Baltimore to see the city and to travel. I also expected to be in business soon with my brother, in connection with his India rubber invention. I remember exactly the time I went down to my boarding house that evening. It was before supper. I was there at supper. After supper, I went up to my room at my boarding house, where I spent an hour and a half or 2 hours, then came down and met Mrs. Parsons, my landlady, and spent the remainder of the evening in the parlor, and at the usual time retired to bed. I did not leave the boarding house that evening. William Lowndes. I am the son of Andrew J. Lowndes, and reside with my father on the York Road. Frequently saw Mr. Goss at the cottage. He told me that he carried on his India rubber investigations in the cellar. He never let me in there. I went into the room above the cellar. I saw in there a little pipe connecting with a can which he had, and he put a little water in the can and made fire in the stove, and said he produced steam to cook his rubber with, which was in the cellar underneath. That is all he would tell me about his rubber. End of section 27. Section 28 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 5. The Goss-Udderzook Tragedy, Part 4. William E. Udderzook. I reside at number 167 Conway Street. By trade, I am a smith and edge tool maker, formerly a teacher of fine arts. Have resided in Baltimore, in the same house, 8 years. I have known Winfield Scott Goss some 5 or 6 years. On the afternoon of the fire, I met with him about 2 o'clock, and proceeded with him to the house occupied by him, situated near the York Road, where we spent the afternoon and portion of the evening together. I have been there frequently before this time. He was engaged in perfecting the invention of a substitute for India rubber. He had his vat in the cellar, and forced the hot air or steam from the stove in the room over the cellar through a pipe running through the floor into a chest in the cellar. His workroom for gilding looking-glass frames was in the northeast room of the house. He and I were both in the cellar that afternoon. It was nearly 8:30 o'clock that evening when I left the house for the purpose of procuring a lamp from Mr. Engel's house, as the lamp we had would not burn. He left us at the door and closed and locked it after us. Before we left, he, Engel, and myself had been trying to make the lamp burn. It was a very large glass lamp. Question. Was there anything passed between you and Mr. Goss when you left? Anything said by you or him as to what you were going for? Answer. It was understood we were going for a lamp. That was the arrangement. Witness further testified. I do not think we were absent from the house more than 15 minutes. I had been to Mr. Engel's house before. I had stopped there that afternoon and borrowed an axe, and I returned the axe about sunset same day. At that time I took supper with the family. They were just seated at the table, and we were very intimate. I was at Mr. Engel's house when I heard the alarm, heard the cry of fire from someone in the neighborhood, and I opened the door to go out of the house, and saw the light of the fire at the same time. The flames were illuminating the neighborhood then, which was within 10 or 15 minutes from the time I had left Mr. Goss. I waited a very few minutes for the lamp, and when it was ready I went out of the dining room into the kitchen. When I opened the door, I saw the reflection of the light from the burning house. I set the lamp back on the table and announced to the family that the cottage was on fire, and ran across the field in company with Mr. Engel's son. At the time we arrived, the fire had spread to such an extent that it was impossible to effect an entrance into the house, or to get open the door. The glass was dropping from the heat, and the roof was in flames from one end to the other before I reached the house. I spoke to Mr. Engel, and told him that if Goss did not appear in a few moments, I would take it for granted he was in the fire, although, I said, it would not be safe to say so at present. I waited a few moments, and then I requested Louis Engel to go and deliver the sad tidings to his wife and the family, which he did. After the house had burned down sufficiently, and the fire had subsided, they succeeded in finding the body. It was carried to a barn and placed in a box there. The next afternoon the coroner took charge of it, after which I went with the undertaker to the barn and brought away the body to his residence, No. 314 North Utah Street, from where it was afterwards buried. I recognized it as being his body, judging by the size and shape of the head, and the size of the neck and breast, which were not much disfigured. I claimed it to be his body. I had a perfect right to do so, I think. I noticed a considerable flow of blood coming from the body. Cross-examination by Mr. Wallace. Mr. Goss and I married sisters. I married into the family the fall of 1865. Had not known Mr. Goss prior to that time. I am employed by the firm of Duker & Bro as an edge tool maker and a smith. Previous to the war, I was engaged in teaching penmanship and fine painting in oil in Pennsylvania. I had an interest with Mr. Goss in the manufacture of his substitute for India rubber. That was the object of my going out to the cottage with him. He had not yet made an effort to procure a patent. He told me that if I would devote a portion of my time with him and furnish some capital, I should have a share in the invention. I furnished him $200 up to that time. My wages are from $13 to $22 a week. My time contributed was in keeping him company. Mr. Goss had specimens of his substitute for rubber, which he exhibited. They were cut in square chunks, as rubber usually is, and he was in the habit of carrying them about with him. On the afternoon of the fire, I went out there with him, as he told me he had some very nice samples, and he was going to work on some that afternoon. I knocked off work that afternoon for the purpose of going out with him. We walked out to the intersection of Charles Street with the Waverly Street cars, and rode out as far as Waverly. At Waverly, Mr. Goss bought a half-pint of whiskey and a gallon of coal oil, which we took to the cottage, and about a quart of the oil was put in the lamp. We stopped on our way at Mr. Engel's house, where I borrowed an axe. My purpose in getting the axe was to cut a little wood to make a fire to heat up the house and heat the stove, in order that we might spend the evening in a warm room. From Engel's house we went to the cottage, where I proceeded to make a fire. He filled the vessel on the stove with water for the purpose of raising a little hot air or steam in the vat which was in the cellar. Occasionally he would go into the cellar to see how the preparation was working. I remained in the room on the floor above. I was in all the rooms that afternoon, but most of the time in the room where the stove was. It was a cold day, and there was some snow on the ground. About sunset I went back to Mr. Engel's house for the purpose of returning the axe. I remained there about half an hour. Mr. Gottlieb Engel then went back with me to the cottage. Goss unlocked the door and let us into the house. Mr. Goss visited the cellar once or twice after that. Mr. Engel and I remained in the room where the stove was. The lamp did not burn well. Apparently the wick was wet. Mr. Engel left the house with me for the purpose of going and getting a lamp. We left Mr. Goss in the dark, with only the light of the stove. I believe there was a little piece of candle there that he had been using. I heard the cry of fire before I left the Engel house. When I got to the cottage, the flames had burst through the windows and had thoroughly spread over the roof. All the rooms were apparently full of flame and smoke. I spoke to nobody but the Engels of my suspicions that my brother-in-law, Mr. Goss, might be in the flames. There was no one else there that I knew until Mr. Lowndes was pointed out to me. Mr. Wallace: In the name of heaven, if a man is burning up, do you have to be introduced before you will ask for assistance in pulling out the burning man? Udderzook: I claim that I performed my duty by sending a message to the family. Witness continued: I returned to the city, Baltimore, about 11 o'clock that night. I went first to number 314 North Utah Street, where Mrs. Goss resided. After I left Mrs. Goss, I approached a police officer on the street and made known to him the nature of the accident that had occurred, and explained to him that I believed it was caused by the explosion of a coal oil lamp. We went into a tobacconist's, and I gave him the details. The clerk at the tobacconist's store wrote the statement down. I asked the officer if he thought we would have time to have it published that night. He said he thought we would if it reached the newspaper office before 2 o'clock. I was anxious to have this get into the newspapers the next morning. Andrew J. Lowndes: The burned cottage was my property. It was a light frame building. Mr. Goss applied to me in the summer or autumn of 1871 to rent the house, as it was then vacant. I reluctantly consented to let it to him. That was my first meeting with him. Mr. Goss was a large, full-chested man. I was at the fire. After the house was pretty much consumed, my attention was first called to the suspicion of there being anybody in the fire by a man whom I did not know at the time, but in the inquest I learned it was Mr. Udderzook. I saw the charred remains after they were taken from the fire. They were very much burned. The chest had been lacerated in being drawn out. The face was partly burned and a great deal defaced. The head seemed to be whole. It appeared to be the body of a large man. Cross-examined by Mr. Wallace. Mr. Goss wanted to rent the house to perfect some discovery or invention of his own. I first declined to rent it to him. He subsequently applied through another person, and I finally yielded to his request. He was to pay $10 a month rent. It was let monthly. I think he had it 4 or 5 months. At the time of the fire, when I first went to the burning building, there was no other one there except my son, who went with me. I heard no noise, no cries, no explosion. In 10 or 15 minutes a considerable number of persons had gathered there. After the house was mostly consumed, I was leaning against the fence, conversing with some neighbors, when Mr. Udderzook came up to me, somewhat solemnly, and said, "I think he is in the house." I turned to him and said, "Who is in the house?" He replied, "Mr. Goss." I said, "Can it be possible Mr. Goss is in the house?" I asked who he was, and he said he was the brother-in-law of Mr. Goss. I said to him, "Is it possible that you, knowing Mr. Goss was in there, have not given the alarm before?" His reply was that he had been looking for Mr. Goss. Failing to find him, he felt sure he must be in the house and burned up. I said to him, "Sir, you might have alarmed the whole neighborhood. We would rather have had a false alarm than for a human being to be burned up alive." At the time Mr. Udderzook gave this information, there was nothing standing of the building but a few scantling. The roof had fallen in, the sides and chimney had fallen. Mrs. Eliza W. Goss. Examination by her counsel, Mr. Whitney. I am the widow of Winfield Scott Goss. Had been married 9 years. The first information I received of my husband's death was between 9 and 10 o'clock the night of the fire. This was from Louis Engel, who had come from the fire. Later that night my brother-in-law, Mr. Udderzook, made me aware of the fact of my husband's death. His body was brought home the next evening. I recognized it as my husband's body by the very full neck, full throat, and broad shoulders. I cut off a small quantity of hair to preserve, but a few days afterwards I found it reduced to powder. My husband was formerly in the looking-glass and gilding business. He was also getting up a patent for a revolving handle screwdriver. Cross-examined. My husband was engaged in the manufacture of a substitute for India rubber. He kept the secret of it entirely to himself. Rev. Richard Fuller. Mr. Goss was a member of the church of which I was pastor in 1860. He removed out west some time after that, and I have not seen him since. I officiated at his funeral. I am acquainted with his brother, A.C. Goss. He is a member of the church of which I am now pastor. Cross-examination. A.C. Goss became a member of my church immediately after the funeral of his brother. Mrs. Sarah Arden. I am the mother of Mrs. Goss. The last time I saw my son-in-law, Mr. Goss, alive, was between 12 and 1 o'clock the day of the accident. He was then at home at dinner. I never saw him again until his corpse was brought into the house. I saw the body very much charred, could not recognize any features. I saw sufficient to satisfy me who it was. I had no doubt about it at all. David Arden. I am stepfather of Mrs. Goss. She was living at my house. I first saw the corpse of Mr. Goss at the inquest. So far as the shape of the head and neck and chest are concerned, it corresponded with him. Cross-examined. It looked like a piece of coke. It was all charred. You could recognize no features. There was nothing peculiar about the chest otherwise than it was a full neck and full-chested man. Gottlieb Engel. I reside out on the York Road. I went with Mr. Udderzook to the cottage the evening of the fire. I was in the south room only. While we were there, Mr. Goss called to Udderzook to bring him a light. They tried to light the coal oil lamp, but it would not burn. I said to them I could fix it by turning the wick, but Mr. Goss said it was dangerous. Mr. Udderzook and I went to my house for another lamp. My mother got a lamp, and we were ready to go back when we discovered the cottage was on fire. I went to the fire, but returned home before the body was found. Mr. Udderzook came to our house after the fire was over, and said they had found the body. When he came into the house, he burst into tears, covered his face with a handkerchief, and trembled so he could scarcely speak. Cross-examined. I had known Mr. Goss about 6 months. Mr. Goss and Mr. Udderzook were at our place about 3 o'clock that afternoon. Mr. Goss invited me to come to the cottage and see him that evening. After that, he and Udderzook went to the cottage. About supper time I saw Udderzook again. He came to return an axe, and took supper with us. After supper, he and I went to the cottage. Mr. Goss unlocked the door and let us in. There was a coal oil lamp burning in the room we went into. Mr. Goss brought the lamp out of a room where it was and put it in the southeast room. I was in only 2 rooms that night, the southeast and southwest rooms. Mr. Goss went into the northeast room a couple of times when I was at the cottage, and closed the door behind him each time he went into that room. He took the lamp with him each time. When he came out of that room at one time, he said something about a fortune, something about wishing he had his fortune. While Goss was taking the lamp from one room to the other, the light went out. Goss then called to Udderzook to bring him a light. Udderzook first took a lighted paper, but it went out. Then he lighted a stick, and with it lighted a piece of tallow candle 3 or 4 inches long. Goss tried to light the lamp with the candle, but from some cause it would not light. I was standing a few feet off, and said to them it could be fixed by turning the wick. Goss said, "No, coal oil is very dangerous." I offered to get a lamp, and asked Goss to go over with me and get his supper. Goss refused, and said Udderzook should go with me as company. I said I could go by myself, but I had nothing against Mr. Udderzook's going with me. When we went out, Goss locked the door after us. He had no light when we left, but there was a tallow candle there on the workbench. We walked over leisurely and remained, waiting for the lamp to be got ready, 10 minutes or longer. I heard no alarm of fire, but when I went out on the porch I saw the reflection of the flames, and then walked to the end of the porch and saw the cottage was on fire. We all stood and looked for a while, and then ran. My brother Louis started first. I reached the fence before Udderzook did, and waited there until he had time to catch up with me. Then we went together to the fire. We walked the rest of the way. Udderzook and I remained together until the house was burned down. Before I left to go home, he asked me to point out Mr. Lowndes to him, which I did. At this stage of the trial, a little evidence was introduced in support of the general reputation for truth and veracity of A.C. Goss and of Udderzook. Plaintiff's counsel then read to the jury the correspondence between the insurance companies and Mrs. Goss through their respective counsel relative to an exhumation and examination of the charred remains which had been buried as those of Goss. Plaintiff here rested. Mr. Hinckley presented the opening statement of defendants to the jury. A. H. Barnitz. I am a clerk in the office of the Assistant Treasurer in Baltimore. I am familiar with the personal appearance of Winfield Scott Goss. Have a vivid recollection of him at this time. In ordinary conversation he disclosed his teeth, which were very good and regular. After his alleged death I went to see what I supposed would be his remains. I called at his residence in Eutaw Street, and was shown the corpse as it lay in the coffin. I could see no point of resemblance between Mr. Goss and the corpse. I saw the head and neck. It was perfectly charred and burned, so I could not recognize it as Goss or as anybody else. Cross-examination. I speak of his teeth being good and regular from what casual observation I made. Charles Hahn. I am a bookkeeper in the National Mechanics Bank. Winfield S. Goss made his first deposit in this bank June 17, 1871, and his last deposit was on the following January 17, 1872. He left his book at the bank to be balanced, and it was balanced and returned to him with his checks on the 31st of January, 1872. The balance due him was $365.75. He presented a check for the exact amount of the balance on the first day of February, which was cashed. End of section 28. Section 29 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 6. The Goss-Udderzook Tragedy, Part 5. John W. Langley. I am Baltimore agent for the Continental Life Insurance Company of New York. I knew Mr. Goss before he came to Baltimore. Knew him in Nashville, Tennessee. Goss met me one day on Baltimore Street and insisted upon going to see some portraits. I went with him into a photographer's, where I reluctantly consented to a sitting for a picture. I sat in a chair, while Goss stood behind me, and in that way our pictures were taken. I am quite familiar with his personal appearance. I remember him as a heavy-built, muscular man, dark curly hair, and wore a mustache and beard. I frequently noticed his teeth. They were unusually fine, regular, and white. It was a feature which exhibited itself in his ordinary conversation. He had a large, open mouth, and when talking would disclose his teeth distinctly. Mr. Goss came into my office with a sample of what he termed a substitute for India rubber. It was a square piece of ordinary India rubber. He showed it to me and offered me a partnership interest in the business of its manufacture if I would put in a certain amount of money. He asserted the sample to be his manufacture, and said that he had shown it to New York rubber men, and they could not distinguish between it and genuine rubber. I found that I could not see any difference. He said to me that one of the constituent elements of its manufacture was sea water. A. R. Carter. I have been agent for the Continental Life Insurance Company. Mr. Goss came into our office one day in the month of December, 1871, and exhibited a sample of what he said was a substitute for India rubber, which he said he was manufacturing. He handed it to me. It was about 3 inches long and 1.5 inches thick. I said to him it looked and felt and smelled like India rubber. He said there was not a particle of India rubber in it, but was made from materials which he got out of Chesapeake Bay. I satisfied myself by pressing it with my hands and by its odor that it was a piece of genuine India rubber, and told him so. He would not allow me to cut it. Mary A. Parsons. I reside at number 41 North Calvert Street, and was keeping the boarding house in which Mr. A. C. Goss lived at the time of the fire. I distinctly recollect that evening. Mr. A. C. Goss was not at supper in my house that evening. After tea, I was in my parlor as usual, and stayed there until after 9, when I went to my dining room. Mr. Goss was not in the parlor then. When I returned to the parlor, Mr. Goss was in there. Mine is a small table. It only seats 12. I always preside at the table. The next morning we had a conversation about this catastrophe, and in talking it over we noticed the fact that Mr. Goss was not at supper that evening, and wondered where he was. My mind is clear on that fact. Cross-examined. I saw Mr. Goss between 9:30 and 10 o'clock that evening. I looked at the clock as I passed out and into the parlor. I should not have thought of these facts but that the next morning, my attention having been called to them, we commented upon Mr. Goss not having been to supper the night before, and wondered where he was. Miss Mamie Parsons. I am stepdaughter of preceding witness, was living with her the night she has spoken of. The first time I saw Mr. Goss that evening was at about 9:30 o'clock. I was sitting in the parlor when he entered. The morning of that day he had made an arrangement to spend the evening with me. Afterwards he left a written message for me, saying that he had to meet his brother, in consequence of which he would be unable to return until rather late in the evening, and was sorry he had to break his engagement. He was at dinner with us that day. I was at supper with my mother that evening. Mr. Goss was not present. When he came into the parlor at 9:30 that evening, I said to him, "You are back sooner than you expected?" He answered, "Yes." I am fixed in my recollection that this was on the night of the fire and of the supposed death of Mr. Goss's brother. Cross-examination. The note was written me the same day he made the engagement. I did not receive it until about 6 o'clock, after I had gone into the parlor. It was lying on the mantel, and someone in the parlor called my attention to it. Mr. Goss left my mother's house the next evening and ceased boarding there. Mrs. E. M. Dudley. I reside at number 41 North Calvert Street in the house of Mrs. Parsons. I have resided there 4 years. I am principal in one of the primary schools in the city of Baltimore. My recollection goes back to the time when this affair took place, which is said to have resulted in the death of Mr. W. S. Goss. Owing to circumstances, I remember it, the circumstances impressing it more deeply on my mind. The next day after the fire being Saturday, and I being away from school, I was in the parlor about 9:30 o'clock in the morning. I am not there on other days. A note was brought in for Mr. Goss, saying that his brother had been burned in the fire the night before. Some one of us remarked at the time that Mr. Goss was not at home to tea the night before. I was myself at supper there the evening before. I can say positively that Mr. Goss was not there. His place at the table was opposite to mine, so that I could not help seeing whether he was there or not. Dr. John Thorne. I am a veterinary surgeon and have a livery stable. I was applied to immediately after dinner, on the day of the fire, by a man whom I did not know at the time, who wanted to hire a horse and buggy for that evening to go to Greenmount Cemetery. I asked him his name. He said his name was A.C. Arden, and that he lived at 314 North Utah Street. Question. Have you seen that person since? Answer. He is before me now. The witness identifies A.C. Goss as the man. He came about dusk and got the horse and buggy and remained out with it until 20 or 30 minutes after 9 o'clock. I have no doubt whatever about the identity of the man. Cross-examined. When he came back, he gave my man a pair of buckskin gloves. I saw Mr. Goss after that, and said to him that my man had a pair of buckskin gloves, and I desired to know if he came by them regularly, if they had been given him, as he claimed they were. I had but that one horse out that night, and I waited for it to return before I went to bed. I looked at the clock when he came back to the stable. James Gilroy. At the time of which Dr. Thorne has just been speaking, I was in his employ as groom. I recollect the hire of the buggy. I noticed the man at the time. Witness identified A.C. Goss as the man who looked like him but could not say positively. He drove out with the horse about 7 o'clock and returned about 9 o'clock. He went down in the yard a piece and then came back and said to me, "Here is a pair of gloves. You may have them." James S. McFarland. I am an officer of the Baltimore Police. Between 11 and 12 o'clock on the night of the fire, myself and Officer Hughes were standing at the corner of Madison and Utah Streets when a man approached us asking if we wanted a report for the newspapers. He then related to us the incident of the fire, saying that his brother-in-law, W. S. Goss, had been experimenting in some patent gum invention when, through the explosion of an oil lamp or some chemicals he was using, the fire and death resulted. We went into a tobacconist's, where the store clerk wrote down the statement as related by Mr. Udderzook. The night reporters were in the habit of visiting the police station for news items, and this statement was given to one of them. Officer Charles E. Hughes corroborated the statement of Officer McFarland. Jacob Wright, the tobacconist's clerk, testified to writing down the statement for publication as Udderzook had related it to him. John C. Smith. I reside where the fire occurred. When I reached the fire, the house had fallen in. I had been there about 10 minutes when Martin Quinn directed my attention to something in the embers which looked like a skull. It was near the chimney, on the north side of the building. A long pole or ice hook was obtained, and I assisted in dragging the body from the fire. I placed the body in a box, and it was taken to Mr. Lowndes' stable. The next morning, the first thing after I got up, I walked over to the place of this occurrence. During the night it had been snowing, and I could see that nobody had been there that morning before me. I went there to find Mr. Goss's watch and jewelry, which I knew he carried on his person. I searched very closely right where the body had been pulled out the night before. I could tell by the remains of the chimney exactly where this place was. I found some bones, which I cared for. I used a piece of iron in raking and searching, and examined the spot very carefully. I searched particularly the spot where the breast of the body had lain. There had been a 4 or 5 inch fall of snow during the night, but the surface of the ground was bare where the fire had been. I placed the bones with the body in the box which was then in the stable. I found a melted glass bottle among the embers. This I brought away with me. Martin Quinn. I was present at the time of the fire. The flames were breaking out from the roof and the windows when I reached the spot. The building was all down when we began looking for the body. Mr. Lowndes came up to me with others and said to me, "This man," meaning Mr. Udderzook, "says that Mr. Goss must be in the fire." I turned to Mr. Udderzook and said, "Do you say he is in the fire?" He said, "I am afraid he is." I said, "Why didn't you mention it before now, and we would have tried to save him?" He said he did not want to make any alarm, as he was a stranger about there. Then we began to look around and saw something dark near the chimney. I pointed to it and said, "If he is in the house, there he is." Mr. Johnson replied, "No, Martin, that must be his India rubber." The color of the object was dark. No one ventured to go in after it but Mr. Smith and me. After the body was taken out, we threw a bucket or 2 of water on it to cool it off. If I had any suspicion or information, when I got to the fire, that there was the possibility of there being a man in the house, I could and would have broken in the doors or windows and gone into the house. I could have got in on the east side. Dr. James Hardy. I am a practicing physician, and as such have attended W.S. Goss on several occasions in the fall of 1870 and spring of 1871. Memorandum entry in my book reads, May 15, 1871, Mr. Goss visited. Effects of a week's drinking whiskey. The next day I again visited him and found him suffering symptoms of approaching delirium tremens. On all the occasions I have had to prescribe for him, he was suffering from the effects of prolonged intemperance, the result of 5 or 6 days' intemperate drinking. Dr. Theophilus Steele. I am a physician in general practice in New York City, where I reside. On the 20th day of January, 1872, I professionally attended a gentleman who gave his name as W.S. Goss of Baltimore. I was summoned in my capacity of police surgeon, and found him in the 15th Precinct Station House. He was suffering from delirium tremens. I found him in the garb of a gentleman, claiming to be from Baltimore, and I prevailed upon the sergeant to allow me to take him to his hotel, he objecting to go to the hospital where I had wished to send him. I took him to the Brandreth House, where I attended him that day and night. It was a slight attack of delirium, brought on by several days' debauch. I continued to attend him until the 23rd of January, when he was much better. I called on the 24th, expecting to find him at the hotel, and learned that he had gone, leaving some memorandum with the clerk, telling me he would call at my office. He did not call, to my knowledge. He did not pay me for my services. My junior partner had some correspondence with him, and I received from him 2 letters. Witness produces the letters. Counsel for the defense here read to the jury the 2 letters as follows. Doctor, I am happy to say that I am much improved, but not entirely well. Please send me your bill, and I will either see you in the morning at 10 o'clock or will send. Please make your bill as reasonable as you can, as I have no more money than I want. Yours most respectfully, W.S. Goss. Doctor, I was much disappointed in not getting some money to settle my bill, but please don't feel uneasy, for I will most assuredly send it to you. I have received a dispatch which calls me to Philadelphia, but hope I will not be detained long, for I am not yet through with my business here, and will return soon. Hoping that I have not incurred your displeasure, and that I will meet you again, I remain, yours most respectfully, W.S. Goss. While I was in attendance upon him, I requested Colonel George Lemon, formerly of Baltimore, to see this patient with me. Mr. Goss stated to me, in answer to my inquiries, that he had had 2 similar attacks previously. Colonel George Lemon. I am a native and for many years a resident of Baltimore. I have resided in New York during the last 6 or 7 years. Dr. Steele, the preceding witness, is my physician and personal friend. The doctor told me he had found a Baltimorean at the station house and had taken him to the Brandreth Hotel, that he seemed to be a very decent man, and suggested that I go there with him and see him. At his invitation I went. I saw the gentleman he had taken there. He was very shaky when I saw him. He told me that he was in business on North Gay Street, Baltimore, in the picture frame and looking glass business. Mrs. Catherine Smith. I knew Mr. Goss, the party supposed to have lost his life at the fire. Have noticed him in conversation, and observed the character of his front teeth. He had such beautiful white teeth, and they were so prettily shaped that I spoke of it. I have often observed his teeth, especially when he laughed and in ordinary conversation. They were plain, even, white, and very nice shape. Charles W. Hamill. I was acquainted with W.S. Goss previous to the war, and have met him frequently since. In my intercourse with him, I have observed his front teeth, and noticed they were regular and good. I took particular notice of them. Herman Bloom. I am a gilder by trade. W.S. Goss was in my employ from April 1870 to June 1871. He had no interest in the business. His wages were $15 per week. At this time he had a fine set of teeth. He used to drink intemperately during this time. He became an habitual drunkard before he left my employ. E. Lloyd Howard. I am a member of the medical profession of the city of Baltimore, a professor of anatomy in the Baltimore College, also professor of anatomy in the College of Physicians and Surgeons in Baltimore. I was present at the exhumation of the body which had been buried in Baltimore Cemetery as that of W.S. Goss. The remains were taken to a private room in the College of Physicians and Surgeons, where a scientific examination was made. Doctors Miles, Gorgeous, and Wysong participated with myself in making this examination. All of us united in a report or expression of opinion as regards the medical facts we ascertained by our examinations. There was no difference in opinion among us as to the medical facts stated in our report. Of the 16 teeth belonging to the upper jaw, 9 teeth had been lost before death. By that I mean some time before death. There remained in the jaw 2 teeth. There had fallen out, since death, 3 teeth, and 2 sockets, which had once contained teeth, were shallow, so that it was uncertain whether these teeth had been lost before or after death. 9 of the 16 teeth were certainly lost long before death, and 2 others possibly were. One of the teeth lost from the upper jaw was a front tooth. Of the teeth belonging to the lower jaw, 7 were lost long before death. 1 tooth had been partially destroyed by disease, 1 root of a tooth and 8 teeth remained in the jaw. Of the 7 teeth lost, 6 were back teeth, and 1 was a front tooth, and the one of which the root only remained was a front tooth. This would have given the appearance of 2 front teeth lost from the lower jaw. Of the 32 teeth, 16 were unquestionably lost before death, and of the 16 remaining, 1 was only a root in the socket. The crowns of 2 of the front teeth approached one another over where a tooth had been lost. In the upper jaw, the palatine canal, which perforates the roof of the mouth just behind the 2 middle front teeth, was greatly enlarged by an abscess which had existed previous to death, and which abscess communicated with the diseased cavity of one of the front teeth. The abscess appeared to have formed about the root of the tooth. In our opinion, this abscess, communicating with the cavity in the bone, had absorbed or eaten through the bone to that extent, forming an opening between the socket of the tooth and this anterior palatine canal. It must have been considerably diseased to have left such lesions in the bone. It could not have been otherwise than very painful. We judged, from the facts pointed out, that the other teeth over the diseased root must have approached each other, giving a crooked, irregular appearance. Plaster model of mouth handed to witness. I have examined this model before and found it corresponded very accurately with the jaws we examined. Question. In pointing out to the jury the place where this tooth, which has been destroyed by caries, and of which only the root was left, will you state the character of the teeth on the opposite sides, if they had been penetrated by caries, and how far? Answer. The tooth upon the one side, the left tooth, was very much injured by caries, which extended entirely through the tooth, so that we could pass a probe from one side to the other directly through the body of the tooth. End of section 29. Section 30 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide Part 7, The Goss-Udderzook Tragedy, Part 6. Dr. F. T. Miles. I am a professor of anatomy in the University of Maryland. I was present at the exhumation and examination of the remains of the subject of controversy here. I was present at the request of the counsel for the plaintiff. The report read to the jury was signed by me. I concurred thoroughly in the facts herein set forth, and in the description of the teeth. Have heard fully the statement made by Dr. Howard in regard to the teeth and condition of the jaws, and according to my recollection and examination, it is correct. I have nothing to add thereto or subtract therefrom in the way of qualification. Question. Something has been said about the fact that, on the morning after the fire took place, when the remains that were found in the fire were in the barn, some water having been thrown upon them at the fire the night before, there was found some blood and water, which on that cold night had frozen around the box, or which perhaps was dripping from it. Permit me to ask you what that would indicate, or whether it would indicate anything in regard to the recent death of the body? Answer. It would indicate nothing in regard to such a body as that the remains of which I examined. It is possible that the body, long after death, may allow the blood and sanies to come out sufficient to stain water thrown upon it. Taking a body surrounded with the circumstances which have been related here, water thrown upon such a body, in the condition it was, The appearance of a bloody fluid would indicate nothing as to the length of time that body had been dead before the occurrence. Dr. Howard recalled. The bloody water noticed about the box by witnesses, in my opinion, would give no positive indication in regard to the time of the death of that body. I do not think I ever had a subject in the dissecting room that did not bleed readily. The blood which flows from such bodies is altered blood, but it gives the usual red appearance. Question. State whether or not there is any difficulty in obtaining dead bodies for the purpose of anatomical examinations. Answer. No, sir, there is an almost unlimited supply. You can get them for $15 to $20 apiece, any quantity of them. Witness further testified. I took some hair from the back of the head of the remains, which I examined. Witness produces the same. Question. State whether it has crumbled into dust or powder while in your possession. Answer. No, sir, it is in a state of perfect preservation. I have another small portion of hair which I took from the back of the head, and which I have washed and examined under a microscope. I found it was of a dark color generally. Some of the hairs were of a very light shade, although most of them were quite dark. You will observe in this specimen, producing the hair, some of them are much lighter than others. Dr. R. Wysong. I participated in the exhumation and examination of the remains which have been spoken of by Drs. Howard and Miles. I did so at the request of Messrs. Whitney and Johns, the counsel for the plaintiff. I joined in the report which was made, and concurred with the others in the conclusion arrived at in the report. I have heard the statement made by Professor Howard and Professor Miles upon the witness stand, and I concur with them in all particulars in what they have said as to the facts. Dr. Gorgeous, one of the physicians who united in the report of exhumation and examination of the remains, being absent from the city, was unable to testify. He was a dentist of skill and experience, and had prepared plaster casts of the mouth, which casts or models were used by witnesses in their testimony relative to the teeth. The evidence of Dr. Gorgeous not being attainable, Dr. Robert Arthur was called by the defendants and testified as follows. I have practiced the profession of dentistry 32 years. Plaster models of the mouth of subject examined, produced, and handed to witness. The operations of nature, after the loss of teeth during life, are such as to leave it a matter of no possible scientific doubt whether teeth have been lost before or after death, provided they have been lost a certain time before death. It is a matter of physical demonstration. Looking at this model of the lower jaw, speaking as a scientific expert, I would say those teeth were lost, with the exception of the ones from these two cavities, referring to the two which the other physician spoke of as where the teeth had fallen out since death, certainly more than 2 years before the death of the subject. In this model of the upper jaw, 3 of the teeth, I should say, were recently lost. The tooth next to the front tooth had been lost, unquestionably, from 1 to 2 years. The absorption seems to have been complete, but the eye tooth and next to it seems not to have been lost so long. The absorption has not been completed. I should infer, from the small cavities, that the front tooth had been lost some time before death. Obviously there was a great deal of disease here. There must have been much physical pain. This place where the penetration appears to have taken place in the roof of the mouth shows a perforation through the bone communicating with the socket of the teeth. The teeth must have been very much diseased to have gotten into this condition. Not within my experience have so many teeth been lost without the patient suffering great pain, and of necessity requiring the services of a dentist. In masticating ordinary food, this person must have found great difficulty. He must have eaten with great discomfort. I would not, by any means, call this person's front teeth quite regular. Teeth that are absent could scarcely be called regular. Even the teeth of the lower jaw must have presented a very irregular appearance. Dr. Charles H. Orr. I am a practicing physician. I have been in practice about 40 years. I am at present the president of the Medical and Chirurgical Faculty of the State of Maryland. I reside in Cumberland. I have been present during the medical examinations here, and have heard the testimony of Doctors Howard, Miles, and Arthur. Plaster casts of the mouth of the exhumed subject handed to witness. Question. Supposing these to be accurate models of the mouth of the subject, which was exhumed and examined by those medical gentlemen, and with the professional descriptions that you have heard, please tell the jury whether or not that was a regular set of teeth at the time of the death of the party. Answer. No, sir, it was a very irregular set. Question. State whether or not that was the mouth of a man, in your judgment, who had never suffered any pain from his teeth and never had occasion for a dentist. Answer. In my judgment, he required the services of a dentist on more occasions than one, and had suffered a great deal of pain on account of diseased teeth. Witness further testified, there is very little surface here for the process of mastication or chewing of food. The grinding teeth are not opposite each other in such a way as to enable this person to masticate ordinary, usual food. The abscess at the roof of the mouth would have produced intense pain. Looking at the whole of that mouth, it is physically impossible for the person who had it to chew his ordinary food without pain, and even with trouble and pain, the process must have been very imperfect. Question. What is the effect of fire upon human hair? Answer. Brought in contact with fire, the hair will burn, and will then crumble upon the slightest touch or friction, so far as the fire has been applied. When the hair has been heated but not burned, it preserves its integrity. Question. Have you ever heard of a case, in your experience, when hair burned would not crumble at the time when it was handled for the purpose of putting it away, but which fell to dust afterwards? Answer. No, sir. In my judgment, that is not physically probable. Hair is not a good conductor of heat. It does not burn well. It will ignite, but as soon as it is beyond the reach of the substance which ignites it, it will cease to burn. The defendant's close. John W. Butler, a witness for the plaintiff, in rebuttal, sworn and examined. I have known W.S. Goss since 1854. He was of an inventive turn of mind. He invented what he called a ratchet screwdriver some years ago. He called at my office some few months before his death and brought what seemed to be a piece of India rubber. Says he, "John, I think I have got it at last." I asked him what it was. He said that he had discovered a substance to take the place of India rubber and not cost more than half as much. I asked him why he did not patent it. He said he did not care about putting the receipt for making it on file, that he found it the hardest work of his life to keep the secret, even from his wife. A.C. Goss called in rebuttal. I heard the testimony of Dr. Thorne in reference to a buggy. His testimony is not true, so far as I am concerned. I have never been in a buggy since I have been in Baltimore. I met Dr. Thorne once before I saw him on this stand. At the time I was accosted by the gentleman whom I have now learned to be Dr. Thorne, I was starting to leave Mr. Langley's office, and passed near Dr. Thorne, who was sitting there with his feet on the stove. He got up, extended his hand, and offered to shake hands with me. He said, "My hostler has a very fine pair of buck gauntlets, which, he says, you gave to him. Will you tell me if you gave him the gloves?" I told him I did not. Then he said, "At the time you got the buggy." I told him he was mistaken in the man. He says, "What is your name?" I said, "Goss is my name, the brother of the unfortunate man who was burned up." He said, "That is not the name the party gave me. He gave me his name as Philip Rao." He repeated the name to me 3 distinct times. I sat there a few moments, and then got up and went home and spoke to my family about this matter. I remarked to Mrs. Arden, "I shall make a little note of that, for it may come up at some time," and I did so in this little book, producing the book. I made this little memorandum at the time in the presence of Mrs. Arden. It reads, I met Dr. John Thorne at Langley's office today. He accused me of getting the horse and buggy of him to go on the York Road. He said the name I gave him was Philip Rowe and not Goss. Question. You stated that you took supper at the house of Mrs. Parsons that night? Answer. Yes, sir. I am almost positive I did. Question. Have you any doubt about it? Answer. None in the world. Cross-examination. I have no memorandum by which I can tell the precise date when this entry was made in that book. I think it was 2 or 3 weeks after the fire, when I had the interview with Dr. Thorne. I had never seen Dr. Thorne before, to my knowledge, and was not then introduced to him. When I got home, I made the memorandum the same day. Question. If you had never seen this man before, and had never heard of him before, tell the jury how you became familiar with the fact that he was Dr. John Thorne. Answer. I think from what he told me. Question. He gave you his Christian name as well as his other name? Answer. I think he told me that, or I would not have made a memorandum. Question. I see that you use language which strikes me as somewhat singular. He accused me of getting the horse and buggy. What do you mean? What particular horse and buggy do you refer to by using that language? Answer. To the horse and buggy he asked me if I did not get from him. Question. It seems to me that a man making a memorandum of that sort, who had never known anything about it before, would have said, asked me about a horse and buggy. Answer. I felt sure when I got home there was a plot and conspiracy against me. Mrs. Arden called in rebuttal. I recollect A.C. Goss coming to my house and making the memorandum that he has testified to. It was done at my suggestion. He stated to me what had occurred. The plaintiff here closed. Dr. John Thorne, recalled in rebuttal by the defense, the statement of the name of Philip Rowe, as made by A.C. Goss, is not true. I never before heard of that name. The defense here closed. Defendant's counsel submitted prayers covering 2 points. First, the question of the identity of the body, of whose burning evidence has been given, with that of Winfield S. Goss, the insured. And second, the question of fraud as presented by the false statements made by Goss in his applications for insurance. The opening argument for the plaintiff was made by H. V. D. Johns, Esquire. E. Otis Hinckley, Esquire, followed in an argument for the defendants. These gentlemen spoke with marked ability and earnestness. The last day of the trial was devoted to the closing arguments of the distinguished counsel, upon whom this duty devolved. S. T. Wallace, Esquire, made the concluding argument in behalf of the insurance companies, and for nearly 3 hours his rare eloquence held the eager attention of the jury and of the great crowd of spectators who had assembled in the courtroom. Milton Whitney, Esquire, closed for the plaintiff, and was listened to with evident pleasure by the audience, and with telling effect upon the jury. The case finally was given to the jury, with leave granted to return a sealed verdict, and the court then adjourned to the next day. After a deliberation of about 5 hours, the jury came to an agreement. They were nearly unanimous from the first in favor of the plaintiff. The sealed verdict was duly read in court, it being in favor of the plaintiff for the full amount of the insurance, with interest added. Defendant's counsel gave notice of motion for a new trial, pending which the court adjourned. End of section 30. Section 31 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an Authentic Record of Remarkable Cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 8. The Goss-Udderzook Tragedy, Part 7. With unmistakable evidences of delight, the conspirators saw that they had almost attained success. But the motion for a new trial, and especially the postponement of the hearing upon that motion until the November term of court, was somewhat of a drawback to their happiness. They knew that the fugitive Goss, addicted as he was to intemperate habits, was liable to betray his hiding-place. Before Udderzook left the courtroom, he spoke to a representative of one of the companies upon the result of the trial, and in reply to a remark of his, was told that heretofore but little effort had been made to ascertain the whereabouts of the missing Goss. Doubtless he drew the inference that a determined search, instituted by the insurance companies, would expose the whole fraud and convict himself and his accomplices of perjury. Well might they have become alarmed with such a contingency staring them in their faces. Their efforts to thwart this, and at the same time secure the plunder awarded them by a prejudiced and hostile jury, resulted in the tragic events which followed. The verdict against the insurance companies was rendered on the 6th day of June, 1873. On the 30th day of the same month, at about 9 o'clock in the evening, William E. Udderzook arrived at the hotel of the little village of Jennerville, in Chester County, Pennsylvania. Udderzook was well known in that place. He had spent his boyhood there, and his parents still resided in the neighborhood. At the time of his arrival at this hotel, he was accompanied by a man whom Udderzook spoke of as his friend, but did not mention any name. He asked for supper. Owing to the lateness of the hour, only a cold lunch could be furnished them, of which they partook, and afterwards they decided to remain all night. They were shown to a room, where they were quartered for the night, both occupying one bed. The stranger is described as a stout, full-chested, rather heavy-set man, with dark hair, dark mustache, and side whiskers. He appeared to be about 40 years of age. The next morning, Udderzook spoke of his friend as being an invalid and unable to come to the breakfast table. A breakfast was accordingly prepared, which Udderzook took to his friend in his room. The stranger kept himself concealed from general observation during the day. Udderzook was absent from the hotel during the forenoon, having gone away for the purpose, as he stated, of visiting his mother and a married sister who resided nearby. In the evening he came back with a horse and top buggy, which he had hired from a neighboring livery stable, settled his hotel bill for himself and his friend, and then taking his companion into the buggy, drove away. Near midnight he returned the horse and buggy to the livery stable. He was then alone. An examination of the buggy next morning showed that the dashboard and bow irons were broken. An oilcloth which had been fastened to the floor of the buggy was missing, as also were 2 blankets which had been furnished with the buggy. The bottom of the wagon was stained with something which had the appearance of blood. A large gold seal ring, set with a bloodstone, and a bone shirt stud were found between the cushions of the buggy. A week afterwards, on Friday, the 11th of July, a farmer who resided in the neighborhood was passing along the roadway through what is known as Bear's Woods, when his attention was attracted by a number of buzzards in the road, on the fence, and in the woods. He thought it an unusual occurrence, but kept on his way. Returning over the same road soon afterwards, and seeing the buzzards still there, he determined to ascertain the cause of it. An examination of the spot led to the discovery of the body of a man, scarcely covered with earth, leaves, and a few branches of trees. Information of this discovery brought others to the spot, and the mutilated remains were found to resemble the stranger who, a few days before, had driven away in the buggy with Udderzook. The deputy coroner, with the assistance of his neighbors, made a careful inquiry into the mysterious circumstances. A jury of inquest was impaneled without delay, and upon the evidence before it they found, "that the same man, name unknown, came to his death between the hours of 7:00 p.m., July 1, 1873, and 8:00 a.m., July 2, 1873, from wounds inflicted by a dirk knife or other sharp instrument in the hands of William E. Udderzook of Baltimore, Maryland." The facts of Udderzook having been principal witness and manager of the occurrences connected with the fire on the York Road, coupled with the other significant fact that the remains of the missing stranger bore a striking resemblance to the description of Goss, were sufficient to arrest the attention of the insurance companies interested. An immediate visit to the scene of the murder followed, and a careful investigation of the facts was at once commenced. To the adjuster of the Travelers' Insurance Company was assigned the general supervision of the matter, in the interest of the companies, and by the 18th of July these investigations had been followed up with such vigor as to enable him to send the following telegram: "Under the direction of the district attorney, we have exhumed and thoroughly examined the body of the man recently found murdered near Jennerville. All the measurements of the body, muscular development, figure, and general appearance, accurately correspond with the well-known description of Winfield Scott Goss. The teeth are remarkably good, regular, even, and well preserved. The remains were fully identified by Baltimore citizens who knew Goss intimately during his lifetime. A seal ring, found in the wagon used by Udderzook on the night of the murder, was today identified by Louis Engel, of Baltimore, who is a friend of the Goss family, and who was a witness for Mrs. Goss in the recent insurance suit. He unqualifiedly declares it to be the ring worn by Goss, says he has seen and examined it many times, has frequently taken it from Goss and placed it upon his own finger. He described the ring perfectly before it was shown to him. The evidence is now complete, except an analysis of the bloodstains on the wagon and similar examination of the charred remains of the clothing burned by Udderzook. The materials for this purpose, under seal, are placed in the hands of Professor E. Lloyd Howard, of Baltimore, for examination and report to the state authorities." Udderzook was arrested on the 15th of July, at the instance of the Sheriff of Chester County, Pennsylvania, and being taken to Westchester, was securely lodged in jail. His arrest upon so grave a charge was well calculated to create the utmost consternation among his numerous friends and acquaintances, and especially among those of the Goss relationship. The daily papers were filled with rumors of alleged discoveries which seemingly strengthened the evidence against him. Startling disclosures followed in rapid succession, until all doubt was early removed from the minds of those who were best conversant with the facts. Udderzook's friends were equal to the emergency. His lieutenant, who in court had unblushingly denied getting the horse and buggy, was unceasingly active in his behalf. They had no personal interviews. Alexander Campbell Goss did not risk a visit to Udderzook while a prisoner in jail, but he plotted to extricate his confederate with characteristic cunning. The same able counsel who had conducted the insurance suit for the widow were soon actively at work for the brother-in-law. Strong local counsel was employed at Westchester, and the Honorable Wayne McVeigh, of Harrisburg, was also retained to defend the criminal. It would be interesting to review the steps which gradually revealed the great mass of evidence which so completely overwhelmed Udderzook upon his trial. This would occupy too much space, however, and as nearly all the facts material to the unfolding of this story appear in the evidence of witnesses produced in court, we may avoid repetition by entering at once upon the record of the trial of William E. Udderzook. On the 21st of October, following the finding of the murdered man's remains, the case came to trial at Westchester, Pennsylvania, Chief Judge William Butler and Associates Hawley and Passmore on the bench. For the prosecution appeared Honorable A. Wanger, of Westchester, Commonwealth's attorney, and William M. Hayes, Esquire, of Westchester. and for the prisoner, Wayne McVeigh of Harrisburg, Milton Whitney of Baltimore, and Joseph Perdue, Esquire, of Westchester. The clerk read the first account of the indictment to the jury. The district attorney, Mr. Wanger, then made his opening statement, wherein a brief resume of the case was laid before the jury. We make the following extracts therefrom. On Friday, the 11th day of July last, the naked trunk of a male human body was found in Bear's Woods, between Penningtonville and Cochransville, a lonely and desolate spot, buried in a shallow grave. The limbs, brutally severed from the body, were found buried some 22 yards distant. The man had side whiskers, was of a dark complexion, with dark eyes, hair dark and wavy, slightly mixed with gray. A shirt was found in the same grave in which the body was interred. From the feet were taken a pair of shoes. Several cuts, apparently stabs, upon the right breast, a cut across the throat, and 2 other slight cuts, revealed the crime of a horrible murder. Winfield S. Goss, in 1872, was a resident of Baltimore. On Friday, the 2nd day of February in that year, he disappeared. It was alleged that he was dead. We have been enabled to trace his wanderings, in some measure, until we come to this foul murder in your midst. In the month of June following his disappearance from Baltimore, he arrived at the Central Hotel in Philadelphia, where he registered under the name of A.C. Wilson. The handwriting upon the register will be submitted to you in proof of this fact. A few days afterwards he appeared at Cooperstown, in Delaware County, in this state, where he gave the same name. He boarded there for some months, and also nearby at Athensville, and frequented Bryn Mawr, not far distant. A description of his person and clothing, his statements and handwriting, will be submitted to you in proof of these facts. A finger ring which he wore, that is positively recognized, will be shown you. This ring he pawned at one time for a loan of a few dollars. He left Athensville for Newark, New Jersey, where he boarded until Wednesday, June 25, 1873. On that day he left for Philadelphia, procuring his passage ticket through the agency of Mr. Williams, a fellow boarder. In Philadelphia he registered at the William Penn Hotel, in proof of which fact we shall submit to you his handwriting upon the hotel register. Winfield S. Goss had effected an insurance upon his life to the amount of $25,000, and there were certain actions in the conduct of the prisoner which will be submitted in proof of an interest or reason for concealing the whereabouts of Goss, and even for his murder. A day or two after W.S. Goss arrived at the William Penn Hotel, as we shall prove to you, the prisoner came to Philadelphia, inquired for Goss, alias Wilson, and the two went away together. On Monday morning, the 30th of June, the prisoner and a stranger arrived at West Grove Station on the Baltimore Central Railroad in this county. They left their baggage and passed on foot for Jennerville, where they arrived at 9 o'clock in the evening. They there remained all night, and in the morning the prisoner hired a horse and rode to his brother-in-law's residence, situated 10 miles north. He met his sister at the house, and with her went to a neighbor's field, where her husband was at work. There he revealed to his brother-in-law that he had a friend at Jennerville who had money, and he endeavored to persuade Rhodes, his brother-in-law, to assist in putting the friend out of the way, stating that he had had this person in Newark, Philadelphia, and elsewhere, and that it would be worth a cool $1,000 to each of them. We shall show you that he had previously written to Rhodes, saying that he had a job for him. The prisoner then left his horse and went to Penningtonville on foot, where he hired a horse and top buggy. Returning, he stopped at Rhodes's place for the horse which he had left, and borrowed a strap with which to lead him. He arrived back again at Jennerville in the evening, returned the horse he had hired there that morning, and between 6 and 7 o'clock in the evening, he and the stranger, his friend as he called him, left in the buggy. They were seen at a number of places on the road, and will be traced to near the spot where the remains were found. At 11:40 o'clock that night he returned the buggy, broken and bloody. On the evening of this day, as we shall show you, there were heard cries upon the road, or within the woods where the crime was committed. This, as you will remember, was on the 1st day of July last. We shall show you that on the morning of the 2nd a smoke was seen arising from the woods. Farther in the woods some of the clothing of the murdered man was burned. Buttons found there were peculiar, and were like those worn by A.C. Wilson, alias W.S. Goss, when he left Newark. The prisoner was seen to pass the hotel in Cochransville on the morning of the 2nd, and at this hotel he received a cup of coffee and a light breakfast. Thence he went on foot to Jennerville, arriving there at 9 or 10 o'clock, with his clothes disheveled. On the way he made statements about the man he had taken away with him, which statements we will show were false. On the evening of the same day he called at the railway passenger station at West Grove, where he had previously left his baggage, as we have stated, and obtaining it, he took it to his mother's house, where he left it. The next morning he left for Baltimore. The person who had let to the prisoner the horse and top buggy sent him a bill for the breaking of the wagon and loss of blankets, amounting to $12.75, which bill he paid. This bill was found upon the prisoner's person at the time of his arrest. Gaynor P. Moore, sworn and examined. On Friday, the 11th day of July last, I was passing along the Newport Turnpike. Coming along in sight of Bear's Woods, I noticed quite a number of buzzards in the road and on the fence each side of the road. As I came up near where they were, I noticed a good many in the bushes in the woods. I went on upon my business, and returning, when I came in sight of the woods, the buzzards were still there. I went into the woods to see what attracted such a great number, and discovered something that was mysteriously hidden. It was partly covered over with earth, some dead leaves, and there were several limbs of trees laid lengthwise over it. I looked around that portion of the object which was exposed, to see if I could find any hair whereby I might determine what kind of an animal it was. I found nothing but a little tuft of dark hair, mixed with a few gray hairs. I did not make any further discovery, for I had nothing to work with. I then went to Mr. Herford's, where I had an errand, and from Mr. Herford's went across the lot to the house of Mr. Rhodes. Mr. Rhodes was not at home. I described to his wife what I had discovered in the woods, and she said she would tell her husband when he came home, and have him come up and see me at my home. Rhodes came about 3 or 4 hours afterwards. I took my shovel, and we went into the woods to the place where I had seen the object or body buried. Rhodes sunk the shovel into the soil on the left side of the body and dug up a shirt. He struck the shovel in again and raised up the head and face of a man. Just then I heard a wagon passing along the road. I went out to the road and saw a gentleman driving by. He was a stranger to me. I told him what we had found, and asked him to come into the woods and be a witness. He did not want to be detained, but, as he was going towards Penningtonville, he took us into his wagon that we might notify the coroner. The coroner and some 8 or 10 gentlemen went back with me to the woods to where the body lay. A jury was at once impaneled. The body lay in the same position as when we had left it. Some person had reached there ahead of us and had uncovered the body. I observed a good-sized whisker on the side of the face, also a very good crop of hair. His beard on chin and lower part of face showed that it had not been shaved for several days. His hair was quite dark, with a sprinkling of gray. Whiskers about the same color. The jury being impaneled, the body was placed in their care. It was the trunk only, the arms and legs having been taken off. It was naked. The limbs were found about 15 paces distant from where the body lay. They were buried only a few inches below the surface. On the feet were a pair of white cotton hose and a pair of Congress gaiters. The limbs were taken out and placed alongside the body. The remains were then removed by the coroner to Penningtonville. I subsequently examined and made measurements of the grave where the body was buried. The deepest part of it was 11 inches below the surface. At that depth was a large root running across the bottom of the grave. There were other roots running across near the ends of the grave. At the time when Rhodes and I raised the head out from the ground, the face had a natural look. By that, I mean I could have recognized it easily if I had known the person in life. I have no doubt of this. Counsel for Commonwealth here proposed to show a photograph picture to the witness and ask him whether he recognizes either of the persons photographed thereon, to be followed by evidence as to whose photograph it is. Objected to by the defense. The Court: The offer, of course, must be considered in connection with the opening that the Commonwealth made, and with the offer of other evidence showing whose photograph it is. We can see without difficulty that it can do no harm if it is not followed by such proof. If it is followed by such proof, the consequences are precisely the same as if the proofs were heard in advance. I do not myself see that it can make any difference to the prisoner, and this question is purely one of discretion with the Court. In our judgment, the evidence must be received. Exception reserved by the defense. The photograph spoken of here was handed to witness. It was the same photograph which had been introduced in evidence during the preceding trial of the insurance case, being a picture of Mr. J. W. Langley sitting and Mr. W. S. Goss standing by the chair. Witness testified: This person standing facing me bears a strong resemblance to the face of the person I discovered in Bear's Woods. From the point of the nose upward, in particular, there is a strong resemblance. Also in the eyebrows and the hair. A linen shirt, very much soiled and somewhat torn, was handed witness. Witness examining: That looks like the shirt found by the side of the body of the man found in the woods. I recognize it by the blood stains, and more particularly by that button, indicating. I noticed that button particularly on the front part of the band. I noticed at the same time that it was a common porcelain button, and that the thread was not white. Also these cuts in the shirt, one near the band, and these on the right side near the front. I observed all these marks while the jury were holding the inquest, before the body was removed from the woods. End of section 31. Section 32 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide Part 9. The Goss-Udderzook Tragedy, Part 8. Cross-examined by Mr. McVeigh. When Rhodes and I first raised the head and face, the face was white, and I looked at it closely with a view to determine whether I knew it, and concluded I had never seen the individual. I first saw the photograph last Friday evening. It was exhibited to me by Mr. Hayes, the Commonwealth attorney. He did not inform me who it was. I was not informed at any time whose photograph it was. Mr. Hayes showed it to me and asked me if either of those faces looked like the man I found, and I immediately recognized the man standing. Question: Did not you know these were two photographs on the same plate, of the insurance agent and of this man whose body is alleged to have been found? Answer: I never heard of that. By the Court: Was the face bloated or swollen to any extent whatever? Witness: I think not. I noticed it sufficiently to see, and if bloated at all, it was very slightly. Hugh Rambo, Esquire. I am Deputy Coroner, and reside in Penningtonville. I was notified officially in the case by Mr. Rhodes, at about 5 or 6 o'clock in the evening of the 11th of July, and impaneled a jury right away. We found a whisker on the right side of the dead man's face. On the other side, the whisker had been rubbed off by a stick and adhered to the stick. I immediately wrapped it in a piece of paper for preservation. I took a small portion of the hair from the head and wrapped it in paper also. We then examined the body lower down and found a cut just below the breastbone. We saw and examined several other cuts on the body, and then we took the body and carried it to the side of the turnpike. While we were getting the body out of the hole, my attention was called to a spot some 60 feet distant by some parties who had discovered a freshly made mound. I took my shovel and commenced to clear away the dirt, and there found the limbs. As it was growing dark, we removed the remains to Penningtonville. Examined witnesses same evening, and again next day. When the limbs were exhumed, there were a pair of white hose and a pair of shoes on the feet. I removed them from the limbs. Witness here identified the gaiters and hose removed by him from the limbs. At the place in the woods where the remains were found, the undergrowth is very thick, and there are many cedar trees. The limbs of the trees grow close to the ground and are full of branches. There was difficulty in seeing any distance on account of the dense growth. Subsequently to the inquest, there was another examination of the remains by Doctors Lewis, Bailey, and Howard. Mr. Wenger, the district attorney, was present at the time. Cross-examination. The hair on the top of the head was loose. Some of it was off, rubbed off, and lying on the skin. The one whisker that remained was rather loose and afterwards rubbed off. The odor was very offensive. We packed the body in ice that evening. Also some disinfectant was placed upon it by Dr. Bailey. Dr. Elisha W. Bailey. On the evening of the 11th of July, I received a message from Acting Coroner Rambo to go to Bear's Woods and examine a body. I went there and found some 8 or 10 persons present. I examined the body as it lay in the shallow grave, and found there was one cut opening into it between the 3rd and 4th ribs, and about 3 inches from the breastbone. There was another similar cut between the 5th and 6th ribs, one between the 6th and 7th ribs, and one between the 8th and 9th. There was one other cut at the end of the breastbone, another in the neck, on the left side, about an inch above the collarbone. There was an incised wound commencing on the left side of the neck, running across the windpipe, and terminating on the opposite side of the neck. This wound opened into the windpipe. There was also a wound across the bridge of the nose at the lower third, depressing the cartilage. This wound showed that it was not done with a sharp instrument. I found that the front teeth, the 4 upper incisors and the 4 below, had been driven back into the mouth. 2 of them were lying loose on the tongue, and the others were adhering. I removed them all from the mouth and have kept them in my possession. The hair upon the head was about 1.5 inches in length, inclined to curl, and was of a dark brown color mixed with a few gray hairs. On the chin was a beard of several days' growth. The limbs were all disarticulated from the body, at the shoulder and hip joints. Witness produced the teeth, which he had taken from the mouth, as stated by him. The person had what I would call a very good set of teeth. They were firm and large, and appeared healthy and strong. At the time of the inquest, I made an estimate of the age of the person and of his personal appearance. I considered him between 35 and 40 years of age, 5 feet 8 or 9 inches in height, 38 to 40 inches girth of chest. The body showed an erect carriage, with the shoulders thrown back, throwing the chest well forward. The limbs were large, well developed, and appeared to be those of a man in good physique. The hands were evidently not those of a laboring man. Dr. E. Lloyd Howard. I reside in Baltimore City. I am a physician and surgeon by profession and practice. I reached Penningtonville on the evening of the 17th of July last. On the 18th, I witnessed the disinterment of a body in the burying ground at Penningtonville. This was in the afternoon. After the coffin was opened, I made a careful examination of the remains. I found the body to be that of a white man of about 5 feet 8 inches in height, weighing about 170 or 180 pounds, and of stout frame. There were marks upon it indicating that a previous post-mortem examination had been held. Also wounds which did not look as though they had been made for the purpose of examination. There was attached to the head a bundle of hair lying loosely to the top of the head. None, however, attached to the scalp. The hair was about 1.5 inches long, of a dark brown color, and some gray hairs scattered through it. I removed a small portion for subsequent examination. There were no whiskers upon the face except upon the chin, where was a beard of a few days' growth. The head was well formed, rather large size. The forehead was straight and square, large, full face, and still further enlarged or slightly swollen by post-mortem changes. The eyes were of a dark color. The exact shade could not be determined. The nose was well formed and rather small. There were certain injuries about the face which I noticed, a cut across the nose, dividing the bones from the cartilage. This cut was not inflicted with a sharp instrument. There were also marks of injury about the mouth. The upper front teeth had been driven back into the mouth, carrying with them a part of the socket of the teeth. The blow upon the nose must have been a very severe one, to have broken in the bone and cartilage in the manner it did. The blow upon the mouth also must have been a very severe one, to not only break in the teeth and knock them back, but also to break in the jawbone. I found 10 teeth remaining in the upper jaw, and open, fresh sockets from which 4 others had been removed recently. 2 upper jaw teeth had been lost previous to death. In the lower jaw I found 9 teeth remaining in position, and evidence that 5 others had been lost immediately after death or immediately preceding it. There were evidences of 2 lower jaw teeth having been lost some months previous to death. At the time of death, he must have had 28 teeth in all remaining in his mouth. The teeth lost previous to death, both in the upper and lower jaw, were back teeth. The general appearance and character of his teeth were perfectly good. They were white, even, and regular. There were 3 or 4 gold fillings, and there were slight marks of disease upon 2 teeth. The neck was large and thick. There was a wound across the front of the neck, dividing the windpipe and extending deeply into the tissues. The chest was large and capacious. The points it presented were that it had been opened in a previous post-mortem examination, and in addition thereto, there were several wounds upon it. The exact nature or cause of these wounds it was impossible to determine. I examined the limbs, and found them cleanly disarticulated from the body at the shoulders and at the hip joints, evidently removed by a sharp cutting instrument. They were large and well developed. The wrists, ankles, feet, and hands were small for that sized frame. The nails were neatly trimmed, and the indications were that the man had not been accustomed to hard manual labor. The collar bones were large, throwing the shoulders well back. Cross-examination. At the time I went to Penningtonville, I volunteered to go with Dr. Lewis. Other persons accompanied us, and were present at the time of the exhumation and examination of these remains. Alexander H. Barnitz. I reside in the city of Baltimore. Am in the office of the Assistant Treasurer of the United States. I was acquainted with Winfield S. Goss. Have known him since 1859. I used to see him very frequently, almost daily, at the establishment of Harrington and Mills, where he was employed. At that time I had the books of that firm in my charge. I was with him there a little over 2 years. During the time he was there I saw him daily. Afterwards I met him occasionally. I saw him frequently, just as I see other people in the streets of Baltimore whom I know. He was a man of about 5 feet 8 inches in height, was well built, erect, unusually prominent bust, shoulders thrown well back, of full form and well developed. He had dark eyes, straight nose, round, full face, dark, wavy hair, a prominent brow, and wide forehead. He had a stout neck. So far as I observed them, his teeth were very good. I simply saw them in conversation. I was in Penningtonville with Dr. Lewis and Dr. Howard on the 17th and 18th of July last, and witnessed the exhumation of the remains. I was requested to examine them critically and see if I could trace any resemblance between them and Goss, that is, if I could identify them. I remembered the appearance of Goss in his lifetime, especially his prominent breast, and this I recognized in the remains. I also recognized the brow and forehead as his, together with the general appearance of the face across the region of the eyes. Cross-examination. The eyes were closed, not much sunken. There was no hair upon the head. I saw upon that corpse the features about the region of the eyes which I recognized as those of Goss. I saw there the expression that Goss wore in his lifetime. The eyes being closed did not destroy this expression. A. R. Carter. I reside in Baltimore, am agent of the Continental Life Insurance Company. I was acquainted with Winfield S. Goss. He was a fine-looking man, about 5 feet 8 or 9 inches tall. Dark brown hair, nearly black. Had a beard and mustache when I knew him. His chest measurement was 38 or 40 inches, and he weighed 175 pounds. He was of good figure, with broad shoulders. He had unusually fine teeth, as they appeared in conversation. I was in Penningtonville on the 18th of July last, and saw the human remains which were there exhumed. I recognized the body as that of Winfield S. Goss. I recognized particularly the prominent forehead, full chest, and square build. When I knew Goss, he was in the picture frame gilding business. He also stated to me that he was engaged in manufacturing a substitute for India rubber. Cross-examination. The peculiarities by which I distinguished the remains as being those of Goss were his prominent forehead, his full chest, and his square shoulders. The Court. Do you mean to say that you recognized those remains as the remains of Goss, or that in the respect which you have mentioned there was a resemblance? Witness. I recognized them as his remains. They resembled him so closely I was positive they were his. I would have taken them for his if I had seen them anywhere else. Louis Engel. I reside in Baltimore County, about 1 mile out from the city. I knew Winfield S. Goss. He lived at my father's house during the summer of 1871, and I was with him almost every day. He was a very fine-looking man, had a large chest, his shoulders were thrown well back, and he walked very straight. He had a broad forehead and had dark, heavy hair. He wore a finger ring with a bloodstone setting. It had square corners and flat top. The part that went around the finger was square on the edges and had a little groove in the middle of it. The ring was also a little bent, was not quite round. When he was living at our house, I would take the ring from him sometimes. I would take it off his finger and put it on mine and wear it. I admired the ring very much. It was a very pretty ring. I never saw one like it since that time. Question. Have you seen that ring since? Answer. Yes, sir, at Penningtonville. I think it was on the 17th or 18th of July last. Question. State whether or not you gave a description of the ring then before you saw it. Answer. Yes, sir, I did. Question. Could you recognize it if you were to see it again? Answer. I think I could. Witness was handed a ring, which he examined and said, "That is the ring." Witness continued. At the time Mr. Goss lived at our house, he had a leather-colored valise. I never examined it closely. Witness was shown a valise. It looked something like that, about that size and color. Goss sometimes drank liquor. I have seen him drink, and one time he borrowed money from me to buy liquor with. At one time I saw him drunk. Cross-examination. The time I went to Penningtonville was upon the same occasion of which the others have spoken. Question. Do you recollect, upon any occasion, of Mrs. Goss calling at your house since the publication in the newspapers about what you have mentioned in reference to this ring? Answer. Mrs. Goss did not call at our house. Question by Mr. Whitney. Do you recollect of calling at Mrs. Goss's house? Answer. Yes, sir. She sent for me, and I went to her house. Question. Do you recollect making any statement there to the effect that you did not mean to be understood as saying that this was her husband's ring, but it was one similar to the one her husband wore? Answer. I said it was the ring Mr. Goss had worn when he was at our house, and I thought it was his ring, and I have said that to different persons. Question. I am not asking what you told other people. Did you not say to her, in the presence of the family, that it was a ring that looked like the one that her husband wore, and that you thought it was the same? Answer. There was no one in the room at the time but Mrs. Goss and myself. I said to her that I thought it was Mr. Goss's ring, and that I was positive of it. Question by Mr. McVeigh. Where did you first hear of a ring found in this case? Answer. I knew nothing of it until I reached Penningtonville. J. W. Langley. I reside in Baltimore. Am agent of the Continental Life Insurance Company of New York. Have been acquainted with Winfield S. Goss many years. I first knew him in Nashville, Tennessee, and afterwards in Baltimore, Maryland. He was a man of medium height, large frame, full, deep chest, full weight. He had dark hair, inclined to curl. He had very fine front teeth. I was present with him in a photographic saloon at one time, at which time we had our pictures taken together. The picture was shown to and identified by witness. In this picture, Mr. Goss is standing and I am sitting. That is the position we were in when this picture was taken. John Charles Smith. I reside in Baltimore. I have known W.S. Goss. He boarded at Mr. Engel's, next door to where I lived. I saw him every day, passing him usually twice a day at the place where he boarded. He was about of the same size as myself, a little taller. He had dark, wavy hair and dark whiskers. He weighed about 180 pounds. Charles H. Jones. I am room clerk at the Central Hotel on Arch Street, Philadelphia. As guests come to the hotel, I see them register their names and assign them rooms. The hotel register of 1872 was shown to and identified by witness. Under date of June 21, 1872, I saw the name of A.C. Wilson registered as it appears here. I have no particular recollection of the individual. He arrived in the evening and went away the next morning about 9 o'clock. End of section 32. Section 33 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 10. The Goss-Udderzook Tragedy, Part 9. David R. Mullen. I reside in Cooperstown, Delaware County, 2 miles south of Bryn Mawr Station. I am acquainted with the prisoner at the bar. The first I knew of him was when he was 7 or 8 years old, when he came to live with me and remained with me until he was 16. His mother then came for him and took him away to learn the blacksmith trade. After he had learned his trade, and when he was upwards of 21 years of age, he came back and lived in my neighborhood for a year or more. It was 12 or 13 years ago when he came back to my neighborhood. I am acquainted with his handwriting, and have seen him write. He boarded with me while he was learning to write at a writing school, which was after he had learned his trade. It was some 2 or 3 weeks, and was 12 or 13 years ago. In the winter of 1871 I received 2 letters from him, to which I replied by 1 letter intended to answer both of his. I never saw him afterwards until I saw him here in the courtroom. 2 letters were submitted to witness. I received these letters through the post office at West Haverford. I recognized the handwriting as William E. Udderzook's. The letters offered in evidence and read to the jury are as follows. Baltimore, October 28, 1871. Mr. Mullen, Dear Sir, I take pleasure in informing you that we are all well, and hope these few lines may find you all enjoying the same favor. It has been nearly 1 year since I seen or heard from you. I thought it my duty to inform you that I still exist. I have constant employment, on cutters, in a factory, where over 100 men are employed. I should have written this letter sooner, but I am rather careless about writing. I suppose I have been prompted to this by a very particular friend of mine. He is a man of fine appearance and about my age, and very well to do. But the large circle of acquaintances he is obliged to mingle with has been a great source of annoyance. It is his intention to leave the city for a few months in order to wean himself from so much company. I recommended Cooperstown as a quiet little place and just what would suit him. Now, if it would suit you folks to receive him as a boarder, please write soon and name the particulars. He will not want to leave Baltimore for a few weeks. Can we look for you down this fall? We would be pleased to see you in Baltimore. I spent a few days in Jennerville last June. Mother was well at that time, but since that time she was very near being killed by the cow that she was milking, all on account of a dog coming to her while she was milking. I would like to write much longer, but owing to the lateness of the hour I will close. Please answer very soon. Very respectfully yours, William E. Udderzook, No. 167 Conway Street, Baltimore, Maryland. Baltimore, November 16, 1871. Mr. and Mrs. Mullen, I wrote a few lines to you some time since, but I have not received an answer. I come to the conclusion that you did not receive it. I therefore take pleasure in writing again. I do not know that I have anything of much importance to communicate at present. The state and city elections are over, and I suppose you have heard the returns. The Republican ticket has been defeated very generally in this state. I was nominated by the Reform Party and endorsed by the Republican nominating convention. After the convention adjourned, a committee called on me and informed me of my nomination. This committee consisted of the president, vice president, and secretary of the ward, also 15 custom house officers, besides a number from the post office and the naval department, also a large number of citizens. Several speeches were made to which I responded. The next evening a mass meeting was held. I, being present, was conducted to the stand by the sergeant at arms, by a request of the president amid loud and continued applause. I addressed the meeting at considerable length. I was not elected by some considerable, but run ahead of the ticket 31 votes in my ward. My district consisted of 6 wards. I was 5 votes short of carrying the ward, which was closer than had been for some years. Too many Roman Catholics. The Democrat ticket in my district stood 11 Catholics, 2 Protestant, and all were elected. I wrote you in my last in regard to a friend of mine that desired to wean himself from a number of his former associates. He has been in the way of getting a little intoxicated. I thought you might reform him. Would it suit you to board him a few months or less? Please answer as soon as possible. My wife and 2 little ones are well. I have steady employment making cutters for a large factory where over 100 men are employed. Joseph Thomas and Son, corner of Park and Clay Streets. Give my respects to inquiring friends. Very respectfully yours, William E. Udderzook, No. 167 Conway Street, Baltimore, Maryland. Witness continued. After I received the second letter, I wrote in answer, informing him that I did not think it prudent for me to take a boarder at that time. Some time after that, on the 22nd day of June, 1872, a man came to my house to board, and stated to me that his name was Wilson. A few days afterwards, he arranged a Mexican vine on my porch, so that as the vine grew it spelled his full name, Alexander Campbell Wilson. He had no occupation. He came in the afternoon of the 22nd of June, and remained until the 16th of the following November. He was a man of about 5 feet 8 or 9 inches, heavy, square build, very full in the breast. His hair was black, and his face cleanly shaved at the time he came. He let his side whiskers and mustache grow after he came. The photographic picture of Goss and Langley was shown to witness. Question: Do you recognize either of these in the picture? Answer: Yes, sir, I recognize the one standing as Mr. Wilson's picture. When Wilson came to my house, he came on foot, and brought nothing with him. He went to Philadelphia, and came back Sunday morning, bringing with him a valise. Wilson had a habit of drinking to excess, for which reason I declined to board him any longer. After he left my place, I received a letter from Newark, New Jersey, purporting to come from him. There was a portion of his board bill unpaid when he left my house. I did not afterwards receive any pay other than a watch, which he sent me by Mr. M.V. Olry. George Crook. I have known Winfield S. Goss since 1868. On my first acquaintance with him, I found him to be an intemperate man. The defense objects to evidence of W. S. Goss's habits of intemperance. The Commonwealth asks to show this habit with the view of identification. The objection is overruled and exception noted. He was a good-looking man, about 40 years of age, would weigh 175 or 180 pounds. He was about 5 feet 8 or 9 inches in height, broad chest, dark brown hair, had a peculiar active walk, and usually dressed neatly. Mrs. Sarah R. Mullen. I am wife of David R. Mullen, whom has been examined. A man by the name of A.C. Wilson came to our house on the 21st of June, 1872, and then went away on the 22nd, and came back on the 23rd. When he came the second time, he brought a leather valise. He was a stout-built man, about 5 feet 8 or 9 inches, very full chest, his shoulders thrown back, rather dark hair, and good teeth. He did nothing. In the fall he made a little house of acorns for a fair. Witness was shown the picture of Goss and Langley. The one in the picture who is standing is very much like Mr. Wilson. Mr. V. Olray. I formerly lived at the house of David R. Mullen in Cooperstown. I knew A.C. Wilson during the time he was at Mr. Mullen's. I saw him almost every day during that time. He was a genteel-looking man, about 38 years old, broad shoulders and chest, shoulders thrown well back, dark brown hair, inclined to curl and turning gray, small hands and feet, and very large hips. My business called me to Philadelphia daily. At the request of Mr. Wilson, I called at the Central Hotel, Philadelphia, for a black silk hat which he had left there. At his request, I directed and sent small paper parcels, which usually weighed 3 or 4 ounces, and were sealed with wax. I gave the parcels to Adams Express Company, at their office in Philadelphia. One of these packages was sent about the 7th of August, 1872, another about the 15th of September, and another about the 24th of September. The address which I wrote by his directions upon the parcels was A.C. Goss, Calvert Street, Baltimore, Maryland, care of Stevens & Co. At his request I went to Bryn Mawr Post Office and inquired for his letters, and on several occasions obtained letters to his address, which I delivered to him. They were all postmarked Baltimore. There was a cabinet furniture card printed on the envelope, purporting to be the trademark of Stevens & Co. Wilson and I conversed about people in Baltimore as mutual acquaintances. He showed me the wooden model of a ratchet screwdriver which he claimed to be an invention of his own. It was so constructed that a person using it could retain the same hold upon the handle and turn the screwdriver. The picture of Goss and Langley shown to witness. I recognize in this picture the one standing as Wilson's picture. Cross-examined. I never saw a man look at all like that picture except Wilson, nor bear any resemblance to him. It is by the general make-up of the man that I identify him in this picture. Abraham Good. I reside in Cooperstown. I am a carpenter by trade. I knew A.C. Wilson during the time he lived at Mr. Mullen's. I saw him 3 or 4 times every week. The picture of Goss and Langley shown to witness. I recognize the one standing as A.C. Wilson. Wilson borrowed $4.50 in money from me. A short time afterwards he came to me and offered me a finger ring as a pledge for payment. I took the ring and kept it about 1 month. I then sent the ring to him, to his address at that time in Newark, New Jersey. I sent him at the same time the screwdriver model. The ring had a large stone setting. The ring before introduced in evidence was handed to witness. This looks like the ring. I sent it to him in a package by express about the 1st of January. I sent it at his request. While I had the ring in my possession, I did not wear it, but put it away. I never examined it particularly. The screwdriver model was a double ratchet made in 3 pieces. The driver part had a stem to it that ran through the other 2 pieces, so that one could move the driver without the handle turning in one's hand. I never saw one like it. It was peculiar. Newton Marshall. I reside at Bryn Mawr Station. I am ticket agent of the Pennsylvania Railroad Company and agent of Adams Express Company. I have received packages through my office directed to A.C. Wilson and delivered them to him, for which he receipted. Receipt book of company handed to witness. The first package was received on October 16, 1872. It was a paper package, probably 18 inches long by 12 wide and 3 or 4 thick. It would weigh about 8 pounds. It felt soft, like clothing. It came from Baltimore by the way of Philadelphia, as appears by the waybill which is in this book. The next package came November 23, 1872, and was delivered to A.C. Wilson. It was a money package, and said to contain $40. He receipted for it in this book. It came from Baltimore by way of Philadelphia. I saw Wilson frequently in October and November, 1872. I suppose I saw him nearly every day for a month. I became familiar with his appearance in a business way by his calling at my office. Picture of Goss and Langley shown to witness. The man standing in this picture is the man I delivered the packages to. David Bachrach. I reside in Baltimore. I am a photographer. Picture of Goss and Langley shown to witness. I have the negative those pictures were taken from in my possession. Witness produces and exhibits negative. It is a picture of Winfield S. Goss and Mr. Langley. I had known Mr. Goss a few months before making that negative. This print, examining photographic card heretofore introduced in evidence, representing one man standing and the other sitting, was made about a year ago from this negative. At the time it was taken, I did not notice anything on the finger of Mr. Goss. The photograph shows he has a ring there. Annie E. Mullen. I reside in Cooperstown in the family of David R. Mullen. I knew A.C. Wilson while he lived in our family. He was a nice-looking gentleman. He had quite dark hair, a little curly. The photograph introduced in evidence shown to witness. The one standing is the picture of the gentleman who boarded at our house. The seal ring heretofore introduced in evidence handed to witness. That looks like the ring I saw him wear. Horatio C. Litzenberg. I reside in Athensville, about 1.25 miles from Cooperstown. I keep a hotel there. I knew A.C. Wilson. He came to my place to obtain board, and remained about a week. He drank occasionally. I saw him intoxicated twice. Witness identified a due bill from A.C. Wilson to H.C. Linsenberg, dated November 23, 1872. I wrote the paper, and he returned it to me signed. I did not see him write his name. Thomas R. Haley. I reside in Athensville, and assist Mr. Litzenberg in his business. I knew a man who represented himself to be A.C. Wilson. He came to obtain board, and remained about a week. He came on the 16th of November, 1872, and went away on the 23rd of same month. He was intoxicated several times while there. I refused him liquor at the bar several times. End of section 33. Section 34 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 11. The Goss-Udderzook Tragedy, Part 10. Mrs. Elizabeth Toombs. I reside in Newark, New Jersey. Am the wife of Isaac Toombs. Mr. A.C. Wilson came to my house November 29, 1872, and remained there as a boarder during nearly 7 months. I remember seeing the prisoner at the bar on the 11th day of May, 1873, at my house in Newark. He came to see A.C. Wilson. He was introduced to me by A.C. Wilson as Mr. Mullen. He came between 5 and 6 o'clock on Sunday morning. My husband conducted him upstairs to Mr. Wilson's room. He took breakfast with me. After breakfast, they made arrangements to go to New York. Wilson came and asked me for an umbrella. They then went away together, and returned together the same evening. They then took supper, after which they went to their room upstairs. Mr. Udderzook left to take the cars a little before 9 o'clock that night. I have not seen him from that time until I came into this courtroom. Mr. Wilson left my house June 25, 1873. It was Wednesday evening, between 9 and 10 o'clock. He left, as he said, to meet a friend in Philadelphia. He said he was going to Philadelphia. Mr. Wilson was what I would call a large man, full-chested, square shoulders, throwing his shoulders back, especially when walking. He had dark hair sprinkled with gray, whiskers the same. He wore side whiskers, with mustache somewhat connected with his whiskers, what I believe are called Burnside whiskers. His eyes were dark. He wore no beard on his chin. In conversation I observed his teeth. He had a very good set of teeth. He took with him his overcoat. I should call it a very dark wine color. He had a pair of light pantaloons on when he went away, and a dark vest. He wore Congress gaiters. He had no buttons on them. Exhibiting shoes heretofore introduced in evidence. They were something similar to those. I could not swear those were the shoes. His shoes were marked 8s. He used to leave them on the rack in my hall. Question. Where was the mark you saw? Answer. On the elastic, on the inside. Question. On both shoes or only one? Answer. I could not say as to that. Question. See whether there is a mark in that shoe. Answer, examining shoe. It looks like the figure I saw in Mr. Wilson's shoe. On the Tuesday before Mr. Wilson left, he was going away on Wednesday, he brought me a shirt and asked if I would wash it for him. Myself and girl washed and ironed it for him. It was a new shirt and rather difficult for the girl to iron, so I told her to leave it until after dinner and I would iron it. I did iron it, and in doing so I observed the band button was off at the back of the neck, and I sewed one on in its place. The shirt opened behind. There had been 2 buttons on, one on the yoke and one on the band. There was a buttonhole in the front of the band around the neck, eyelet holes in the middle plate of bosom for studs, a loop at the bottom of the bosom plates, and plates by the side of the middle plate. It was the first time it had been washed since it was done up new. Mr. Wilson had worn it a week previous. The shirt heretofore introduced in evidence exhibited to witness. In respect to the buttons, buttonholes, and the plates, this shirt answers to the same description as the one I washed. When Mr. Wilson first came to my house, he engaged board, and then went away and got his baggage, which consisted of a leather valise only. The valise had 2 handles placed so they could both be clasped by the same hand. The inside partition of the valise was loose, as I learned by picking it up from the floor where he had thrown it. The partition was covered with blue paper, small figures. This partition was left behind by Wilson when he went away. When I moved house, it was thrown away. The valise was tan-colored, and looked as though it had been roughly handled. There were 3 letters on one end, one of which I think was a C. The valise heretofore introduced in evidence exhibited to witness. It looks like the valise. The letters on the end are in the same place, but I cannot say certain about them, as they are so much defaced. The size of this valise, its color, and the color of the lining correspond with that of Wilson's. At the time Wilson came to board with me, I lived at number 275 Mulberry Street, and I moved on the 1st day of April, 1873, to number 331 Mulberry Street. When he left, I was living at number 331 Mulberry Street. When he came to board with me, he wore no ring, but he often spoke of one which he owned, and when it came I was curious to see and examine it. I had it in my hands and examined it, and saw him wear it afterwards. I had it in my possession one afternoon last April. It was handed me by a member of the family to give to Mr. Wilson. I put it on my finger until tea time, and then delivered it to Mr. Wilson. It was a gold ring with bloodstone setting. The stone was longer than it was wide. There was a groove around the gold band, a sort of beading. The ring exhibited to witness. It looks like the same ring. I placed it on this forefinger because it was loose from my other fingers. Mr. Wilson wore it on the ring finger of his left hand. Mr. Wilson received letters by post, brought by the letter carrier. They were addressed to Mr. A.C. Wilson. I did not often notice the postmark, but I have noticed the postmark Baltimore upon his letters. He has directed letters to me. I saw a letter he sent away. I saw that it was addressed to Miss Eliza Arden, Baltimore. He had a pair of eyeglasses. He never appeared to use them. I have seen him read and write. He did not then use them. He wore them by a cord about his neck, and carried them in his vest pocket. He had a habit of drinking. On several occasions he was very much intoxicated. When Mr. Udderzook was at my house to see him, Mr. Wilson called Udderzook Doctor. He left on Wednesday evening. The next Saturday morning I received a note from him, written on Friday, dated from Philadelphia. I did not save it. I burned it. He wrote me saying that he enclosed $2.50, with which he wished me to pay $1 to the paper man and $1.50 to a Mr. Myers across the street from my house. He wrote that he was the most miserable man living, and wished himself back at our house again, and said he would set sail for Europe on Saturday noon. There was no money in the letter. We had a private sitting room for our boarders, and he frequently went into it. He had an invention which was called the model of a screwdriver. My attention was called to it, but I could not explain what it was. The name of A. Campbell Goss was here called, but he did not respond, and the examination of the above witness was continued as follows. There was another person who called to see Mr. Wilson. I think it was during the last of January, 1873. He was introduced to me as Mr. Wilson's brother. He resembled Mr. Wilson. He came on a Sunday morning and left Monday afternoon. He called for a private room, and in the evening I gave him the dining room to do some writing in. They were writing there all the evening. The Goss-Langley picture was exhibited to witness. I recognized the one standing to be Mr. Wilson. Mr. Wilson had no business while he was at my house. Cross-examination. I saw the shirt before I saw it here in the office of Mr. Wenger, the Commonwealth's attorney. I also saw the shoes in the hands of other persons. I did not examine them. At the time Mr. Wilson lived with me, my family consisted of 15 or 20 persons. Sometimes we had 12 to 18 boarders. The latter part of last January, a gentleman, who represented himself as from Nashville, Tennessee, and as being a brother of A.C. Wilson, came to my house in Newark. He resembled Mr. Wilson. Miss Emma Taylor. I reside in Newark and live with Mrs. Toombs, who has just been examined. At the time A.C. Wilson boarded at her house, I knew Mr. Wilson. Saw him daily at mealtimes, evenings, and on Sundays. He was a stout, fine-looking man, with full chest, very dark brown hair, slightly mixed with gray, and at that time wore a mustache and side whiskers. He had large, dark eyes, and heavy eyebrows. In talking he showed his teeth, which were very good. He had a large seal ring, which at one time he gave to me, and I kept it about 3 weeks. I have not seen it since I parted with it. On the stone setting were 2 spots, which he pointed out to me, with a sort of drip between them. The part which goes round the finger is not quite round in shape. The ring heretofore introduced in evidence handed to witness. Witness takes the ring and proceeds to a window and closely examines it. I cannot see the spots so distinctly as I remember them. The resemblance of the ring itself and the shape and size is the same. The Court. Let us see what those spots are. The witness hands the ring to the judge and explains what she means by the spots. Mr. Wilson gave it to me to keep, and I wore it on that forefinger with 2 or 3 other rings. It was a rather tight fit on that finger then, and it is the same now. I kept the ring about 3 weeks, and then gave it to Mrs. Toombs, and she returned it to Mr. Wilson. I have seen Mr. Udderzook, the prisoner at the bar, before. I saw him on the 11th of May last, at the house of Mrs. Toombs. The way I remember or fix the date is because there was a lady friend visiting me, and she went away on Sunday, and the 11th, when he came, was the Sunday week before she went away. The Goss-Langley picture exhibited to witness. I recognize the one standing as Mr. Wilson. He left Mrs. Toombs's family on the 25th of June. He told me he was going to Philadelphia. While he lived at Mrs. Toombs, he wrote me several notes. Cross-examination. I recognize Mr. Wilson in the picture from the whole appearance of the person, from the whole effect of the figure. When Mr. Wilson gave me the ring, he was under the influence of liquor. I offered him the ring back several times when he was sober, and he would not take it. The notes he wrote me were upon small pieces of paper, which he placed in my hands. To some of them he signed his name A.C. Wilson, and to others no name at all. He wrote them frequently, sometimes 3 or 4 a day. Sometimes he and I would talk about the contents of the notes afterwards. I have a recollection of his handwriting, but not very distinct. Commonwealth's attorney proposed to offer 2 letters to witness and ask if she recognizes handwriting. One letter dated Newark, January 9, and received by David R. Mullen. The other addressed to S. R. Downs, June 19, 1872. Objected to by defense, and exception reserved. By the Court. Do you recognize handwriting? Look at it carefully and say whether you know that handwriting. Do you know the character of the writing? Answer. Yes, sir, the writing is that of A.C. Wilson, to the best of my knowledge. The following are the letters shown to witness. S. R. Downs, Success, L.I. Dear Sir, I have just noticed your advertisement in the New York Herald. Please drop me a few lines and state if you could not accommodate an humble, unassuming, and good-natured individual, as I profess to be, for less money than your advertisement calls for, am easy to please, can put up with anything. All I want is to get in the country. Please let me hear from you at any rate with directions how to find your house. Yours most respect, A.C. Wilson. New York, January 3, 1873. David R. Mullen, Esquire, Cooperstown, Pennsylvania. Dear Governor, I have but just time to write you a few lines, merely to inform you of my whereabouts and good health, etc., etc. Well, as you can see from this letter, I am again in the great metropolis, hard at work, and working harder than I ever did before in my life. I am with a large firm here, that was among the sufferers from the Boston fire. Their loss is near $100,000, and they are working hard to regain their former footing. I am glad that I have come to them in their distress, for they were sorely in need of my assistance, humble as it may be, for in these hurried times they wanted no new hands, but old ones, and as I am familiar with their business as well as their custom, I need no instructions. I have been to Philadelphia twice and to Boston once since I left you, and I leave here again tonight for Boston, and as soon as I return, I am off for the West for them. So you see, my dear Governor, I have my hands full. I have not had any leisure moments to myself since I have been here, and will not until I return from my Western trip. These men have been my friends in times past, and I am glad to have the opportunity to reciprocate their kindness. Gov., you know that I was looking for a package by express when I left you. Well, in that package I expected $100. I have received the package, but only received $40 instead of $100. The truth of this you can find out from the clerk at Bryn Mawr Station. Had I received the $100, I should have been able to pay you what I owe you, but as it is, I hope you are not uneasy, for I will not long remain in your debt. Now a few words about family matters, and I will close my letter. The time that I lived in your family have been very pleasant and agreeable. I was treated by all like a gentleman, and tried to the very best of my ability to act in accordance, and I flatter myself that I succeeded until within a few days of my departure, and then that D.M. old fool made me mad with his insults, and then I made an ass of myself by drinking whiskey. I would not have had it happen for anything. That I possess, particularly while in your house, but I can only say now that I am heartily ashamed of it, and I hope that I will, at no distant day, have an opportunity to make atonement for it. I wish that I had all to go over again. How different I would act! My affairs in Tennessee are progressing favorable, and I hope soon to be all right. Please remember me with kindness to your good wife and to Annie. Also to all inquiring friends. I have written Abe Good, and he is to send me my ring and screwdriver, and if you have no objection, please give him watch. I need it very much in traveling. Write me a few lines and send it in the package that Abe is sending me. Hoping to hear from you soon, I remain as ever, yours most respectfully, A.C. Wilson. Mr. Hayes offered to show to the witness the letters of W.S. Goss to Mr. Steele, vide page 227. Upon examining the handwriting, witness said, "It looks like Mr. Wilson's writing, but not so distinctly. I think it is his to the best of my judgment." Isaac Toombs. I am husband of Mrs. Toombs, who has testified. I knew A.C. Wilson, who was at my house, about 7 months. I saw him nearly every day. I was with him and conversed with him frequently. He was a fine-looking, stout, well-built man. He would throw his shoulders well back when he walked. He had a large, full chest, was about 5 feet 8 inches tall, and wore side whiskers and mustache. His hair and whiskers were nearly black, mixed with gray. He had dark eyes. I have noticed his finger ring, have had it in my hands several times. We had a talk about the ring before it came, and when it came it had become a subject of curiosity, and we all took a look at it. The ring heretofore introduced in evidence handed the witness. It looks in every particular like his ring. The photograph handed to witness. I recognize the one standing to be Mr. Wilson. He would frequently drink to excess. I saw him when he left my house. He said he was going to Philadelphia. I have seen the prisoner, Mr. Udderzook, at my house. He was there on Sunday, the 11th day of May, 1873. He came to see Mr. Wilson. He came soon after 5 o'clock in the morning and rang the bell. I got out of bed and went to the door and let him in. He said he wanted to see Mr. Wilson. I told him I did not like to call Mr. Wilson at that hour, as there was another man who roomed with him. He said he was a particular friend of Mr. Wilson, and I asked him in. He followed me upstairs. I called Mr. Wilson and told him a gentleman wanted to see him. I turned and asked the gentleman his name, and he said, Doc. I repeated, Doc? He said, all right, and then I left him and Wilson together. I afterwards saw them at breakfast together, sitting side by side. Mr. Wilson and he went away together, and I saw them at tea on their return to my house the same evening. About 9 o'clock they both left the house to go to the depot. Mr. Wilson came back alone. Cross-examined. Mr. Wilson was not in any business. He spent his time mostly in the house. He would often lie abed in the afternoons. He would smoke after dinner and then go and lie down. After breakfast he would usually light his pipe and sit down to read the papers. Towards the last of his being there, he and the other gentleman took a paper together. We commenced taking it about the time the trial was going on in the insurance case in Baltimore. End of section 34. Section 35 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 12. The Goss-Udderzook Tragedy, Part 11. Samuel Reeve. I reside in New York. Am a jeweler by trade. I knew A.C. Wilson when I boarded with Mrs. Toombs in Newark. I knew him from 5 to 7 months. I saw him every day during the time I was there, which was from the day after Thanksgiving until the second week in April. He was a stout, broad-shouldered man, round, full chest, very straight back. I should think his height 5 feet 8 to 9 inches, weight from 180 to 190 pounds, and from 35 to 40 years of age. He had dark hair, side whiskers, and mustache. His chin was shaved. His eyes were dark. I roomed with him from the first night he came, and as long as I remained. I roomed with him after we moved. He had a valise, all the baggage I ever saw. The valise heretofore introduced in evidence was where witness saw it. It was very much like that one. I think that is the valise. I have seen it opened, and I know the partition inside of his valise was broken. He used to drink to excess. I have seen him pretty tight several times. I saw and examined his finger ring several times while he was there. He asked me once or twice how much the ring was worth and how much he could obtain by pawning it. Ring exhibited to and identified by witness. The Court. How are you able to identify that? Answer. The ring Wilson had a stone of the same material and of the same size, and had a beading from the setting around the finger to the setting. The stone was set in the same manner as this. Usually the setting, from the stone, flanges, is not square. This one is neither square nor slanting. I have seen an invention of his. the model of a revolving double-ratchet screwdriver. I have had it in my hands and examined it. I have seen him write letters in our room. Sometimes he gave the letters to me to mail for him in New York. I remember the address of A.C. Goss, Baltimore, upon the letters. I do not remember the street and number. I sent for him a package, by Adams Express, from New York to Baltimore. It appeared like a newspaper rolled up in brown paper. It was addressed to A.C. Goss, Baltimore. He asked me to express it from New York. I worked in New York and went back and forth every day. He had a pair of eyeglasses which he used to wear fastened to a black cord. I never saw him use them to place them on his eyes. The Goss-Langley picture handed to witness. The gentleman standing is Wilson. Franklin E. Mills. I reside in Newark. Was acquainted with A.C. Wilson at Mrs. Tombs's boarding house. I knew him while I was there, which was from about the 15th of February to the 1st of April, 1873. He was a full-chested, broad-shouldered man, dark hair, slightly mixed with gray, side whiskers and mustache. I have mailed letters for him directed to A.C. Goss, Baltimore. I mailed them in New York at his request. James R. Williams. I reside in New York City, am a manufacturer of jewelry by occupation. I knew A.C. Wilson in Newark from the middle of May until the time he went away in June. I saw him leave Newark. He left in the evening of the 25th of June. I saw and examined his ring. The ring shown to witness. That is the ring. I recognize it because it is what is called a fine bloodstone, and it is a peculiarly made ring. I never saw any other ring made as this is, and I have been in the business some years. From the shank of the ring to the top of the head it is unusually flat. An American-made ring is usually higher. The stone is square, and the setting should be square with it. It is not so, however. The corners of the setting are rounded. The Goss-Langley photograph exhibited to witness. I recognize the tall person, who in the picture is standing, as A.C. Wilson. Cross-examination. An American-made ring is usually higher. That is to say, this is flat for an American ring. I spoke of this fact when the ring was first shown to me by Wilson. I made the remark that the ring was probably made in America by an Englishman. The stone is not uncommon. The only peculiarity I noticed about the ring is in its manufacture. The reason I took so much notice of that ring is because I was asked to buy it, and consequently I examined it thoroughly. The head of the ring, that is, the stone and setting combined, is low for an American-made ring. The English workmen make the head lower than we do, so that the ring may be worn with a glove. I should judge, as an expert, this ring was made to order, because of its peculiar make, rather than made in the usual ordinary course of manufacture. It is not a good piece of workmanship, nor a fine piece of jewelry. Augustus J. Saurin. I reside in New York City, am a carriage painter. I knew A.C. Wilson all the time he was at Mrs. Tombs's boarding house. I boarded there myself, and saw him nearly every day. Witness identifies the photographic picture of the man standing by the side of Langley as A.C. Wilson. 2 or 3 weeks before he left, he borrowed a pair of boots from me to wear while he was having his shoes repaired. I saw his shoes. They were Congress gaiters. He had them half soled, and he showed them to me after they had been repaired. The shoes heretofore introduced in evidence exhibited to witness. These shoes look like the same ones, but I would not swear positively they were the same. I have before seen the prisoner at the bar. I saw him in Newark, at the house of Mrs. Tombs, one Sunday morning. I heard the bell ring at the door, and heard Mr. Tombs call Mr. Wilson. I heard Mr. Wilson open the door to say to Udderzook, "Hello, Doc," and Udderzook answered, "Hello, Sandy." I occupied the same room with Wilson at the time. I was in bed, but could see them both. They soon went out of the room, and I did not see them again until at breakfast. Cross-examination. I occupied the same room with Wilson about 2 months, the latter part of the time he was there. Edwin Sutton. I reside in New York City, am a manufacturing jeweler by trade. Have been in the business 15 years. I knew A.C. Wilson about 4 months at the house of Mrs. Toombs in Newark. I roomed with him about 1 month. Photograph heretofore offered in evidence handed to witness. The person standing in this picture I recognize as A.C. Wilson. I have seen him have a finger ring. Ring handed to witness. This is the ring which I have seen A.C. Wilson wear. I recognize it by the beading running all the way around the shank, and by the peculiar shape of the head and setting. The stone is an oblong square, while the setting is not square, but rounded at the corners. He showed me the ring to know what it was worth, and I examined it at the time. I have seen him write, but never examined his writing. I once posted a paper for him, mailing it at Station C, New York City. It was addressed to an attorney at law, Baltimore, Maryland. I saw an invention of his. It was a wooden model of a screwdriver, with a revolving handle working with a double ratchet. I have seen the prisoner at the bar. I saw him in Mr. Wilson's room at Mrs. Toombs' house on the 11th day of May, 1873. Wilson introduced the prisoner to me as Mr. Mullen. He asked me about the trains to New York. I did not see them again until evening. Wilson called the prisoner Doctor when he spoke to him. Cross-examined. I should think this ring was made to order, because I never before saw one with a beading all round, and with the setting rounded off at the corners when it should be perfectly square. When Wilson showed me the ring, I noticed it had been mended by soldering upon the inside of the shank. Mrs. Mullen recalled. Mr. Hayes. I propose to show this witness a promissory note dated Cooperstown, September 20th, 1872, signed by Henry Ruppel, in favor of witness for $75. Look at that paper and say what you have to say of it. Who wrote it? Answer. Mr. A.C. Wilson. I saw him write it. I requested him to write it for me, and he wrote it in my presence. Michael O'Donnell. I reside in New York City, am a manufacturing jeweler. I knew A.C. Wilson from the first week in January, 1873, until he left Mrs. Toombs's, where we both boarded at the time. At one time I roomed with him. He had a valise with him. To the best of my recollection, this valise now shown to me is the same valise Wilson had. Photograph heretofore introduced, handed to witness. The gentleman standing I recognize as A.C. Wilson. I saw the prisoner at the bar on the 11th day of May at Mrs. Toombs's boarding house. I first saw him there at breakfast. Mr. Wilson called the prisoner Doc, and introduced him to me as Mr. Mullen. Wilson wore eyeglasses upon a round black cord, which was around his neck. I never saw him use the glasses to look through. I have seen him read and write. I once asked him for a button, and he said, "Why don't you get buttons put on like mine?" And he showed me that the buttons upon his pantaloons were riveted on. In the afternoon of the day he went away, I gave him a bone collar button, or stud. I had had the button some 18 months before I gave it to him. The button looked as though it had been smoked. It was of a brownish color. When I gave it to him, he put it in the collar band of his shirt and buttoned his collar with it. Question. Look at this button and give us your opinion about it. Answer. That is the same button I gave to Wilson, to the best of my recollection. Cross-examined. I gave him the button because I had made myself a gold one, and was putting the gold one in my shirt when he asked me for the bone button, and I gave it to him. He at once put the button or stud into his shirt collar band. I bought the bone button in New York, at a place where there were many more. It was discolored when I bought it, just the same tinge to it as it has now. The prosecution offered to show by this witness that Wilson had stated himself interested in an insurance suit, which at first he was afraid he would lose. If they succeeded, his share was to be $15,000. Wilson subsequently told witness that the suit had been successful, and endeavored to induce the witness to join him in a scheme to cheat the insurance companies, saying it would be very easy to do so by effecting an insurance upon his, Wilson's, life, and then he would disappear and go to Europe. The offer was made to show that such a suit was actually progressing in Baltimore. The court said the transaction was a fact, but this was a declaration of the deceased and could not be admitted as yet. If a fraudulent combination be proven, then it might be. At present it could not be admitted. Benjamin C. Norris. I reside in Newark, am a house builder by occupation. I knew a man who called himself A.C. Wilson, who boarded with Mrs. Toombs. The witness was shown the photograph. The one standing resembles the gentleman whom I knew as A.C. Wilson. He at one time called my attention to a pair of pants he had. The pants were much worn. They were a light-colored brown pants. The seat of them was darned very much. He darned them with a needle and thread. A pair of pantaloons handed to witness. I think these are the pants. It looks like them at all events. There is the darning. I am able to say they are the same pants. I last saw them in his room. He had his valise lying on the bed, lying open, and he was about taking it up to go away. He had no room in his valise to put them. Mrs. Toombs recalled. When Mr. Wilson went away from my house last June, he left a coat and a pair of pantaloons. They were light-colored pantaloons. Same pantaloons as shown to previous witness were handed to this witness. I think these are the same ones Mr. Wilson left there. I recognize them by this darning, which I saw him do. I noticed it at the time, and spoke to him about it. His coat was a long, black frock coat. It was an old coat. Handing witness a black cloth coat. This is the same coat. Augustus J. Saurin recalled. Mr. Wilson left a pair of old pantaloons and an old coat when he went away from Mrs. Toombs's house. They were light-colored pantaloons with brown spots in them. He offered them to me to work in as overalls. I never used them. I was rooming with him when he went away. The coat and pantaloons heretofore introduced were shown to witness. These are the same pants that he gave to me, and this is the very same kind of coat he had. It was left in the room when he went away. Louis Engel recalled. I have testified before, and stated that Winfield S. Goss formerly boarded in our family. When Mr. Goss was living at our house, he had a pair of light pantaloons mixed with brown, and a vest of the same color. The pants had a welt in the side. I was with him almost every day, and he wore those pants then. He was boarding with us about 4 months, and he wore those pants most all of that time. The pantaloons shown to previous witness were shown to this witness. To the best of my recollection, these are the same pantaloons. Cross-examination. When Mr. Goss boarded with us, it was in the summer of 1871. I do not remember the color of the pantaloons which my father or my brother wore that summer. Question. Now, what is your particular reason for remembering the color of Mr. Goss's pantaloons in that summer, when you do not remember the color of your father's or your brother's? Answer. Because his wife wanted me, at one time, to help her wash these pantaloons, and she washed them, and I helped her to do it. I never washed my father's, my brother's, nor my own pantaloons. I noticed the welt on the side then. Mr. Litzenberg recalled. I have said that Mr. Wilson boarded with me a week or 10 days at my place in Athensville. When he went away, he left a coat there. It was a dark frock coat. It was long-waisted, with short skirts. A coat handed to witness. I believe this to be the coat he left at my place. Mr. Sutton recalled. Mr. Wilson had a pair of light-colored pantaloons when he boarded at Mrs. Toombs's house, and when I roomed with him. I noticed they were darned considerably in the seat, and that they were rather short for him when he wore them. John W. Butler. I reside in Baltimore, am a manufacturer of woodwork. I knew Winfield S. Goss several years, was well acquainted with him. He showed me a screwdriver with a ratchet attachment. It was some time ago. According to my recollection, it was made of wood. It was so made you could keep firm hold of the handle in using it, as the driver would catch on the ratchet. It was between 1869 and 1871 that he showed it to me. I have corresponded with Winfield S. Goss, receiving letters from him and answering them. We corresponded through 2 or 3 years. I used to know his handwriting quite well. I think I would know it now. Cross-examined. I have none of his letters now. I destroyed them years ago. Witness was closely examined by Mr. McVeigh as to his competency to testify upon the handwriting of W. S. Goss, and on completing his examination, Mr. McVeigh remarked, "I think he is competent to testify on this subject." Redirect. A letter addressed to Mr. Steele was declared by the witness to be the handwriting of W. S. Goss. Another letter, without address or date, signed W. S. Goss, was also declared the same handwriting. A letter signed A. C. Wilson, written to S. R. Downs, dated Newark, June 19, 1873, was declared by the witness to be the same handwriting. In reference to the letter, the witness said it was a little more difficult to keep out of mind the other letters before him, which are signed by Goss, but in looking at the character of the handwriting signed A. C. Wilson, and trying to carry in his mind the character of the handwriting of Goss, he recognized it as Goss's handwriting. It was his judgment that Goss wrote it. A letter was shown witness, dated New York, January 3, 1872, signed A. C. Wilson, written to David R. Mullen, Cooperstown, Pennsylvania, in examining which the witness said that in his judgment it was the handwriting of W. S. Goss. The signatures of A. C. Wilson to sundry papers heretofore introduced in evidence were shown to witness, who said he could only speak of them by comparison. They appeared to be Goss's handwriting. Of the signature in the register of the Central Hotel at Philadelphia, under date of Friday, June 21, 1872, the witness said he should take that to be written by Goss. End of section 35. Section 36 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 13. The Goss-Udderzook Tragedy, Part 12. The jury were withdrawn at this point of the case, and a discussion ensued before the court alone, as follows. Mr. Hayes, the Commonwealth's attorney, said that they proposed to show that W. S. Goss, alias A. C. Wilson, within about a year prior to the burning of a house on the York Road in Baltimore, Maryland, February 2, 1872, procured sundry insurances upon his life to the extent of $25,000. At the time this fire took place, William E. Udderzook and others alleged that Goss was burned to death, and the prisoner at the bar made an affidavit to that fact and presented it to the insurance companies for the purpose of procuring the sum insured for Mrs. Eliza W. Goss, in whose benefit the insurances were written. The prosecuting counsel further proposed to show the institution of suits against the several insurance companies, the appearance of the prisoner as chief witness in behalf of Mrs. Goss, the result of the test suit, the motion for a new trial, setting forth that the insurance companies would show, if time were given them, that W. S. Goss was still living, and that it was while this motion was pending before the court, the prisoner persuaded A. C. Wilson, alias W.S. Goss, to meet him in Philadelphia at the William Penn Hotel, and took him thence to Jennerville, and thence to a point at or near Bear's Woods for the purpose of murdering him, and there murdered him. Mr. McVeigh, the prisoner's counsel, argued strongly against the admissibility of such evidence. The prisoner was not on trial for a conspiracy to defraud insurance companies. The offer of the Commonwealth's attorney was an effort, in part at least, to introduce the acts and declarations of an alleged co-conspirator as against his alleged murderer on a trial for his life. If the prisoner was now upon trial for conspiracy with W.S. Goss to defraud these insurance companies, and previous evidence had been introduced as to concert of action between them, the acts and declarations and conduct in every respect of Goss, bearing possibly upon the conspiracy, might, under the latitude that prevails in reference to this matter, be admitted. But when the conspiracy is ended, when the relations have changed, and the relations of hostility commenced, and the hostilities alleged to have been carried to the point of murder, and the prisoner is upon trial for his life, charged with having murdered a co-conspirator, then, the counsel argued, the saving efficacy of another rule can be invoked in the prisoner's favor, that only such acts as are immediately and directly concerned with him are to be given in evidence against him. The Court does not fail to understand the importance of this offer to the prisoner as well as to the Commonwealth. It may be that some parts of the offer are not evidence. The main features of the offer, however, are evidence that we must hear. It is the right of the prisoner to have the benefit of every reasonable doubt, as well in regard to law as to facts, and nothing will be admitted or has been admitted to the Commonwealth in respect to which the court has entertained a doubt, and nothing will be excluded that may be offered by the defendant in reference to which the court may have a doubt. The main features of the evidence offered bear upon two branches of the cause. First, the identity of the man who was known as A.C. Wilson with Goss. Second, the motive which may have actuated the prisoner. There is evidence for the consideration of the jury that this man, known in New Jersey as Wilson, was Goss. But Goss belongs in Baltimore. Now, it is proper that the Commonwealth should show, indeed it is necessary that it show, why it is that this man is there living as he lived and known by another name. It is very important. If they fail to show it, the argument will be no motive shown for change of name. No motive for this man residing in New Jersey who belonged in Baltimore. There is evidence for the consideration of the jury that this man was seen in New Jersey subsequently to the fire and subsequently to the commencement of the suits against the life insurance companies. If the jury believe that evidence and find that this man Wilson was Goss, it would be for them to reach a conclusion which would to them seem to follow, that Goss had entered into a corrupt scheme to obtain money from the insurance companies, and thus the motive is at once shown why he should disappear from Baltimore, and why he should change his name and hide from the world as Goss. Thus it is seen that in that respect the testimony must be heard. What he said, thus far we have not heard and do not propose to hear. The fact that he was insured, the fact that there was a fire, and that Goss is alleged to be dead may be shown. Then there is another aspect in which the testimony must be heard. As it is shown in evidence, this man after the fire appeared in New Jersey under an assumed name. Now it is proposed to show that the prisoner at the bar, under this condition of circumstances, made affidavit that he was dead, which affidavit was the basis of the suits against the insurance companies, that he appeared as the main witness in those suits, testifying that he was dead. Now, if the jury finds that Goss, at that time, was living in New Jersey under an assumed name, then it would seem to result that the prisoner was also in the scheme and perpetrated a fraud against the insurance companies. The conclusion would seem to be legitimate that he was to have a portion of the fruits. To keep Goss concealed from the world was necessary not only for the success of this fraud, but also to secure the prisoner against consequences which might follow discovery and exposure. Thus a motive may be found for concealing him in the most effectual way by taking his life when, peradventure, it was discovered that a concealment without it could no longer be successful. It is in these aspects of the case that the court thinks the offer is proper, and the testimony must be heard. The court will note an exception to the whole offer, and to every part of it, and will overrule it at present only in respect to a part. The jury were then recalled. Evidence was now introduced giving the history of the insurance written upon the life of Goss, and of the facts relating to the fire upon the York Road, together with the medical testimony as to the examination of the charred remains found in the ruins. It was substantially the same as that given at the insurance trial, and it is therefore unnecessary to reiterate it here. A few additional facts, which furnished cumulative or corroborative evidence, appeared in this testimony. Louis Engel testified that Goss sometimes called Udderzook doctor when addressing him. Engel also described the double ratchet screwdriver model, which Goss had frequently exhibited as being his own invention. One new and important fact appeared in the evidence of Thomas D. Laudenslager, who testified as follows. I reside in Baltimore. I am acquainted with the prisoner at the bar. For about 3 years and a half we worked together at the same shop, in the employ of Joseph Thomas and Son, on Clay Street, Baltimore. He first worked for them about 18 months, then left for a while, and then came back again and worked about 18 months longer, when he was discharged. The time he was discharged was about 2 months after the fire on the York Road. On the day of the fire a box came to our place and was unloaded and set on the pavement. That was in the forenoon, and after dinner it was taken away by Udderzook and W.S. Goss in an express wagon. At the time it arrived, I was in the second story of the factory, looking out the doorway, and was quite near them. The box was 4 or 5 feet or more in length, and about 15 inches wide and high. It was closed up all round. Udderzook came up to where I was, after helping to unload the box, while it was still there on the pavement. 3 other workmen and myself were standing together. One of them asked him what was in the box, and he said it contained machinery for their laboratory on the York Road. Cross-examination. The box was taken away in an express wagon soon after 1 o'clock that same afternoon. It was brought there in an express wagon between 10 and 12 in the forenoon. It was placed on the street pavement. It came there and was taken away the same day of the fire on the York Road. The fire occurred that night, and I heard of it the next morning. I have always lived in Baltimore. I first made known the facts about this box soon after the discovery of this murder. I knew of the insurance suits and of the contest being over the remains found there on the York Road. I did not give information at the time about this box because I did not want to be subpoenaed. To the court. Udderzook was working in our establishment at the time of the fire. He worked there in the morning of the day when the box came, but not in the afternoon. William B. Crockett. I reside in Newark, New Jersey. I am a merchant dealing in gentlemen's furnishing goods. I knew a man who boarded in Mulberry Street, who was known to me by the name of A.C. Wilson. He called at my store 2 or 3 times. He was a man of near 6 feet, probably shorter, not taller. He had side whiskers, was a well-built man, neck about 16 inches. The photograph heretofore introduced in evidence was handed to witness. I recognized the man standing as the man to whom I sold goods in my store in Newark. I sold him a shirt, some socks, and a pair of collars. I have never seen the shirt since, nor the stockings, nor the collars. No one has since described them to me, nor have I ever heard or read any description of either of them. We have a system in our store of marking shirts. It is a system that does not exist anywhere else, to my knowledge. I have with me a box of shirts marked in the way which is peculiar to our store. We have used this mark about 5 years. The manner of our marking is this. We start with the number 35, which is our lowest number, and adjoining the number is the letter E. Next to the letter is the size of the neckband, then comes the length of the sleeve. We have different grades. That is our lowest grade. The next grade is 45E, neck and sleeve as before. The next is 48E, neck and sleeve. Next, 545E, neck and sleeve. Then 58E, 67E, 625E, and lastly 6ME. On some of our shirts is a star at the end of the lettering which denotes the extra size of the yoke. The E upon the shirts I have described means open back with eyelets in the bosom. Without the E, they are open fronts with buttons. The number denotes the quality. The marks are placed on the front of the shirt, on its skirt, and will not easily wash out. Another peculiarity of our shirts is the shape of the tab at the bottom of the bosom, placed there to hold the bosom down. The stamping is done with type. I do not recollect the quality of shirt I sold to A.C. Wilson. It was in June last, but I cannot say what day. The shirt found in the grave, in Bear's Woods, and heretofore introduced in evidence, was handed to witness, with a request that he should examine it carefully. That is our shirt. The tab is the same, and marked 545E, 1634. I speak with confidence. The size of the neck is 16 inches, and the length of sleeve 34 inches. William S. Hines. I reside in Baltimore, am a merchant tailor, was acquainted with W. S. Goss, having known him about 16 years. I have done work for him, and now have his measure. My last measure for him is for a black frock coat. It was taken July 27, 1866, and is entered upon my book as follows. Length of waist 19 inches, whole length of coat 40 inches, half width of back 7 3/4 inches, at the elbow 20 inches, whole length of sleeve 32 inches, breast measure 36 1/2 inches, waist 34 inches. The coat identified by Mrs. Toombs of Newark was handed to witness. This coat has very much the appearance of my make of coat at that date. It is an old-fashioned coat now. The sleeve linings and inside work still retain the marks of my manufacture. The measurements compare exactly with the measure I took of W. S. Goss. My custom is to write the name of the person for whom the coat is made, or his initials, upon the inside of the loops by which the coat is hung up. There is a name or letters written upon this, but it has become so indistinct as to be barely discernible. The Court. Suppose you try a magnifying glass upon it. Witness, after examining with a magnifying glass, I see what appears to be W.S., but the remainder of the writing I cannot make out. Robert H. Hodgson. I reside in New London, Chester County, am acquainted with Mr. Udderzook, the prisoner at the bar. I saw him on the 28th day of June last, late in the afternoon, in the city of Wilmington, Delaware. He took a seat by my side in the cars, and rode with me from Wilmington to Philadelphia. We left the cars together, separated at the depot, and I have not seen him since until I saw him here. We conversed much of the time while in the cars. He told me he was going to New York. He told me he had come from Baltimore. It was on the last Saturday in June, the 28th. Josiah Jacobs. I reside in Philadelphia, am clerk and bartender in the William Penn Hotel. I recognize the prisoner at the bar as a man whom I saw on the 28th day of June last. He came to the hotel and asked for A.C. Wilson, who was then in his room, and I showed the prisoner to Wilson's room. I knocked at the door and told Wilson a friend was there to see him. The prisoner was at once admitted to the room. I saw him again at breakfast the next morning. He brought no baggage with him, and he and Wilson both went away immediately after breakfast. Wilson arrived at the hotel on the 26th of June before dinner. He brought no baggage at first, but that afternoon he brought to the hotel a leather valise. He registered his name in my presence. The register of the William Penn Hotel, under date of June 26, 1873, was handed to witness, who identified the name of A.C. Wilson as the name he saw registered. Mr. Udderzook did not register. Wilson remained in his room much of the time while at the hotel. Francis M. Pyle. I am a farmer by occupation and reside in West Grove, Chester County, Pennsylvania. I saw the prisoner at the bar on Monday, the 30th of June last, in the forenoon. I was at the time putting hay into my barn, when I heard footsteps on the barn floor, and upon looking I saw two men, one of whom I recognized as William Udderzook. The other man was a stranger to me. I went up and spoke to them, and they answered me. Udderzook spoke as though he did not know me, at least I thought so. I have known his mother and his two brothers since about 1854, and I at once recognized him. I asked him if they were strangers in the neighborhood. Udderzook replied they were, and that they had come from the city for a little recreation and to go fishing along the creek. I went to my house and left them at the barn. I was absent at my house about half an hour, and then on coming out I met Udderzook, who asked me if he could get a pie at my house. I referred him to the women, and told him they were pretty busy, as it was washing day. He went into the house, and I went to my barn. Soon afterwards I saw Udderzook with my little boy going towards the stranger whom I had first seen with Udderzook. The stranger was standing near the fence by my orchard, about 100 yards distant from where I then was. Udderzook was carrying a plate, and the little boy had a pitcher. The gong rang for dinner, and I went into the house. I recollect that Udderzook wore a straw hat, and was dressed in blue coat and pantaloons. I noticed that he had boots on, and had turned up the bottoms of his pantaloons, as it had rained that day. The stranger was a large-sized man, dark hair, side whiskers, and mustache. His eyes were dark. He would weigh, I suppose, 170 to 180 pounds. He wore light-colored pantaloons. He had on no coat when I saw him. When he was sitting down, I noticed that he wore gaiters, but I did not observe them more than simply to remember the fact that he had on gaiters such as gentlemen sometimes wear. When he spoke, I noticed he showed his teeth, and they appeared to be good. He wore a dark cap. I think he had no collar on. I noticed that he wore a ring upon one finger, but I could not describe it. Photograph heretofore introduced in evidence shown to witness. The man standing looks like the stranger whom I saw with Udderzook. I reside 1/4 of a mile northwest of West Grove, on the road leading from West Grove to Jennerville, and about 2 miles from Jennerville. Bears Woods is about 10 miles distant from my place. Cross-examined. I fixed the day and date because it was on the day I commenced mowing. There were 2 or 3 showers that day. They came into the barn for shelter from the rain. I have been acquainted with the Udderzook family ever since 1854, but I had not seen William for some 7 or 8 years or more. I made up my mind that it was he, and when I went into my house I told my wife there were a couple of strangers in the barn, and that I believed one of them was Jane Udderzook's son, William. I did not talk much with them. They did not seem to want to talk much. I tried to enter into conversation with them, but they did not wish to talk. The stranger mentioned having been to my cherry tree, and Udderzook said they had stepped into the barn out of the rain. I did not make myself known to Udderzook, nor ask him if he was William Udderzook. I was certain it was he. The stranger was a man of striking appearance, and I should have recognized him the next day amongst 100 from his general appearance. End of section 36. Section 37 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Homicide, Part 14. The Goss-Udderzook Tragedy, Part 13. Elmer Pyle, a bright, intelligent-looking boy of 10 years, was called and examined by the court, and then qualified as a witness. I am a son of Mr. Francis M. Pyle. I have seen the prisoner before. It looks like him. It was some time last June, on Monday, I think. I was on my father's farm. I first saw him coming up the road, and next saw him under the cherry tree by the roadside. I again saw him at the upper end of our orchard. There was a man with him. I was with them a good bit. The first time I heard them talk much to each other was about the eyeglasses. They were then at the cherry tree. I was there too. I went down there to them. The one who had the cap on, not the prisoner, wanted to look for cherries. Then he asked his man here, Udderzook, if he had seen anything of his eyeglasses, and they looked around on the ground for them. After this he found them behind his back. They were fastened to a black string, and were hanging down behind his back. I saw them there. He then commenced to look for cherries, and then he said, "Doctor, you had better go up to the shed out of the rain." The doctor called the other man comrade. Then I went away. I saw them afterwards at the upper part of the orchard. I went to the house, and father was going to the barn and met the doctor coming towards the house. The doctor asked if he could have something for himself and comrade to eat. Father told them to inquire at the house, and I went in with him to the house. He asked mother for something to eat, and she told him to go round to the front porch, and he did so. She got him something to eat, and asked him if he wanted some water, and he said yes. So I went for a pitcher and tumbler, and then he went up to where the other man was under the tree. They commenced to eat then, both of them. They asked me to take back the dishes, and I did so. They then went down the lane, and up the road towards Jennerville. That is the last I saw of them. Question. Do you recollect, so that you can give any description of these men? Answer. The comrade had on a cap, and I saw some kind of a button up here on his shirt, at the neck. I saw he had some kind of gaiter shoes on. I noticed the gum and the straps to pull them on with. The doctor had a straw hat on. Elizabeth J. Pyle. I am the wife of Francis M. Pyle of West Grove. I saw the prisoner at the bar with another man in our orchard in the forenoon of Monday, the 30th day of last June. Mr. Udderzook afterwards came to the house and asked me if he could have something to eat for himself and comrade. I told him that he could. He said they had come out on a day's excursion. He wore a suit of dark blue, a high-crowned straw hat with the rim turned up. He had on a white collar and a long blue necktie, the ends hanging down upon the bosom, but not far enough to hide his shirt studs. Cross-examination. I know it was on Monday because it was wash day, and I had been to church the day before. I have a distinct recollection of that. I am certain Udderzook had on a suit of dark blue clothes and a blue necktie. He had 3 small shirt studs. They looked like a clear white stone in a gold setting. They were small and pretty. I was standing very close to him and observed his appearance. I remember this positively. No one has since spoken to me of this or how he was dressed. My husband that day told me who Udderzook was. David R. Mullen, recalled. I have said that I reside in Cooperstown, and that A.C. Wilson once boarded with me. A piece of wood, with ratchet end, handed to witness. This is part of a screwdriver model that Wilson made while he was at my house. It is of pine wood, and cut out with his knife. This and one other piece of the screwdriver was taken out from the model when he had completed it, and Abram Good, who is a mechanic, made some smoother pieces, which were put into the screwdriver in the place of these. Wilson took the model away with him, but these 2 pieces he placed upon my porch and left them there when he went away. I saw him at work upon it, and saw him put it together when completed. John J. Chambers. I reside in West Grove, Pennsylvania, and am agent for the Baltimore Central Railroad Company. A person called at my office, on or about the 30th of June last, and asked me the road to Jennerville. It was immediately after the 9:30 morning train had arrived from Philadelphia. A valise was left there, and it remained several days. Samuel C. Jeffres. I reside in Lancaster City, having moved there on the 17th of last month. Prior to that time, I lived in Jennerville, where I kept a hotel. The prisoner at the bar came to my house in Jennerville, accompanied by another man, arriving at about 9 o'clock in the evening of the 30th of June last. He asked for supper. I told him it was too late, but I gave him a lunch. I told him we were about to retire, and if they wished to remain all night, I would then show them to their rooms; that they could stay if they wished. Udderzook paid for the lunch, and said he would consult with his friend and tell me in a moment whether they would remain or not. He soon came back and said they would stay. I showed them up to a room fronting the south in the 2nd story. A drover by the name of Harvey Townley occupied the adjoining room. The next morning I saw Mr. Udderzook when he came downstairs. I asked him if his friend was not coming down to breakfast, or if he was ready for breakfast. He told me his friend was indisposed and would not come down. At breakfast, Mr. Townley, Mr. Udderzook, and myself were the only persons at the table. After breakfast, Mr. Udderzook carried his friend's breakfast up to him in his room. He inquired about a team, and I referred him to Mr. Edwin Patchell as having a horse and buggy which he could probably get. He told me, as I left him then, that he would be back for his friend by dinner time. I did not see him go away. He returned about 6 o'clock in the afternoon. This was the evening of the 1st day of July. He had a horse and buggy with him, falling top wagon. It was a bay horse. I noticed the lap blanket folded and lying on the seat. He watered his horse and held some conversation with his friend, the man who was at my house. This man was on the porch. They went to one side and held some conversation which I did not hear or pay any attention to. As they separated, I heard Udderzook say to him that he was going to see his mother. He said he would be back in half an hour, and he then drove down the road in the direction of his mother's. He returned in about half an hour afterwards. I saw the man who came with him at about 2 o'clock that afternoon for the first time that day. I had been away from home and returned at about 2 o'clock. The evening before, when they arrived, I handed them their lunch, and they ate it while sitting on the porch. I did not observe the man particularly that evening. When I came home at about 2 o'clock, I went into the dining room, which was darkened, and saw a man lying on the lounge. The shutter windows were closed. About 4 o'clock I was passing the front of the house. This man was on the porch and called me to him. We had some conversation there for about half an hour. We were at the table together at supper. Harvey Townley and my son George were at the table with us. I saw more or less of him from 4 o'clock until he left with Mr. Udderzook. It was in the neighborhood of 7 o'clock when he left in the carriage with Mr. Udderzook. When they drove off, they went in the direction of Cochransville. Mr. Udderzook was dressed in a suit of dark clothes and a straw hat. The other man was about 5 feet 8 or 9 inches, with dark hair and dark mustache. He was rather a fine-looking man, stood erect, and I would suppose him to be in the neighborhood of 40 years of age. My judgment would be that he would weigh about 175 or 180 pounds. They came on Monday and went away on Tuesday evening. Photograph handed to witness. The man standing in this picture resembles the man who was with Udderzook. Mrs. Margaret Jeffres. I am the wife of Samuel C. Jeffress, the preceding witness. I saw the prisoner at the bar in Jennerville on the 30th day of June last, at the time when he asked my husband for supper. I saw Mr. Udderzook at the breakfast table the next morning, and waited on him there. He told me he would take the other man's breakfast up to him in his room, and I prepared to give it to Mr. Udderzook, who went out of the dining room with it. I did not see him again that day. Mr. Udderzook and the other man occupied the same room. There was only one bed in the room. Between 9 and 10 o'clock in the forenoon, I saw the man who had come with Udderzook standing on our front porch fanning himself. It was a warm day. I held some conversation with him and inquired particularly as to his health. I informed him that we would close the dining room shutters and he could lie on our lounge there. The next I saw of him he was lying on the lounge in the dining room. I had some 5 or 10 minutes conversation with him in the dining room. He soon afterwards came and rapped on the kitchen door, and I opened it, and I talked with him a little while. I next saw him as I was going to the cupboard in the dining room. That was after 11 o'clock. He was lying down as I went into the dining room. He jumped up straight and said he would pay any price for some liquor. Mr. McVeigh: One moment. The Court: He jumped up straight and said something? Witness: He did. The Court: We will not hear what he said. Witness: He then ordered his dinner, and I prepared it for him. It was then about 12 o'clock. He ate his dinner alone. He ate quite heartily. I again saw him lying on the lounge, apparently asleep, at about 2 o'clock in the afternoon. I afterwards saw him sitting on our porch at about tea time. I did not see him afterwards. He was a stout-built man, nice appearing, but rather soiled. He had a full face, dark side whiskers and mustache. His chin looked dark, as though it needed shaving. His hair was dark. I don't know whether black or brown. In appearance I thought he was the straightest man I ever saw. He was full-chested. He wore no vest and no collar. As he lay upon the lounge, I noticed that he wore shoes, cannot say what kind of shoes. I noticed his white stockings between his pants and shoes. I think I would recognize the man if I should see him again. Photograph handed to witness. The one standing in this picture resembles the man. I never saw this picture before. Mr. Udderzook was dressed in a suit of dark clothes. Harvey Townley: I reside in Crawford County, Pennsylvania, am a drover and farmer. I saw the prisoner on the evening of the 30th of June last at Mr. Jeffress's hotel in Jennerville. I was lying on the dining room lounge when Mr. Jeffress came in with 2 gentlemen, and lighting a candle, said, "You 2 gentlemen wish to room together?" The prisoner here replied that they did. Mr. Jeffress showed them upstairs, and soon afterwards I retired to my own room, which proved to be adjoining theirs. It may have been 20 minutes after they had gone upstairs that I went to my room. I could hear them talking in their room, and could hear that they had not yet retired. I went to bed immediately and went to sleep. About midnight I was awakened by a noise in their room. I did not know what the noise was, unless someone was up and stirring about in there. I got up and lighted my candle, looked at my watch and saw it was a little after 12 o'clock. I then put out the light and went back to bed. They were talking in a low tone of voice, and I could not understand what was said. I then went to sleep and slept until morning. I saw the prisoner at breakfast the next morning. He said his friend was unwell during the night, and that he had had a great deal of trouble with him for a couple of nights. After breakfast I went out and sat in the porch. Soon after, this gentleman, the prisoner, came out and sat down at the right of me on the same bench. Mr. Jeffress came out and sat down there with us. Mr. Udderzook asked Jeffress if he had a team that he could have to go to Penningtonville, and Jeffress told him he could not let him have his horse, as he was going away himself with it. Just then Mr. Wallace came across the street and up to the porch, and said to Udderzook, "If William Udderzook was in this country, I should say you were he." Mr. Udderzook said that that was his name. Mr. Wallace then came and sat down in the porch, and I went away. In the evening, after supper, as I was going over to the store, I heard a wagon rattle past, and looking, I saw Mr. Udderzook driving towards the hotel. As I came back from the store, I saw Udderzook and the man who was with him at the hotel get into the wagon and drive off towards the north. I had known Udderzook's mother and sister for a good many years, and when I learned who he was, I observed him particularly. He was dressed in a suit of navy blue cloth, and he wore a straw hat. I saw the man who was with him at the supper table that day. He was a good-looking man, pretty square shoulders, erect, dark hair, side whiskers, and mustache. The photograph handed to witness. The one standing resembles the man whom I saw with Udderzook. George C. Jeffress. I am the son of Samuel C. Jeffress. I saw the prisoner at the bar on the 1st day of July last, in his room at the hotel in Jennerville. I was sent up to call him to breakfast, and I knocked on his door, when he opened it, and I then saw him. I again saw him after he came down. I saw the man who was there with him. I first saw this man at about 3 o'clock that afternoon, and I again saw him at the supper table, and ate supper with him. He was a stout man, with broad shoulders, throwing his shoulders well back, high forehead, mustache, and side whiskers. Witness identified the picture of the man standing, in the photograph heretofore introduced in evidence. John A. Wallace. I reside in Jennerville. I know the prisoner at the bar, have known him 15 years or more. I saw him in Jennerville on the morning of the 1st day of July last. As I walked up to the tavern porch, I saw a man sitting there, and as I came up to him, I said, "This is Billy Udderzook from Baltimore, if I am not mistaken." He raised his head and spoke in a low tone of voice, so that I did not hear his reply to me. "That is the same man," pointing to the prisoner. Mr. Townley and Mr. Jeffress were on the porch at the time. Charles Watson. I lived in the house of Mrs. Jane Udderzook, the mother of William E. Udderzook. I knew the prisoner. I saw him on the evening of the 1st of July, as I was going to my workshop. My business is that of wagon making. It was about 6 o'clock in the evening when I saw him. He was driving a bay horse harnessed to a top buggy, and there was a loose horse, a bay mare that belonged to Edwin Patchell, walking ahead of him. The mare had a saddle and bridle on. I was going into the gate of my house at the time. I noticed he had a summer lap blanket spread over his knees as he was driving. I saw a stranger on the porch of the hotel that day. I saw him as I went back and forth from my shop, and noticed him particularly. He was rather a large-sized man, heavy set, and when he stood erect he was so straight he apparently leaned backwards, throwing his shoulders well back. He had black hair, black side whiskers, and mustache. The photograph heretofore introduced in evidence handed to witness. The person standing looks like the man I saw. End of section 37. Section 38 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Homicide, Part 15. The Goss-Udderzook Tragedy, Part 14. Edwin Patchell. I reside in Jennerville. I know the prisoner at the bar. He came to my place in the morning on the 1st day of July last to hire a horse. My place is about 50 feet from the hotel. I looked at him as he came up to my place, and I knew him. I said, "Hello, Billy. You are a stranger in this country." He replied, "I was sent from the hotel to hire a horse from you to go to Penningtonville, or this side of there, to Samuel Rhodes's place." He said he would give me $2 for the horse to go there. I told him he could have it. Then he asked for a carriage. I told him I had none. He said he had a friend at the hotel that he wanted to take to see Samuel Rhodes. Then he asked for saddle and bridle, and I loaned him my mare. He returned my mare about 5 o'clock that afternoon, and had a horse and buggy with him. I knew the horse. It belonged to Albert Baldwin, who lives in Penningtonville. And half an hour later I saw him driving up the road past my place, going towards Cochransville. Annie Rhodes. I am the wife of Samuel Rhodes and sister of William E. Udderzook, the prisoner at the bar. I reside about 1/4 of a mile south of Penningtonville, on the Turnpike Road. My house is near the road, and the barn a little distance from the house. My brother, William E. Udderzook, came to see me on the 1st day of July last at about noon. Here the witness was completely overcome with emotion, and for several moments was deeply affected. Udderzook's mother, who was sitting immediately behind the witness, buried her face in her handkerchief and wept bitterly. Udderzook bowed his head for a moment, but quickly recovered his calmness. When the witness had become more composed, the examination proceeded. He, Udderzook, asked if Mr. Rhodes was at home. I told him he was at Mr. Zachariah Baldwin's, about a mile distant from our house. He said he had come to see Mr. Rhodes. I told him we would first have dinner and then go over to Mr. Baldwin's. He came there on horseback, and he put up the horse in our stable. He took dinner with me, and then we started over to see Mr. Rhodes. We conversed by the way. He said he had been to Philadelphia. He said he had not seen my mother or my sister. We found Mr. Rhodes out in the hayfield at Mr. Baldwin's. He was out towards the middle of the field. We went through a piece of woods to get to the field, and when we came in sight, he told me to stay there in the shade while he went and brought Mr. Rhodes up to where we were. He went to Mr. Rhodes, and then I followed after him, and then we all came back to the shade. They walked along together and were talking, and I walked a little way distant from them. They appeared to be talking quietly, as if they did not want me to hear. I did not hear any of their conversation. They were talking some 20 minutes or more. Then Mr. Rhodes went back to the field, and he, Udderzook, and I came away and walked on to Penningtonville. He said he was going to Penningtonville for a horse and carriage. I went to a store, and he went to a livery stable. He came round and called at the store for me, with a bay horse and top buggy. I got in, and he drove over to my house. I noticed a lap blanket in the buggy. I wanted him to stay to supper, but he did not. He took his other horse from the stable and tied him to the horse harnessed to the buggy. He tied him with a strap to the bridle. It was a hitching strap which he took from our stable for the purpose. Then he got into the buggy. I asked him if he would come back in the morning. He said, "No, this evening." He told me he had a friend with him at Jennerville who was in delicate health, and that he thought a few days in the country would do him good. Then he asked me if it would inconvenience us to have his friend at our house. I told him it would not. He started and drove a short distance, and then stopped and changed the saddle horse, tying it behind the buggy. I went up to him and said the horse would not lead that way, and advised him to turn it loose, and he did so. I did not see him again until I saw him here in the courtroom. I waited that evening and heard several carriages. He did not fix any time when he would come back. Mr. Rhodes and I waited up till 11:30, at which time we heard a carriage drive past the house. By the sound, it was going rapidly. Samuel W. Rhodes. I am the husband of Mrs. Rhodes, who has just testified. On the 1st day of July last, between 1 and 2 o'clock in the afternoon, Mr. Udderzook came with my wife to a hayfield where I was then at work. I was probably about 50 yards from the edge of the woods. He, Udderzook, came to where I was, and after he had said something about its being very warm, he said he had written me a letter. As soon as I saw him, I thought of that letter which he had written me. It was a suspicious letter, one that surprised me when I received it. I said to him I had written him in reply to know what he meant, and had received no answer from him. He said, "No, I could not write any more. It had to be by word of mouth. However," he says, "it is just as good now, and better if anything. It is a sure thing for $1,000 apiece for us." Then he said it was warm, and we walked up to the shade. I asked him what it was. He says, "Well, have you got a horse?" I said, "Yes." He asked, "Have you a wagon that will hold 3 persons?" I said I could get one, and asked him when we would get the money. He said we would get 500 apiece right away, and there was more money we would get afterwards. He would guarantee me $1,000. I asked where we would get it. He said, "Right here in Jennerville. I have towed it right here to Jennerville." He said it was a man who had been drinking, and who was spending his money for no good. He said he had had the poker about 3 times since he had been with him, that the man had about $1,000 with him, of that he was pretty certain. He wanted me to harness my horse and go with him at once to Jennerville and get this man and take him into the woods and give him a little laudanum and get him to sleep and then take his money. I said to him that I could not do that. I told him if he commenced that he would ruin himself and his whole family. He said there was not a bit of danger. He had had this man in New York or Newark, I can't say certain which, and in Philadelphia, and, he says, I would not go to all that trouble unless I knew what I was doing. I told him that nobody knew what they were doing when they commenced that kind of business, that he would have to give up the idea. He said, "I will not go home till I get it." He said that he would do all the stealing. He spoke as though he wanted me to hide the money. He said that he had been to a great deal of trouble and expense, and that he would do it himself and bury the money. I told him not to do so. I said to him, I must go to my work, and asked him to stay a day or 2, and I would talk with him in the evening and again in the morning. He said the man would not stay in Jennerville by himself. If he, Udderzook, stayed, he would have to bring the man to my place. He asked if he might do so, and I said yes. He then asked me for a horse and buggy to bring him with. I told him I could not give him my horse, as it was at Napoleon Warner's. I told him there was a livery stable in Penningtonville where I thought he could get a team. He said the man was very sick, and he thought he would die last night or the other night. He said that he had been up with him dosing him with whiskey. He said that he believed the man would die, and asked, "How would it be with you and Annie," that is my wife, "if he should happen to die at your house? Would you allow me to put him away and say nothing about it?" "No," I said. "If a stranger was to die at my place, there would have to be a coroner's inquest held." He said there was nobody to look after this man, that he had been lost for a long time, and everybody thought he was dead. He had no friends to look after him, nor who cared for him. I said to him it made no difference. If a stranger should die there would have to be an inquest. He dropped his head down, and his cheek appeared to be getting red. He said it might lead to some suspicion. I told him I could not help that. I could not have anything of that kind. He said, "Well, what then?" I told him I would say nothing more until I saw the man. He left me then, going in the direction of Penningtonville. I did not see him again until I saw him here. I own the leather hitching strap, which I found at Mr. Baldwin's livery stable a few days after Udderzook had taken it from my stable. A leather strap handed to and identified by witness as his hitching strap. I know William E. Udderzook's handwriting. Letter handed to witness, dated on the envelope December 16th, and postmarked Baltimore. No date to the letter itself. I received that letter between the 16th and 20th of December, 1872. It is the letter I spoke of in my testimony. The following is the letter referred to. Friend Sam, I have something of much interest that I wish to communicate with you. It must be done by word of mouth. Please don't let any one know of our communications, but as soon as you read this, mount your horse and come to Oxford, take the morning train to Baltimore. When you arrive in Baltimore, inquire for Mr. Duker and Brother planing and sawmill. This mill is right across the street from where you get out of the cars. I am employed in said mill, and am there every day. You will arrive at 1 o'clock. You must take the next train for Oxford, which is at 2:30. That will give us 1 hour and a half, which will be sufficient for us to arrange one of the finest planes that you ever heard of. There is a cool $1,000 in it, and there is nothing to prevent us from getting it, this is without a doubt. Do not buy your ticket at Oxford, but pay for your fare on the cars. Do not let a soul know where you go. I cannot explain further till I see you. Do not fail to come, drop everything at once. You can make the trip in a few hours. I have no person else in confidence with me, and now propose to take you. You will find that it is the best day's work that you ever did. I will give you the full explanation when I see you. Bring this letter with you. Your expenses will be only $4 or a little less. Very respect yours, William E. Udderzook. Be firm, be true. Footnote. This letter is written on a commercial note sheet and is signed on the 3rd page. On the 4th page, near the bottom, evidently written after the letter was folded, are the words, "If you decline to come, write me a line to number 167 Conway Street, Baltimore, Maryland." End footnote. The cross-examination of Rhodes was conducted at great length, without eliciting any important fact, other than an admission that he had suspected Udderzook might be plotting against him, but his suspicions took no definite form. The whole of Rhodes's direct testimony was rigidly cross-questioned, without shaking it in the least degree. He was then asked by the Commonwealth's attorney if he ever showed the letter which he received from Udderzook to any person. Prisoner's counsel objected. Objection overruled, and exception observed by the defense. Witness answered that he showed it the same day that he received it to Mrs. Annie E. Skelton, who was at the time keeping house for him. Also, on the same day, he showed it to Gaynor P. Moore, and to Mrs. Elizabeth Udderzook, a widow of the brother of William E. Udderzook. He showed his answer to the letter to Mrs. Skelton. Witness was asked if he told his conversation with Udderzook, which he held with him in the hayfield, to any person. Prisoner's counsel asked the court if he thought this admissible against the prisoner. The court said it was admissible to show whether or not, if there was a scheme, the witness was a party to it. That if the witness was a party to the crime, his testimony should be received with great caution, and should not be relied upon except in so far as it is corroborated by other circumstances. If he is not to be treated as a party, then he stands as any other witness. Witness then said that he told the conversation, first to Albert Baldwin on the 2nd day of July, and to Zechariah Baldwin on the morning of the 3rd of July, when he returned to his work, that he worked all that day and in the evening of the same day. After going home, he told it to Gaynor P. Moore. He also spoke of it to several other persons, whose names he mentioned. The court then asked, when was the first time the witness heard of the man's body being found? Witness answered, "The first time I heard of the body being found was at about 5 o'clock in the afternoon of Friday, the 11th day of July. I went to the woods with Gaynor Moore, to the place where the body lay, and on putting a shovel down by its side, I came to and dug up a bloody, dirty shirt. I placed a shovel under the head and raised it up. Just then we heard a buggy passing on the pike road, and we went out to it. We got into the wagon and went back to Gaynor Moore's house, and I left Gaynor there." Annie Skelton identified the Udderzook letter as the one Rhodes showed her on the day he received it by mail. She also testified to having read an answer to it, written by Rhodes. Mrs. Elizabeth Udderzook, widow of the brother of William E. Udderzook, testified that Rhodes showed her the letter the latter part of April. Gaynor P. Moore testified that Rhodes showed him the letter in the early part of last winter. He also testified to having been told by Rhodes about the conversation between Udderzook and Rhodes, which took place in Baldwin's hayfield. The witness was told of this conversation on the evening of July 3rd. Albert Baldwin, keeper of the livery stable at Penningtonville, testified that Rhodes told him of the conversation on Wednesday evening, July 2nd. Zechariah Baldwin testified that he saw the prisoner in his hayfield on the first day of July and saw him with Rhodes. On the morning of the third day of July, Rhodes told witness of the conversation. Samuel Slocum testified that on the 6th of July, Rhodes told him of the conversation and also showed him the letter from Udderzook. Albert Baldwin recalled. I saw the prisoner at my livery stable on the first day of July, 1873. He hired a team of me to go to Cochransville. He was to be back between 6 and 7 o'clock. I furnished him 2 blankets. One was a light summer horse cover, and the other was a linen lap cover. He paid me $2 for the team, and then got in and drove off. I retired to bed about 9 o'clock that night. Udderzook had not returned when I went to bed. Gassaway Peters. I was employed at the livery stable of Mr. Baldwin in Penningtonville last July. I saw the prisoner on the first day of July last. I met him on the road between Gilfillan's tan yard and Bear's Woods. He was driving a horse of Mr. Baldwin's harnessed to a buggy. There was a horse with saddle and bridle on ahead of him. I next saw him that night when he returned the horse and buggy to the stable. It was then 20 minutes to 12 o'clock. I unlocked the stable and led the horse in, and unharnessed him in there. Udderzook stood by me, and I said to him, "You did not get in as soon as you expected." He said, "When a man gets out among the women, he does not know when he will get in." I noticed the wagon was broken, and asked him how he did it, and he said he did not know how it got broken. The dasher was broken at the handhold, and the iron frame bent over towards the horse. 2 of the hind bows in the buggy top were broken, and 2 rivets were broken from the bows at the ends where the bows are fastened to the seat, so that the bows were swinging loose. This was on the left-hand side. I asked him to pay for overtime, and he said he would see Baldwin in the morning. He went away, and I locked the stable and went to bed. The next morning I was examining the wagon, and I found a finger ring and a collar button lying between the cushions near the front edge on the seat. They lay between the creases of the cushions and were in sight. The ring heretofore introduced in evidence was shown to and identified by the witness as the one he found in the buggy. I gave the ring to Mr. Baldwin that morning. The collar button heretofore introduced in evidence was shown to and identified by witness. I kept the collar button until I gave it to the coroner's jury. End of section 38.